Good morning, good morning, good morning. It's day 30 of the Karen Read Retrial, and this is Live Trials with me. I'm Emily D. Baker. I break down the trial in real time, gavel to gavel, what you want to know, and tell you about what's happening in court. Today, we are starting out with argument. We saw the attorneys saying that they were going to bring things before the court at the beginning of court today. And when the court said everybody needs to be ready around like 9:20, I thought she meant ready for the jury because she gave the jury an extra half hour this morning that they were going to give themselves like a half hour and started like 9. No, that's not what they did at all. That's not what they did at all. So court didn't start until just a little bit ago. So we are going to be getting into court before the jury comes in as they are doing arguments. I don't know why they didn't give themselves a full half hour. I really don't. I don't know if stuff was filed and the court was in chambers reading it or if people weren't there. I don't know. But we're going to go to court and see argument. The defense has 2 witnesses left. One's already on the stand, Dr. Laposata. I imagine we're going to see the defense arguing again about Dr. Laposata being able to testify as an expert regarding dog bites. We also know that the defense is unhappy with the admonition the court gave to the jury yesterday. That shouldn't have just been an instruction. That should have also been an admonition. Attorney Brennan said or asked, and I went back yesterday and rewatched what the court indicated she was going to say before she got upset with the defense for conferring with each other while she was on the bench. And she was saying, Attorney Brennan asked about this. That should be stricken. And I think she still should tell the jury that that information should be stricken. She didn't. It was not enough of an admonition for me. The defense should have had time to confer and ask for a stronger admonition. She told them it was going to be stronger, and then it wasn't. And for all of you coming in for day 30 and are like, what is going on? Attorney Brennan asked the expert from ARCCA, Dr. Wolf, a number of questions saying, aren't these holes on the back of the hoodie something you considered or didn't consider or should have considered? And Dr. Wolf said those aren't consistent with road rash, which is fine, but it was still asked about as if Dr. Wolf didn't consider something. And well, those holes are clearly from the crime lab. And Attorney Brennan said, I have made a mistake. Yeah, a big mistake. But the court needed to give a stronger admonition so it's clear to the jury that those holes were there from the crime lab, that the attorney was aware of it, that they were not there from the 29th, and those pictures need to be in evidence. The court said she was putting in evidence. She needs to tell the jury to stricken the question, and now she's going to have to remind them what it was because it's no longer close in time. I think a much stronger admonition, not just an instruction, is needed. Is absolutely needed. It was not nearly strong enough yesterday, and I'm not surprised that the defense said at the end of the court day yesterday that they will be bringing it back to the court's attention and putting it in writing. It protects the It protects the record further to put it in writing. And I think that's what we're going to see them do today. Put it in writing and then ask the court to admonish the jury further and admit the photos into evidence and strike Brennan's line of questioning and tell the jury that line of questioning is stricken. So we'll see what the defense asks for. We're going to get into court to hear their argument before the jury comes in. Dr. Laposata's testimony is not done yet, and then Dr. Rentschler. And that will be the end of the case for the defense. That'll probably take us through the rest of today. And then we have just a few hours of rebuttal we've heard from the Commonwealth. That might take us to Thursday. So the court indicated Thursday was going to be a half day. Friday might be closing and giving this case to the jury, or the court might try to bump it forward and get a full day in Thursday. They're still going to need at least a few hours of a jury instruction conference. So somewhere in there, the jury is going to get sent home early so that the attorneys and the court can work through what the jury instructions are going to say, because we still know that there is a fight over the necessary witness instruction, sometimes called the missing witness instruction. It doesn't mean somebody's actually physically missing and couldn't come to court. It means who did the Commonwealth not call that they could have, and can we argue to the jury about it? And do they get an instruction telling them that they can assume that if that person were called, that what they had to say was damaging or negative to the Commonwealth's case. That can be a potentially very big instruction, and we'll hear argument over that. So yes, there's going to be more argument. Yes, there's going to be more motions. Yes, cases do tend to pick up speed. I'm sure there's an equation as we get towards the end, and that's what we're going to see today, I imagine, and tomorrow. So let's go. Law nerds!
Bring the jury.
It's time for court. Let me know where you're coming in from, what you're drinking. I've got a homemade cup of cappuccino this morning. But who knows? It might be a day for multiple coffees. We'll see. Let's go to court. Hey there. I'm lawyer and legal analyst Emily D. Baker, and this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time so you know what's happening. No law degree required. So join the law nerds in the chat. They're here for the facts, not and let's get to court. All right, let's get to court. I don't think there were any hear ye's. I think it was just court is in session. Hopefully we'll get hear ye's before the jury comes in today. I'm optimistic, very optimistic.
All right, so I received a couple of motions a little while ago.
And we're going to catch up before court goes on break for the morning, so
and there's some things we need to talk about from yesterday.
We've got adequate Zoom room today.
Here. Okay, good.
Y'all told the jury to come in a half hour later so you could have time to work.
All right, so the order I'd like to do is, Mr. Jackson, yesterday you were going to take a look at any photographs you intend to put in with Dr. Laposata.
Like you better.
Yes, those have been presented to the Commonwealth.
All right, can I just, are you all in agreement, or are you just looking at them now, Mr. Brennan?
I haven't heard specifically from Mr. Brennan, but the issues that he had, obviously we're not, at this juncture,
all right.
Further, we're not going to bring in anything having to do with dog bites.
Yeah.
Claws, dogs in tissue, any of that information, but we are going to bring in exactly what we indicated yesterday. If there's an issue with, for instance, the ecchymosis, we've got a clean copy of the photograph without any of the narrative next to it, which is explanatory.
Part of what the court's worried about is graphic photos.
All right.
Photos
so
of
I need to know just
damage
for
to the brain, damage to stomach lining.
Instructions to the jury about. I'm concerned about the photograph on page 5, figure 3. Yes.
Yeah, that's going to be. We intend to show that. That shows the.
So what I would like you to do, if you could, is just crop the center that shows what appears to be blood cells or the red. I assume that that's the part you want to get into.
Brainstem's are not horribly disturbing.
Sure. If you.
Though we did have the jurors earlier on when they were showing stomach lining photos, they took a pretty sudden break, and it seemed that perhaps some of the jurors were disturbed by the photos. So I think the court is being mindful of that. Different jurors have different sensitivities to photos. This is not a case where the photos are horribly, horribly graphic. They're sad, but they're not terribly graphic. But if the jurors were upset about the stomach lining photos, I can understand the concern about brain photos, but it is a homicide trial. They are going to see photos. This is not a case with horrible photos. It's not. There are some cases with horrible photos. This is not that case. They're sad, but they're not.
I'll let it in, and I still want to give an
horrific.
instruction. So I need to know what you're going to do with that.
So
I was going to exclude it, but I understand. So if you can.
No.
Yes. If you can do that, I think it takes away some of the sting on the gruesome photographs. All right, so you'll do just the brainstem on that, Mr. Jackson? All right. And so I'm concerned more about the ones that I think may cause the jurors some concern. So
I also realize my threshold for this is completely
photograph,
broken. So
figure 5,
I get it.
the Wisniewski spots. I thought that was in evidence. I don't know for sure if it's in evidence.
I agree. Welcher's was horrible.
I don't believe that it's actually in evidence.
She's not excluding them.
Okay, so
It's not in evidence.
okay.
She said she was going to, and she's
Yes.
not.
I'll put it as
All right, they've already seen it, so it's less
Right.
less likely to have an impact on them for purposes of the gruesome photographs. And then on page
And again,
8, figure
the random-
6, the stomach lining.
The Welcher photo that was kind of out of nowhere that wasn't related to this case was more graphic than any of the other photos that we've seen in this case. So, yes, I get it. And Morgan Mercury said all of those of us who grew up with faces of death are pretty I think this is why I am broken. It was definitely part of it.
Correct, that's already in evidence.
Okay,
the
that's
Welcher
what I
photo
thought.
wasn't related
That's
to
where you
this
told me
case.
yesterday the number, right? So those are in. So are you using them again?
I'm going to use them again comparatively, and probably side by side.
Okay. All right, I don't have a problem with that. Does the Commonwealth?
I don't.
Okay.
Remember,
All
we're
right,
at argument before the jury comes in this morning.
Those are the ones I was concerned about for purposes of an instruction. If there's
Court
objections
housekeeping.
to hearsay or something, I'll give Mr. Brennan an opportunity to take a look at whatever he's got.
Understood.
Okay. All right. So with that, that's helpful. Thank you. So there is a new motion this morning suggesting that the Commonwealth open the door with their questioning of Dr. Russell to allow Dr. Laposata to talk about bite wounds. So I've read that.
Okay.
Okay, sure.
So again, we're in morning housekeeping. The jury is not there. The defense filed a motion this morning. The court said she has read it. And again, when I said that maybe the reason they didn't start is because the court was reading things, it seems like the court was in fact reading things that were filed this morning, which is normal, even though I was complaining that they should just be getting started. But again, not unusual that the judge would be in chambers reading something, so they are started even though they're not on the record. However, I thought we would see the defense argue more about Dr. Laposata being able to get into the dog bites. And now we are getting into, did the Commonwealth open the door? Not, Your Honor, reconsider that this expert is an experty expert. No. Go about it a different way. I'm not surprised that they are finding a different way, saying, hey, the Commonwealth opened the door. Let's see what AJ has to argue.
I'd like to start, if I may, by marking 2 documents for permission. One is Dr. Laposata's entire report, and the second is
great.
her entire CV. if that's
Okay. Yeah, those are the ones I needed from yesterday. So, yes. Yes.
Exhibits D, 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 and exhibits
D, 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 D.
E, E, E.
Exhibit D, 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 D.
All right, go ahead, Mr. Jackson.
Thank you, Your Honor. We are asking the court to reconsider the court's ruling yesterday concerning Dr. Laposata and her ability to opine on the issue of dog bites, dog bite and claw mark wounds and pattern recognition. We had some concerns yesterday and previous to yesterday about an issue that has been ongoing with the Commonwealth, and we've brought this to the court's attention. The Commonwealth has been using a tactic to shift the burden to the defense with cross-examination that's laced with indications or implications about witnesses that may or may not be called by the defense. That is a problem. I brought it to the court's attention at sidebar. The court will probably remember that colloquy. It was not an open court, but I expressed grave concerns, to use that phrase, that there was a burden-shifting system that was going on when Mr. Brennan is asked.
Jackson, spending too much time on the internet. There were the defense has grave concerns about the burden. He's so happy with himself about the burden shifting questioning of the Commonwealth.
Asking our witnesses about, or his witnesses, about other witnesses that may be on the defense witness list and may be called. Obviously, as the court knows,
I have grave
foundationally,
concerns about more
we don't
than
have to
this.
call anybody. We don't intend to call anybody. We don't have to call anybody, but we can call whoever we feel like. But we shouldn't be put in a position where our hand is forced to call witnesses because of questioning by the Commonwealth, which is improper. After I brought it to the court's attention, Mr. Brennan has continued along that same line. The Commonwealth has continued along that same line, and I want to bring something to the court's attention specifically. Last night, we pulled the tape. Dr. Russell was cross-examined by...
They used the timestamps and went back and looked. Okay.
Mr. Brennan on the issue specifically of Dr. Laposata and her opinions regarding dog bites. He asked questions over and over and over again. The colloquy probably lasted more than 5, 6, 7 minutes with Dr. Russell
on that cross-examination.
Specifically on the issue of whether or not she had seen Dr. Laposata's reports, whether she was aware of Dr. Laposata's opinions, implying that Dr. Laposata had opinions about the dog bites. She was asked if she was familiar with Dr. Laposata's credentials. Dr. Russell said, yes, she was familiar with Dr. Laposata by name, that she thought she had impeccable credentials.
Yes.
And she very much wished she could have seen her reports as it relates to dog bites.
Yes.
It was an intellectual curiosity by Dr. Russell that was evoked.
She went looking for
and
it
elicited
in the file
by Mr. Brennan on cross-examination of Dr. Russell.
Russell wanted the tea.
She was then asked the seminal question. Did the defense, Dr. Russell, give you any reports by Dr. Laposata related to dog bites?
What page is that on here?
And the transcript?
Yes.
He needs Elizabeth Little to hand it to him. He's a stand up and argue type of a lawyer, not a where are my papers type of a lawyer.
Yes.
Okay.
We remember that. We were talking about it yesterday. We were talking about
just
how
read it.
much the Commonwealth asked
Question by Mr.
Dr.
Brennan
Russell.
to Dr. Russell. And so you think of all those forensic pathologists, medical examiners, you think that qualification and experience itself is not enough to qualify someone to give an opinion on a photograph about the genesis of a wound related to dog bites? Answer. Well, if a forensic pathologist autopsied 1 or 2 cases of dog bite wounds versus my experience with over 500 to 1,000 cases of dog bite wounds, I'm not sure that person would be a very good expert in that kind of case. Question by Mr. Brennan. Have you ever heard of a doctor named Laposata?
So are you going to read all 3 pages?
No.
So I've read it, Mr. Jackson.
I'd like to read it into the record, Your Honor.
It's in the record. I will put this transcript into the record. I'm not going to let you read 3 pages here.
It's not 3 pages, Your Honor. It's about another 5 lines.
The
It just
part
goes to
that
the
you
top of the
brought
next
to
page.
my attention is on page 15, not where you're reading.
Colloquy between between Dr. Russell and Mr. Brennan was specific to dog bite wounds. It was specific to Dr. Russell's understanding of whether or not Dr. Laposata had been retained by the defense, whether she was a defense expert, whether she had written a report, and whether she opined about dog bites and dog bite wounds.
Right.
And after she was asked if she was it had been provided,
She has the transcript. She doesn't have to let him read it into the record because it's in the record twice. And again, we're in the timing of things, right? Just like, we got to go. You don't need to just read it for the internet. We got to go. It's in the record. Just tell me what you want to tell me, because there's no need. If it's in the motions and she read the motions, and I know you guys want him to read it out loud, but if it's in the motions and she's read the motions, don't tell me what you told me in the motions. Tell me what you need to tell me in addition. So, and she does that consistently.
any reports by the defense attorneys specifically, from Dr. Laposata related to dog bite wounds, Dr. Russell said, no, I haven't been. And to summarize her statements, which the court has in front of it, Dr. Russell went on and said, I really wanted to see what Dr. Laposata had to say about these dog bite wounds. I really wanted to read her report. But
I
was never provided her report or reports by the defense. And of course, Your Honor, as the court knows, that is standard operating procedure. I don't trade reports between and among experts, because obviously I want independent analysis. I don't want to cross-contaminate any opinions, et cetera, and be accused of doing so. So of course we didn't provide a report from Dr. Laposata to Dr. Russell. But Dr. Russell's intellectual curiosity was then extracted
Questioned.
from the witness stand,
That's
and
fair.
the jurors heard all of that. So then days later, not weeks, not months, 3 days later, after eliciting testimony from Dr. Russell about Dr. Laposata having a report, being hired by the defense on the issue of dog bites, and not providing that report to Dr. Russell,
That's a good point.
the Commonwealth then moves to exclude the very testimony that he was eliciting from Dr. Russell, leaving the jurors with a very, very deep and irremediable misimpression.
He's like, thank you, Mr. Alessi. Irremediable is our new favorite word.
They used it tactically as a sword and a shield. And that's burden shifting. That leaves the jury with the impression that
The
Dr.
Commonwealth has done that a
Laposata
few
was
times.
consulted by the defense, number one, that she wrote a report, number two, that the report was about dog bites, number three, that she didn't provide that report to other experts, number four, and the reason she didn't, obviously, is because her opinion, Dr. Laposata's opinion, would be harmful to the defense. That's the only reasonable interpretation of those facts. And the
That's a
Commonwealth
good argument.
has taken advantage of that. The Commonwealth's questioning of Dr. Russell about Dr. Laposata and her report and her opinions about dog bite wounds specifically was deliberate, and it left the jury with an open question. We know they consulted her. We know it was about dog bites. This is how the jurors are thinking about it now. We know they consulted her. We know it was about dog bites. They hid the report from Dr. Russell because they didn't want her to know about it. Ergo, must be harmful to defense. Now we've got Dr. Laposata on the stand.
It's a good
Her
argument.
credentials are peerless, absolutely peerless. They've got possibly the most qualified medical examiner in the country, certainly on the Eastern Seaboard, right in front of them, about 6 feet away, and the defense is not going to ask a single question about her opinions concerning dog bites when she reviewed the entire autopsy. How is the jury going to conceive that? How is that going to land with them? The answer is they're going to think, they have no choice but to think, the only reasonable explanation is if Dr. Laposata's opinion helped the defense,
They would have it.
would ask her.
That's a fair argument.
If they don't ask her, it's because whatever Dr. Laposata says about that right arm and those wounds, it's got to be harmful to the defense. They would absolutely ask the question. So the Commonwealth got to have it both ways. They got to ask Dr. Russell about Dr. Laposata
And try to undermine
imply
her.
that Dr.
And the Commonwealth has done that consistently. They've used one expert to try to chip away or undermine the other experts. So you don't think this is enough experience, do you? You don't think this is enough to do the work that you did, this. But that's not the argument Jackson's making. He's taking that argument a step further and saying the jury will be left with nothing but to assume that the reason it wasn't shown to Dr. Russell is because it contradicts. And if we don't ask her about it, the jury's only left to assume that it's bad for us.
Laposata had opinions about dog bite wounds, and then they have it the other way, which is let's ask the court if she
To
will
keep it out.
exclude
It's a
Dr.
good
Laposata
argument.
from testifying about the very issue that they brought up in front of Dr. Russell.
They asked
That
Dr. Russell
cannot
so much
stand.
about
That
Laposata.
it reasonably ensures that the jury will misrepresent or misunderstand
We'll assume. Right.
the import
Fair.
of why we're not asking Dr. Laposata about her expert opinion, especially as it specifically pertains to dog bite wounds. I want to talk for just a second, and that has, by the way, that has constitutional implications. Ms. Reed is entitled to a fair trial, not a fair trial that the Commonwealth designs, not a fair trial that the Commonwealth curates, but a fair trial. Regarding Dr. Laposata's credentials, we went back through, specific to the court's questions yesterday.
I don't have
her
issues with
resume.
her credentials at all.
There are no fewer than 13 classes, 13, that she has taught specific to wound pattern recognition that have included dog bite recognition. On page 7 She was the course director for medical legal death investigation. That was in 2013. She taught about dog bite recognition in that case, or in that course.
The she's not qualified's wild. I could see the court saying it's cumulative, and we've already done this for like 2 days. But the she's not qualified because I don't think her methodology is sound. She uses the same methodology as every other fucking doctor, which is pattern recognition. Same methodology. Yeah, that was wild. I could see cumulative, but this is a good argument that should allow them to get into it in some fashion. Because the issue is not, for me, the experience.
She was a thesis advisor for Master of Science Graduate Medical School, Boston University School of Medicine. Taught about dog bites. Staying with page 7. Forensic Pathology, course director in pathology. Course 205. Taught about dog bites.
Right.
Member of Quality Assurance Committee, Training Division of Trauma and Surgical Critical Care, teaching on the issue of wound recognition, animal bites, and specific to dog bites. Pediatric Forensic Pathology, Texas Homicide Symposium. She was a presenter in 1989. She taught about the issue of dog bites as it relates to pediatrics, children, dog bites in children. Forensic aspects of physical child abuse as related to being left with dogs that can injure a child. Dog bites, dog bite recognition. These are all classes taught by Dr. Laposata on the issue of dog bites to other medical professionals. The one that stands out, however, and I'm not going to go through the other 9 or 10 or 11. The one that stands out is 2015 and 2016. 2 courses. The name of the course, Emergency Room Forensics, Evidence and Patterned Injuries. New England chapter of the International Association of Forensic Nurses.
There it is.
Taught in Norwood, Massachusetts, both times.
The emergency room.
Specific to dog bites and the issue of dog bites as seen by emergency room physicians. How they should handle them, what they should do with them, how they should view them, what to look for in terms of pattern recognition. She's eminently qualified. I will leave the court with one thought. The court indicated when
the defense in their argument did something that is incredibly helpful to them because they gave the court an out. Just confronting the court with, hey, change your mind, here's more information, doesn't always help. But giving the court an out with something else, not just, hey, Your Honor, change your mind, is incredibly helpful. And that's, hey, Your Honor, the Commonwealth opened this door in the way they chose to do their cross-examination. They chose to do their cross-examination. And at the time they cross-examined Dr. Russell, we didn't know they were going to move to exclude this information from Laposata because they hadn't done it yet. So they can't have it both ways. They can't use it, as Jackson said, as a sword and a shield. They can't do both. And I hope at some point he will say, and we would have examined Dr. Russell differently if we knew the defense was moving this, or we would have objected to that entire line of questioning and cross. We didn't, because they hadn't even asked yet to keep out Dr. Laposata. So we couldn't cross-examine different, and we couldn't shut down that line of questioning because they didn't tell us they were trying to keep it out at the time when we did all the motions eliminate.
In qualifying Dr. Russell, one of the preeminent things that the court mentioned in qualifying Dr. Russell is that Dr. Russell utilized a methodology that the court sanctioned and quoted and said the methodology that she used of wound pattern recognition, dealing with differential diagnosis, utilizing
pattern recognition
and interpreting dog bites by the method of
differential
exactly what Dr. Russell did.
Yep.
Differential diagnosis is something that the court said was exactly why the court sanctioned Dr. Russell and blessed Dr. Russell as a qualified expert, and that's exactly what Dr. Laposata testified yesterday she utilized and utilizes in coming to her opinions and conclusions. Going back to the open door issue, obviously she's eminently qualified, but
Agreed.
Your Honor, this cannot stand. The Commonwealth cannot have it both ways. They cannot walk up and say and leave the impression with
That's
the
a good
jurors
argument.
that Dr. Laposata opined about the dog wounds, but we're not able to hear it. We, the jurors,
Right.
are not able to hear it because obviously that is something that is her opinion, whatever it might be, is harmful to the defense.
Right.
When in truth and in fact, it's exactly the opposite. Dr. Laposata's opinion has never wavered. Those injuries on John O'Keefe's arm are from a dog. Period. Full stop. Anything less than presenting that to the jury at this point would be to perpetrate an intentional fraud on this jury. Ms.
That's
Reed is
strong
entitled
language.
to more. She's entitled to better. She's entitled to the evidence.
All right.
It's a very
Thank
good
you.
point.
Mr. Brennan?
I think that's one of the better arguments we've seen from Jackson. He also has really good grounds to make that argument. We cannot leave the jury with another wrong impression created by the Commonwealth. And he did it without directly attacking Brennan more. So, that we could have, I think. I
The
think he had
pattern
room
of
to.
conduct that stands out is persistent, repetitive, contrary to court rulings and court orders, and deliberate. And that is the defense uses their witnesses to vouch for their own credibility.
Sir. Mm-mm. 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 Mm-mm.
They use their witnesses. Defense uses their witnesses to vouch for their own credibility. They use their witnesses to introduce information they know is not admissible, and they use their witnesses to introduce otherwise inadmissible hearsay. Dr. Russell took the stand, and she was led into answers where she was vouching for her own credibility. Dr. Russell promoted herself.
What do you mean she was vouching for her own credibility? She gave you her credentials. Why is that even a sentence?
Not only as an expert, but through the defense's questions, as virtually the only expert in America who has the expertise to give this type of opinion. It is the defendant's
You asked about that.
tactics that open these doors that they then want closed. The defense had Dr. Russell all but assure the jury that she uniquely was in the position to give any type of opinion regarding dog bites. Inevitably.
She is in a unique
When I
position.
asked Dr. Russell, and I began asking her about her credentials, whether she thought that she was exclusive, and I mentioned Dr. Laposata, she denied ever reading anything about Dr. Laposata. I did not specify whether she read an opinion about a dog bite. I
asked
asked
about
if
the
she had heard
report.
about Dr. Laposata. She denied it, and then she told us that she knew about Dr. Sheridan. Unsolicited, then added that Dr. Sheridan, involved in a previous proceeding, believed that the bites were consistent with dog bites. I don't know how she became aware of Dr. Sheridan's testimony, and since the defense doesn't speak to her about these things, she must have watched it on her own. But inevitably, she introduced inadmissible
boy.
hearsay and inadmissible opinions. And so the sum zero here is that Dr. Russell has denied that she saw anything relative to Dr. Laposata, ensured that she was exclusively qualified, and introduced an improper opinion.
That's the feed. I'm going to give it a second. That's not you.
Aims to,
There we go.
as it pertains to dog bites. We asked her questions about her specific experience. She did not provide a basis, and so her opinions regarding dog bites should not be permitted in this trial.
Throughout the record, two things stand out about that speech.
We are seeing repeatedly with Attorney Brennan that he is not focused on the legal aspect of the arguments.
Mr. Brennan literally just said, I didn't elicit any information about dog bites. I just asked about her experience. Question by Mr. Brennan.
That's not what I said. That is
Excuse
not what
me.
No, I'm not going to.
So
That's not what I said.
I heard what Mr. Brennan.
Brennan's like, that's not what I said. That's not what I said. That's not what I said.
out about that speech.
Oh boy.
Mr. Brennan literally just said, I didn't elicit any information about dog bites. I just asked about her experience. Question by Mr. Brennan.
That's not what I said. That is
Excuse
not what
me.
No, I'm not going to.
So
That's not what I said.
I heard what,
Oh, I want to see Brennan's face too. God, they're so pissed at each other. They are so done with each other. And Brennan's like, that's not what I said. Again, that's how Jackson's characterizing what Brennan said. That's not exactly what he said. Brennan said the defense is using their witnesses to vouch for themselves and that the defense is opening these doors.
Mr. Brennan said, you don't need to tell me what Mr. Brennan said, but go ahead to
How
your
about if I
argument.
quote his words? How about that?
How about that?
Question.
Oh, shit.
And so you
Don't clap back at the judge when you're mad at Brennan, though. How about I quote his words? Run it back.
think of all those forensic pathologists, medical examiners, and you think qualification and experience itself is not enough to qualify somebody to give an opinion on a photograph about the genesis of a wound related to dog bites. The question was specific to dog bites. That's how he introduced the subject matter to Dr. Russell. Then his next question was, have you ever heard of a doctor named Dr. Laposata? Those were his words. Then he goes on, I think he also just said that he did not elicit information.
He went on to say, is there a reason that you're like pumping up Dr. Laposata so much? Is there a reason that you're doing this? He went down that line of questioning for a while. And that's when Dr. Russell was saying, to the best of my memory, I've seen her name at conferences and this and this. And he's like, oh, it's not just because she was hired by the defense or whatever. He went down that whole line of questioning on cross. And it's not that he just did it with this line of cross-examination. Brennan has done that with multiple witnesses and trying to undermine their expertise and their credentials using one another.
About other individuals, including Dr. Sheridan or anybody else. Question by Mr. Brennan. Were you ever told what other people's opinions might be regarding those photographs? That's the question that she was answering when she said, quote, I'm aware that there was a Dr. Sheridan involved in a previous proceeding, and he believed that those were consistent with dog bites. That was in relation or in response to Mr. Brennan's specific question. She didn't just elicit that. She didn't volunteer it. She said it because he asked her. And that was all by design. The entire thing has been by design. He elicited the information suggesting that Dr. Laposata was being hidden from Dr. Russell because her opinion would harm the defense. He left that with her on purpose, then turned around, and 3 days later
Made a
said,
motion.
and by the way, the defense should be disallowed from using Dr. Laposata to talk about the very dog bite wounds that I asked Dr. Russell about. That cannot stand in this courtroom.
Go ahead.
It's helpful if you read the entire thing with context, which I won't do. We always have a right to object to an admissible opinion. So the suggestion that somehow an ambush here is not only misplaced, it's strategic by the defense to try to create an narrative. It's improper.
All right. I'll be out in 10 minutes on this, and we'll get started right away with Dr. Laposata.
All right, the court, please.
And we're on to a break. Well, damn it. We didn't even get to talk about the instruction. The court is going to, I imagine, go back and read the entire transcript about the prosecution's cross-examination of Dr. Russell regarding Dr. Laposata. There was quite a bit of conversation in that cross-examination. So the court went back into chambers. We are going to zoom until the court comes out of chambers. So let's do that.
All right. So I'm not going to allow Dr. Laposata to testify regarding dog bites. Your rights are saved.
Objection. 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 Well, the court says your rights are saved, meaning you can appeal it if you need to. I think the defense made a strong argument about the Commonwealth opening the door. I don't think we're done with this, though. I think we will see this argument again.
I'm going to give an instruction regarding burden shifting. So
Why not? Why not do both?
Outrageous. I think the conduct is outrageous. And I don't think that the purity.
I'm going to try to gain this up. The court said, I'm going to give an instruction about burden shifting. It's a pretty heavy-handed instruction, by the way, but it doesn't change it.
I'm going to give an instruction.
I'm going to try to gain this up since it seems like Jackson's not going to go back to the microphone anytime soon. He starts saying outrageous, but I can't hear what he says is outrageous. It's definitely not Jem. So I want to be able to hear him.
Regarding burden shifting. So
I just think it's outrageous. I think the conduct is outrageous. And I don't think that a purity instruction can do anything except bring the point home again.
okay.
But if the court is not willing to allow her to testify to her full opinion to a meeting between scientific service, can she at least testify that she reviewed the arm, looked at the arm, and it's consistent with an animal? Can we at least split the baby?
I will do that. I'll allow that. Yes. Over the Commonwealth's objection.
Then I look to have the cross-examiner, because if you're going to allow consistent opinion with a dog,
No, Mr. Jackson said animal.
I'll leave it at animal if that's what I can get. I'll take what I can get.
In her experience, Mr. Jackson, you have to lay a foundation. In her experience,
She has the
saying
foundation.
animal.
The foundation has been well fucking laid. Are you joking? Again, I said this yesterday at the end of stream. Even the feed has yeeted itself. I said this yesterday at the end of stream. She continues to shift. Make the ruling, don't make the ruling. But she makes the ruling and then starts walking back the ruling. And it's going to be whoever stops talking last. Make the ruling, don't make the ruling. And now walking back the ruling. Well, the only thing the lawyers can do is just continue to fight. That is the courtroom that she is encouraging at the end of this trial. Whoever shuts up last is who's going to have the ruling shift. Well, now the ruling is shifting. The court said she's going to give a burden shifting instruction and she's going to let the defense ask for the consistency. Okay. I can't go code red yet because apparently we're not done. I don't know where the ruling's going to end up because it might work its way backward into where the defense asked for it in the first place.
Bites.
Jackson said, I said animal, but I'll take what I can get.
the cross-examiner, because if you're going to allow consistent opinion with a dog,
No, Mr. Jackson said animal.
I'll leave it at animal if that's what I can get. I'll take what I can get.
In her experience, Mr. Jackson, you have to lay a foundation. In her experience, saying animal bites.
Is consistent.
This is consistent with what she has seen in an animal bite.
And that will include, I'll come to sidebar before I display anything. That will include
Looking at the arm.
a representation of what an animal jaw looks like.
No. No, it will not.
Why is that?
That's my ruling, Mr. Jackson.
Why?
So no visuals.
No visuals, just that one sentence
What about
that's
the arm?
consistent with what she has seen.
You can't just tell them you can ask this one sentence and not this sentence.
It's an animal bite. A brief foundation, because I'm letting that statement in. As long as she has said, as long as she testifies that she has seen animal bites over the years.
Were you there yesterday?
That's it, Mr. Brennan. That's what I'm doing. So you don't want an instruction, Mr. Jackson?
No, both.
Okay. All right. So there are two other quick matters, but the jury's been here, and I don't think we'll get past the break without this anyway. I may have left it in I left it in my office anyway. So let's just bring the jurors in and move forward with this.
Okay.
All rise, please.
It sounds like she's not giving an instruction on burden shifting. Emily, what the fuck just happened? I don't even know. The defense argued this morning that they should be allowed to ask Dr. Laposata about the opinion that the injuries to John O'Keefe's arm are from a dog. The court said she wasn't going to allow it, but she was going to give a burden shifting instruction. And then the defense said, can we at least ask if the injuries are consistent with an animal bite? And the court said yes. And then the Commonwealth said, well, then I need to be able to cross-examine on it if it's a dog bite. And the court said to Alan Jackson, well, he said animal, not dog bite. And Jackson said, well, I will take what I can get. But they asked quite consistently Dr. Russell about Dr. Laposata. And the court said, well, if the foundation is laid. Yesterday, we heard how many different autopsies Dr. Laposata has been involved in that include dog wounds. We won't just say bites, but dog wounds, bites or scratches. And that she has taught courses regarding pattern injury recognition, including animal wounds, dog bites, claw marks, and wounds. And so Brennan is asking, well, then I need to be able to cross-examine on it. And then at the end, she's like, so you don't want the instruction on burden shifting? Okay. I will be very curious to see if these questions end up just opening all the way back up into, are these injuries consistent with dog bites that you have seen? I won't be surprised if we end up all the way back there. And then the court left something in chambers and is back off the bench as the jury comes in. So I'm going to zoom past that. My cat is complaining. My cat doesn't like that was a long time back to chambers. My cat is complaining. I just want to hear some fucking hear-yees. The thing that is so frustrating is that there's timing to all of this. And the role of the prosecution and the defense are different. Their jobs are different. Their obligations are different. So to go down the line of cross-examination with Dr. Russell before making the motion to keep out or any indication to keep that out with Dr. Laposata is why the defense was arguing they're trying to have it both ways, because we can't cut off the argument with the one witness not knowing they're going to argue it with the other witness. It's a fair argument. And then Brennan's like, we can object without foundation at any time. This isn't a lax foundation issue with Dr. Laposata. This isn't lacking foundation. Foundation's not the issue. Okay. We're going to get some hear-yees? Maybe some hear-yees? I need the defense to just say, it'll go faster if you just allow it at some point. It'll just go faster. I'm waiting for hear-yees. Where are the hear-yees?
Hey. All persons have any business before the Honorable Beverly Kennedy, Justice of the Norfolk Superior Court, before the country of Norfolk. Draw near, give your attendance, and you shall be heard. I say the Commonwealth of Massachusetts. The court is now open. You may be seated.
You know, I'm so frustrated that the hear-yees don't even cure it.
Good morning, jurors.
The hear-yees aren't a cure-all at this point because I'm so annoyed. But the defense is ahead of schedule in their case. They have a right to make their case.
Thank you for your patience this morning. I know we brought you in late. Maybe should have brought you in a little bit later, but we've been working in an effort to sort of streamline things for you. So I do have those questions I have to ask you. Is everyone able to follow my instructions and refrain from discussing this case with anyone since we left yesterday? Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left yesterday? Everyone said no or should. All right, can we have Dr. Laposata back, please?
You guys have a number of questions. These decisions are within the court's discretion. They're within the court's discretion. She can make these rulings. She can make these rulings. And I don't agree that there's not proper foundation for this witness. I don't agree that this witness doesn't meet the standards that this court set out for what would meet the Daubert-Lanigan standard. I don't agree, but these are within the court's discretion.
Doctor, I'll remind you, you're still under oath. Thank you.
Thank you. I will.
Good morning, Doctor.
Morning, Your Honor.
So we're back to Dr. Laposata, who brought with her a bottle of water. Not surprised. And we are getting back into defense witness number 10. I tried to gain back down the mic. Hopefully we can hear it.
All right, Mr. Jackson, go right ahead.
Thank you, Your Honor. Good morning, Dr. Laposata. Nice to see you again.
Good morning. Glad to be here.
Yesterday, when we last left off, we were talking about a small injury to the upper eyelid of Mr. O'Keefe. Do you recall that?
I do.
Could we have Exhibit 165 with the court's permission, please?
Okay.
I'd like you to take a look at a specific area. I could. There we go. Right here on this exhibit. You see that area?
Yes, I do.
Tell us what that is.
And that is a horizontal splitting of the skin, which was caused by application of force.
Well, good morning.
That
They're going into injuries to the face of John O'Keefe. That's exactly where they left off yesterday.
overcame the tissue's resistance, so the tissue split. And behind that, we see the raccoonite discoloration of the eyelid from the basal or
From
skull
the brain
fractures.
injury, or the
Can we have Exhibit 13?
brain injury and the broken bones.
I want to draw your attention to this area of the vehicle. First of all, do you recognize this photograph?
Yes, I do.
How do you recognize that photograph?
I recognize it from looking at it in my materials reviewed, that it's the rear of Miss Reed's SUV.
Taking a look at the area that I'm highlighting, right about there.
Yes.
Could we zoom in on that area?
Oh, the upper fin spoiler overhang.
Do you see that overhang over the window?
Yes, I do.
If I use the word spoiler, would you understand what I'm talking about? If we call that a
Yes,
spoiler?
yes. I
Chat
do.
would also understand what you're talking about.
Is the laceration to Mr. O'Keefe's upper eyelid that we just looked at, is that consistent in your opinion with a strike from
Well, there's
that
gonna be an
area
objection to that.
of the vehicle if that vehicle were traveling in reverse at, say, 20 plus miles per hour?
No, that
There wasn't.
that rounded, thick
I'm very surprised there wasn't an objection to that, honestly. Really surprised.
area would not cause that skin
what are you-
defect in his
Such a
upper
hurry about?
eyelid.
George?
If in fact a person were hit
cat's
at,
just
say,
came
20
running
plus
behind
miles an
my
hour
desk.
in the face with that rounded edge, what kind of what kind of injury
Injury.
would you expect to see on that person's face?
I would expect to see
Jackson's asking about the spoiler fin on the car being rounded and what type of injury you would get from the rounded fin spoiler overhang.
a ribbon of bruise that would correspond to the height of that spoiler, and it would go across the eyeball. It would hit the nose. So I would expect to see some horizontal ribbon of bruise.
Did you see anything consistent with that, with Mr. O'Keefe's injuries?
No, nothing.
Thank you. We can take that down. We talked yesterday about this phenomenon known as coup contra coup injury to the brain, correct?
I think she
Yes.
explained it incredibly well yesterday.
What happens to the brain after a coup contra coup, a significant coup contra coup injury?
Yes, this was quite a severe brain injury. Was injured on the back of the brain and also the front of the brain. The falling back and impacting the back of the head made the skull fracture radiate along the base of the brain on the right and left sides. It also radiated around on the side of the skull, and that indicates a tremendous transfer of force and energy to the skull and then to the brain, and the brain is rattled around, therefore, within the cerebral spinal fluid in the skull. So what that does is that it breaks the connections between the neurons in the brain and causes small little hemorrhages, and it causes the brain to swell. So when you get an injury, like if you get an injury on your arm, it starts to swell. The same thing happens when that injury energy is applied to the brain. The brain starts to swell. And unfortunately, the brain, when it swells, it doesn't have anywhere to go.
Yeah.
Because it's encased in the skull. So what happens is that the brain and the brain stem under the brain starts to go down the opening in the base of the skull where your spinal cord goes. And that is a harbinger of death, because that means that the brain stem is getting pushed down in this
Sorry, I can't help myself. Harbinger. All right, I will stop. But I love the way she teaches. I love how naturally she looks at the jury and explains. She's not staring the jury down. It doesn't feel forced. She's checking in with them, and she's easy to follow, and she's also not forcing her explanations. Some people don't naturally talk with their hands effectively. She's just been so great in the way she explains things. I love her flow of explaining. Harbinger of death is something the jury's not going to forget. So, but I love the way she explains. I really do. She makes it so easy, and I just love her entire demeanor with the jury.
hole in the skull. All
right, I'm going to back that up.
And that is a harbinger of death, because that means that the brain stem
That's where we're
is
at.
getting pushed
Harbinger
down
of
in this
death.
hole in the skull. And
Are there any bands named Harbinger of Death? I feel like that is the name of a metal band, or should be.
compressing the areas in the brain stem which control the heartbeat and breathing, and that's called brainstem herniation, and that you just die after that. So that's what happened to Mr. O'Keefe's brain.
I have a document that I'd like to approach with.
Emily, what book series have you been reading? One where the main character is referred to as the Harbinger of Death.
Hand it to you and tell me if you recognize it.
Yes, I recognize this.
How do you recognize that document?
From looking at the autopsy photos of Mr. O'Keefe's brain.
And what portion of the brain are you looking at?
This shows a photograph looking up under the brain, and it shows a cross section of the brainstem that went down in the hole in the base of the skull, and we see there's hemorrhage in it, and those have a special name. They're called Duret hemorrhages.
How do you spell that?
D-U-R-E-T with there's a little accent somewhere
Sure,
there.
over the E?
Yes. And this shows that the brainstem is going down into the hole where the spinal cord goes. It's stretching the blood vessels and causes little hemorrhage and compresses the neurons in the brainstem which control your heart rate and your respiration. It's called brainstem herniation, and that's a harbinger of immediate death.
Your Honor, with that, I would ask for the admission of the next, that document is next in order, subject to the appropriate actions.
Okay, so we'll take that into evidence. Yes.
Your Honor, with the court's permission, with the redaction, may I present the...
Not yet. 1 minute. Jurors, I told you before that there were photographs that have been introduced into evidence.
The court's going to give the photo instruction. I don't know if the brainstem is really that graphic, but okay.
That aren't pleasant. And you may find that these photographs are graphic. And I'm instructing you
I don't know. I
again
feel
that
like
your
brains
verdict
are a
must
bit
not in any way be influenced
more
by the
detached.
fact that these photographs, you'll see some more today, I believe, that have already been introduced into evidence. So your verdict must not in any way be influenced by the fact that these photographs may be unpleasant or graphic. The defendant's entitled to a verdict based solely on the evidence and not one based on pity or sympathy for the deceased, which might be occasioned by the photographs. Importantly, consider the photographs only as they may draw your attention to a clinical medical status or to the nature of Mr. O'Keefe's injuries themselves. So again, these will be presented to you in the deliberation room in an envelope. But today you'll see some on the screen, and I just wanted you to know that before you see it. So now you can display it.
Your Honor, may I approach very briefly?
Yes.
I appreciate that they send the photos back to the jury in an envelope so that they're not flipping through the evidence and come across them. They get to choose how they
Yes,
take a look at
this
it.
photograph shows the cross-section going this way of the brainstem with the hemorrhages caused by the brainstem going down into the foramen magnum.
With that, Your Honor, actually, I think with the court's permission, I would trade that as the next in order rather than the unredacted version.
All right, is there any objection to the switching the exhibits like that?
No.
Okay.
Oh, and the arrows point to that on there.
So this is going to be the next exhibit?
That'll be it.
Exhibit 225.
Thank
So they're on
you.
exhibit 225. I know, Chad. We
The
won't
other one
see
will be
these.
for identification, the first one.
Thank you, Your Honor.
And that'll be FFF for ID.
Photo F, 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 F for ID. Just F. Robin, A, thank you. And B, yes, I agree. Robin in the chat said, as an educator, I love to see other natural educators. I absolutely agree. I've told you in every trial, one of my favorite things about an expert is an expert that loves what they do, loves their field, and loves to talk about it. It's whether I agree with the expert or not, that is vibes. PTSD Advocate, thank you for the 10 gifted memberships. We're going to thank everyone for their gifted memberships as we are waiting for the defense to either put up the pictures or give them the redacted photos and move on with the questioning. We gave ourselves a little zoom room for a reason today.
Okay, you can
I feel like
display
we're going
Thank
to
you,
need
Your
it. B2, good to see you in the chat. Thank you for the gifted memberships.
Do you see what's displayed on the
Elizabeth
screen?
asked, should judges have smartwatches during trial? I mean, I think it would actually be a really big help because there's other things that go on in court that judges need to be aware of and in other cases. So I think that would be a personal choice. There's nothing wrong with that. They have
Yes.
computers
What is
on their
that?
desks that they can use.
That's a cross-section across the brainstem of Mr. O'Keefe, and it shows where the blue arrows I've put in there show the red areas, which are areas of bleeding, which is the sign of brainstem herniation. All the background is white material, and that's part of the appearance of neurons in the brain. So that shows that the brainstem, because of the brain swelling, pushed it down into the hole in the base of the skull where the spinal cord goes, and it pulls on the blood vessels, causing the blood vessels to break and the blood vessels to bleed, and that shows you that the brainstem has been compressed and damaged, causing death.
May I approach?
Yes.
I'm holding a green laser pointer.
Oh, thank
Could you
you.
use the display to your
The
right?
laser pointer's back.
Viewers can better see it. Could you point to the areas with that laser pointer of the bleeding that you indicated causes the swelling?
Okay, so, okay.
It's
that
not
going on the-
It's not as good of a
It is.
laser
It's
pointer as you would
hard
think,
for you to
ma'am.
see.
Oh, that's okay. So this sort of roundish thing is the brainstem, and the arrows are pointing to the red areas. So there's a blood vessel that's broken there because it's been torn and pulled, with surrounding blood going into the neuronal tissue here and over here and over here. And also some of this is also bleeding, with the blood looking brown because the brain was placed in formaldehyde. So all this brown area, the red area, should not be there.
Is
Mrs.
this type of
RCM, they are
herniation
looking at
life-threatening?
It causes death.
they are looking at John O'Keefe's brainstem. I imagine they will talk about how long it would take for him to pass. It's going to go to count 2, possibly count 3, but I imagine that will be part of it. But this is the brain injury that is the primary cause of death, which is what we've heard from the Commonwealth pathologist as well. And what was interesting to me in this case is when we heard from the neurosurgeon from the Commonwealth, and I think that this was probably unexpected by Brennan, but said, I saw these injuries all the time in Minnesota when people would slip on the snow or slip on the ice and fall backwards, or would be drunk and slip and fall backwards, or would have a heart attack shoveling snow and fall backwards. That these injuries are consistent with a fall backwards without more force added, without a push, a shove, a car, anything. Just a fall backwards can be enough. And that's what we have here. So we also have testimony that this wouldn't have been instantly fatal, but would have rendered someone unconscious and incapacitated. So we will see where we get, because the neurosurgeon testified about that, and so did the ME for the Commonwealth. So unconscious, yes. Instantly fatal, no. And we heard from the neurosurgeon that it might have been fatal down the road, but not necessarily immediately. Unconscious, yes. So, continuing on.
Yes, it is life-threatening.
How quickly
Yes.
you can take that down?
Oh, that's where he's going immediately right now. Emily, keep reading.
Should not be there.
Is this type of herniation life-threatening?
It causes death. Yes, it is life-threatening.
How quickly we can take that down? How quickly, doctor, would you expect that this could cause? Let's first talk about incapacitation.
Yes.
How quickly would someone be incapacitated after they suffer a coup contra coup injury of this magnitude with the concomitant injuries that you see in the brainstem?
We got all the way to concomitant today. Jackson's just gone full Alessi this morning.
Well, there would be 2 parts to what that injury would cause the body to do. First, there would be immediate unconsciousness because of the transfer of all the energy to the brain and the massive skull fractures. So that, so that would disrupt the normal function of the brain and produce immediate unconsciousness. Then the brain would start to swell, and within 15, 20 minutes or so, then that brainstem starts to go down the opening in the bottom of the skull, and then the blood vessels are broken, the brainstem gets compressed, and the centers in that brainstem which control the heart and the respiration then stop. So you go unconscious, brain swells, then you die.
Turning to the actual, your review of the actual brain, in this instance, Mr. O'Keefe's injuries specifically, did you reach any conclusion or opinion to a reasonable degree of medical certainty about his incapacitation,
This is her opinion?
the length of time it would take for him to become first incapacitated and ultimately to be rendered dead?
He would be immediately incapacitated with a decreased level of consciousness once he received that impact on the back of the head. He would not be able to make any purposeful movements. There might be some arm jerking or some seizure activity, but he would not be able to carry. He wouldn't be able to get up.
Lock
He wouldn't
the
be
phone,
able to walk.
Face
He wouldn't
ID.
be able to do any purposeful activity. He would be severely concussed, unconscious, not able to walk, not able to carry out purposeful activity. And then as the brain continues swelling and that brain stem gets compressed, then the heartbeat is disrupted, the breathing is disrupted, and then those heart and breathing stop. And within 15 or 20 minutes, then he could be dead.
Is that opinion to a reasonable degree of medical certainty?
Yes, it is.
You testified concerning wound pattern recognition pretty extensively during the course of your giving your qualifications. What is a patterned injury?
A patterned injury is very basic to the training in forensic pathology and medicine because it helps us understand some change on the body, some pattern injury that corresponds to the object that made it. So we can look at an injury and say, we can figure out what made that. Sometimes you can, sometimes you can't. But a pattern injury is very important for a forensic pathologist to recognize because it's going to really help the police investigation. Because I can say, oh, this looks like it's a wound from scissors. This looks like it's a wound from a screwdriver stab. So by identifying the
Members, remind me to talk to you about the case I had with scissors. Just that's all. That's all. Just remind me when we get to members only. If there's a half day Thursday, it'll be Thursday. Just remind me. We need to talk about the case with the scissors.
The pattern that object makes on the body.
Yeah, scissors
I can
are so
help
specific.
the death investigation by helping the police say, look for some screwdriver, look for some hammer. So looking at that, identifying a pattern injury is really important it's basic to the forensic pathologist's knowledge base, and then also very important to the investigation of the crime or incident.
I'd like you to look at another photograph, an exhibit that's already been put into evidence. 160, please, with the court's permission.
The Aurora housewife, yes, or HY.
Sure, is this
So
maybe one of the photographs as
my
well?
brain went full.
Right.
Bravo.
It'll be a
Scissors
series.
not in scissors. Yes. Scissors not in scissors. No, ma'am. Ma'am, the other end.
Laposata, I want to draw your attention to the center of this photograph. First of all, do you recognize?
Screwdrivers are tremendously common. More common than you would think. TV uses knives and guns and stuff, but screwdrivers are, they also leave a very specific pattern, but screwdrivers are fairly common. Also, where I worked, we saw a lot of skateboards and skateboard-related
Recognize what's depicted here?
attacks.
Yes, I do.
How do you recognize?
I recognize it from reviewing the autopsy photographs of Mr. O'Keefe.
You reviewed it, informing your opinions and conclusions?
Not screwdriver the
Yes.
drink, screwdriver the tool.
Can you describe what's depicted in this photograph? What are we looking at?
Yes.
Patricia, I worked in California.
We're looking at the back of Mr.
More
O'Keefe's
screwdrivers,
head and
less ice
an
picks.
injury caused by the angular acceleration going down and hitting his head in the back. And then this is also a patterned injury. So what we see is the horizontal tear of the scalp, and we can see it's undermined a little bit. So that means the direction is going from bottom to top. Also,
These
we
are
see
the external
these sort of
injuries on the scalp
vertical
to John O'Keefe that
lines
they're showing in court.
Here and down below. So what that tells me is that the back of his head hit something that had a fine granular pattern to it to cause those individual little marks, and then also something that had a linear or ridged pattern that he went back on that broke the scalp there. So we have two parts really to this pattern injury. We have the horizontal tear of the scalp made by impact with some sort of ridged surface. And then we have these vertical scraping of the skin above and also below. They're obscured a little bit by the ruler there, which says that whatever he hit had some little like granularity to it with each little sort of granule.
Right, the Commonwealth's going to ask
those
about that
vertical
berm.
marks, and then the ridged pattern having
Because
the-
this isn't, she's not talking about, well, we'll see if they ask her about a step. We're not talking about a step necessarily. The Commonwealth's going to ask about the berm because it's different than what their expert, Dr. Wolf, hungry like the, not Dimples, testified to about a flat surface and this injury being consistent with a flat surface. So you have two differences here, but I imagine we'll get to the skull fractures being consistent with a flatter surface because there's no, I don't want to be too graphic, but there's no deep indentation into the skull. We'll leave it at that.
major point of impact.
What is the significance of the pattern when you say ridged pattern and there's two things we're looking at, the laceration or the abrasion versus the defect above and below that laceration?
Yeah, so what this injury tells me, or what I would tell the investigators, is that Mr. O'Keefe went back onto some object that had some sort of ridge to it to make that horizontal tear in the skin, but that ridge also had, it wasn't smooth. It had some little grainy,
Like the berm.
grainy thing sticking up on it that would make
It was not
each of
smooth.
then these little things. And then it's the job of the police then to go back to the scene and look around for something which might fit that pattern.
We can take that down.
Yeah, we're
Did
gonna
you,
hear
in furtherance of your investigation,
questions about
coming to your opinions and conclusions, look.
We're going to hear questions about that. However, a number of you in the chat have asked the same thing. Like gravel, yes, but like a hat. And I would think that it would depend on the clasp on the back of the hat. So it would depend on the clasp on the back of the hat. But a lot of you have asked, what about the hat? So could the clasp on the back of the hat be something we hear about in Cross? We'll see.
At the area of 34 Fairview,
The outside, yes.
meaning photographs.
Yes.
Did you also see photographs of any significance to you related to the garage, the interior of the garage?
Sustained. Jurors, disregard that comment.
Brennan immediately asked for a curative instruction with the question about the inside of the home.
Photographs of any significance to you related to the garage, the interior of the garage?
Sustained. Jurors, disregard that comment, that question.
What part of the area did you see? What part of the location did you see?
So that question was stricken.
I saw all the scene photographs taken by the police, which showed the front yard in the area where Mr. O'Keefe was found. I also saw some photographs of the inside of the house and the inside of...
So I'm going to stop you there, Dr. Laposata. Jurors, I'm striking anything after what the pictures from outside, Mr. Jackson. Move on.
Let's stay with the outside of the home. Did
Yes.
you see the front lawn area?
Yes, I did.
How did you? What did you note about the front lawn area?
Well, I was looking at the area where Mr. O'Keefe's body was found, because we know once he came back and slammed his head, he's not going to get up and move around.
So, yes, I'm going to
No.
strike the second part of that.
Why?
Answer.
After the head injury, she's allowed to testify that he can't get up and move around based on the medical opinion that she just gave. She can testify to that.
Slammed his head. He's not going to get up and move
I'm going to back up to the question
around.
because that's responsive to the question as well, and based on her opinion.
Well, I was looking at the area where Mr. O'Keefe's body was found, because we know once he came back and slammed his head, he's not going to get up and move around.
So, yes, I'm going.
I think the prosecution took issue with the characterization of once he slammed his head, but I don't think anyone's interpreting that to mean that John O'Keefe did something intentional to cause his injury. All of the evidence in this case has said that his head injury is caused from going backwards. The cause of him going backwards is what's really in dispute. It's not in dispute that the head injury is caused from him going backwards. So I hear her using slammed his head colloquially, not as if he did something. Does that make sense? But I think the DA is reacting to, or the special prosecutor is reacting to that characterization.
You strike the second part of that. Just answer the question specifically.
Okay, I'll try, Your Honor. Thank you.
It's within her
Why were
opinion.
you interested in the outside area where his body was found?
Because then I could identify an object possibly there that would have caused the injury on the back of his head.
Did you see any such object in any of the photos that you reviewed?
No, there was nothing there. It was a flat grass surface.
Would the flat grass, let's assume that the grass was very cold and very hard, the dirt was very cold and very hard. Would falling backward onto that dirt, hard or not, would that cause the patterned injury that you see, that we just saw in Exhibit 160?
No.
And that's the difference between the two experts. Dr. Wolf, hungry like the, said, yes, we see this all the time. Yes, this is consistent. She said, no, this is not coming from a strike on a flat surface. So it's going to come down to which expert. And a number of you in the chat have asked about the fire hydrant. I think we would see different types of injuries from the fire hydrant, and I'm not going to be more graphic about that, but we don't have a concave fracture to the back of the head. So what we have from the multiple medical doctors is that that is going to be a more dispersed surface, not like the pointy parts of the fire hydrant. But that's what I'm taking away from the testimony.
Why do you say that?
Because if you fall back on a flat surface, you get many times the tear you get in the scalp can be more like a star, because you've just hit one part and then the
Splits.
tears go in kind of a star pattern. And also because you would not have those
And we heard that from Dr. Wolf as well.
Discrete vertical scraping of the skin. You would tend to, if you fell back on grass, you would tend to see, you might see grass in the wound, or you would tend to see an irregular kind of crisscross pattern of the flattened grass. And that's not what we have here on Mr. O'Keefe.
Do you have any training or experience in diagnosing hypothermia in individuals?
Oh, yes.
Have you conducted autopsies of individuals who've suffered from or died from hypothermia?
Yes, many.
And again, helpful to have
many?
somebody from the East Coast.
100 or more, and then I've supervised my assistants who've also diagnosed the same death from decrease in body temperature.
Yes, on the West Coast, you can have hypothermia as well, but a coroner from Los Angeles is not going to see as many hypothermic deaths as a coroner from Rhode Island or Massachusetts. It's just different. And I would imagine most of the hypothermic deaths in California also involve water, especially if you're in Los Angeles. So it's helpful to have someone on the East Coast for this who's going to have seen more of them, also that aren't involving water specifically.
Have you ever engaged in any death
I would
investigation, aside from the actual autopsies, death investigations in which the cause of death was deemed to be hypothermia?
Yes.
How many times would you say you've undertaken that type of investigation?
At least 100.
Have you ever reviewed any peer-reviewed medical literature associated with or discussing hypothermia and something known as Wisniewski spots?
Yes, that's in the medical literature and also in our forensic textbooks.
Did you review the medical examiner's file, Dr. Scortibello's file, as it related to, in connection with this case, you reviewed the entire file, correct?
I did.
Did you conduct a differential diagnosis as it relates to the potential for hypothermia?
Yes, I did.
Describe, before we get into your findings or your conclusions and opinions, what is inferential thinking?
Inferential thinking is another name for making a differential diagnosis. In other words, seeing a finding and then saying, how many ways can I get that finding? And then go and investigate each one of those ways and either rule them in or rule them out as being responsible to causing that finding.
Did you note whether or not the medical examiner, Dr. Scortibello, mentioned hypothermia as a potential cause of death in this case?
She did put that on the death certificate.
Along with something else?
Along with the blunt force head injury.
Do you agree
I mean, it was blunt
with
force as
blunt
the
force head injury
primary.
as a cause of death?
Yes, Mr. O'Keefe died from the blunt force head injury.
Do you concur with the diagnosis of hypothermia?
No, the body did not have any hypothermia.
What led you to that conclusion?
Well, when you have we know that normal body temperature is around 98, and we know that then at the hospital that Mr. O'Keefe's rectal temperature was around 80. So we know that his temperature went down. So there are two ways the body temperature can get down. It can get down while you're alive, or a dead body also cools when it's in a cold environment. So those are the two things you have to look at.
What I still don't have an answer to, and I know this will interest 7 of you in the chat. It's more than that because we have way more nurses in the chat. But I still don't know when they took his body temperature because they were undergoing efforts to warm him back up. And I have questions about the timing of that. It's probably more in depth than anybody wants to know, but I have questions. I've also seen a lot of questions about the victim's blood volume, that there's no testimony regarding that in this trial. And there is no testimony about
Do you recognize
volume.
what's depicted in that photograph?
Yes, I do.
What is that?
This is a photograph I took from our forensic medical literature, and it shows the lining of the stomach. So the stomach is opened up, and we look at the lining of the stomach, and it shows a characteristic pattern of small ulcerations throughout the stomach, which are called medically Wisniewski's ulcers. And that allows a forensic pathologist to diagnose
I'm never going to think of anything other than
death
Wazowski.
from being exposed to a cold environment or death due to hypothermia. And they're caused by, as the body gets colder and colder when it's alive, the small blood vessels in the lining of the stomach, they start to break, and then they're in the
I don't know if
acidic
they took
environment of the stomach,
his
and you
temp
get
on
tiny
scene.
little ulcers, which then look like
been
small
testified to.
dots. And that is how at postmortem examination or autopsy, it's one of the findings I look for to see if a person died from hypothermia.
Doctor, what is gastric mucosa as it relates to the stomach lining?
The gastric mucosa, when you open up the stomach and you look at the inside, the first cells lining that inside is called the mucosa.
Is that what we're looking at in this photograph or no?
Yes, we're looking at the mucosa with ulcerations, which are little craters that form in it due
She's
to
explained that so
hypothermia.
well.
Is that exemplar of what Wisniewski spots looks like as it relates to hypothermia from a book that is, or literature that is peer-reviewed?
Oh, yes.
Is it widely accepted in the medical field?
Yes, it is.
And is it referenced
She's like,
by
yes.
forensic pathologists and used in teaching?
Yes.
Your Honor, I would move for the admission of that photograph.
Okay.
I once, and this is probably a story for members only as well, but my doctor at one point asked to take a picture of something that was going on with my arm. And she's like, I've only seen that reaction in in the medical literatures, I've never seen that in person. Can I take a picture? And I was like,
Exhibit 226.
sure. And also, of course, it's me. That's delightful. That's delightful. I'm so happy for me. That, I've only seen that in the literature.
Is this
not something you want to hear.
representation of what you were just looking at?
Wow.
Yes.
Describe what we're looking
Never
at.
seen that before.
Okay, so this, I took this photograph from our forensic medical literature, and this was from a person who died due to exposure to a cold environment. And this is the stomach has been opened, and we're looking at the inside of the stomach. And the normal appearance is kind of pinky white. That's how it should look like. And what's abnormal here is all these black dots, which are the Wisniewski's ulcers, which are diagnostic of death due to exposure to the cold. So these areas...
No, the temperature would have been taken at the hospital. I just don't know when, because the temperature of John O'Keefe, I'm curious when they took it to the hospital, because again, he needed to be warm. The first EMT on the scene was treating this like a code, like he just done. The other senior paramedic said, no, we can't declare him until he's warm. So then they started CPR. Then they were trying to warm him up. I don't know if EMTs took his temperature. We didn't hear any testimony about it. And we didn't hear testimony from anyone at the ER, any of the medical personnel at the ER, about when it was taken. It's just a lingering question. It's not going to matter, I imagine, for the jury, because that temperature, the 80 degrees, was at the hospital. We don't know how much warming efforts, because we also heard that I don't know if we heard in this trial that they were doing saline and things to try to warm him up before they declared him. So I don't know exactly when in time that was, because we didn't hear from anyone at the ER. But it's not super relevant until we now have a battle of the experts over whether or not there is, in fact, hypothermia. Why is the defense fighting over hypothermia? The defense is going to have to focus on count 2. And it makes sense, because for a lot of jurors, they're going to look at count 1 and see count 1 as a volitional homicide and look at this and go, where's the intent? But count 2 does not involve intent. So getting to whether or not John O'Keefe had someone called for help, had he not been left in the snow, those kinds of things are important to the defense. So fighting the hypothermia works on 2 points, and fighting the hypothermia also goes to he was not outside for as long as they say. There are 2 ways they can argue it, as to count 2 and as to he was not outside that long. So that's why we're getting into the hypothermia for their argument. Because if he wasn't outside that long, it didn't happen how the Commonwealth said. And that's the point of the defense. The defense is not getting into a third-party defense. They're not saying this person did this. What they're saying is it couldn't have happened the way that the Commonwealth said. And part of that is he's not as cold as he should be if this happened when the Commonwealth said. Because the Commonwealth's window of when this happened is like within 3 minutes at 12:30, whatever. So this goes to, there's no way he was out there that long. All right. Continuing on.
Are little tiny craters, and they fill up with blood. And we see that in over 90% of the cases of people who die from exposure to the cold.
Doctor, did you also look at Mr. O'Keefe's stomach lining?
Yes, I did.
If we could have, with the court's permission, Exhibit 164 put up as well.
I think we're going to start to see in this witness and maybe the next witness as well, the Commonwealth's strategy here was to really pare down the evidence.
Do you see the photograph on the right?
I
Yes.
think some
What
of
is
these
that?
things are going to bite them.
This is the Mr. O'Keefe's stomach, which has been opened up when we're looking at the inside. We see that the mucosa is a little bit red, and there's a little bit of increased blood flow here. And this is the normal pattern of the inside of the stomach is kind of ridged. That's called rugae. That's the normal folds inside the stomach. But there's no ulcerations here. So the diagnosis of death due to hypothermia is not appropriate in his case.
Did you see, or do you see, any classic Wisniewski spots in Mr. O'Keefe's stomach lining or gastric mucosa?
Sarah, I disagree.
No.
Do you observe?
I disagree that the title has spoilers because the defense said it in their opening. So this is what this witness is what the defense talked about in their opening.
Any ulcers
appreciate it.
specific to Mr. O'Keefe's stomach lining?
No, there are no ulcers. It's a normal appearance of what we would call a gross specimen when
And
you
that's
open
not
the,
what
the
Scortibello
stomach.
said.
At autopsy, you can see some redness of the normal lining of the stomach.
Did you, let me ask this first. Do you have an opinion as to a reasonable degree of scientific certainty based on the totality of your review and examination of the autopsy and its associated file, an opinion as to whether or not Mr. O'Keefe died of hypothermia or complications related to hypothermia?
I do have an opinion.
And what is that opinion?
He did not die of hypothermia.
And is that opinion to a reasonable degree of medical certainty?
Yes.
Taking a look at the
It doesn't mean he
darker
didn't
red
have
areas,
hypothermia, and I'm sure they will say that too. Ugros Haley said, was he dead before he was put in the snow? That is what the defense said in their opening, that the evidence will show he was killed somewhere else and then put into the snow. That's what the defense is arguing.
in the stomach lining of Mr. O'Keefe on the
That's
photograph
not
to
what the
right,
Commonwealth
Yes.
is arguing.
Exhibit 164. Can you describe what those are? What are those darker areas?
Well, here we see a little bit of bleeding. The darker areas are the areas of the lining that are at the bottom of the normal rugae, because the inside surface of the stomach sort of looks like it's covered with little mountains. And so we can get the redness in between what the rugae and the stomach. And there's a little bit of increased redness here, but no ulceration.
Do you have an opinion, or were you able to form an opinion as to what the increased redness might be or is associated with?
Yes.
Did you note anything of significance in the rest of your examination of the file, the autopsy file, the medical examiner's file, that was
Is it
related
about
to
alcohol?
what you see in the photograph
About alcohol?
164?
Imagine
Yes.
it's about alcohol.
See its eyebrow for just a minute here.
You can take that down.
You're just hiding back there. My cat is just hiding behind the What are you doing? Oh, he's going the other way. Are we playing hide and seek? Georgia, I'm streaming. We can't play hide and seek. He's just looking around the monitors on both sides of me, just peeking at me. All right. They are going to sidebar regarding why else the stomach might be red. I think we have foundation for that.
May I continue?
Yes.
Thank you. With regard to the, it's my word, not yours, doctor, so forgive me, the defects, the redder marks
The
that
redness
you're mentioning
to the stomach.
on the rugae or in and around the rugae, on the gastric mucosa. Did you note that there was a machine that was used for life-saving measures as it related to Mr. O'Keefe?
Oh, yes, it caused some damage to the body.
Okay, let's talk about that for just a quick
Lucas.
second. What is that machine called?
It's a mechanical device to administer chest compressions, and the company that makes it is called Lucas, or one of the companies, so it's
I
called
think
a
Lucas
Lucas
is an
machine.
acronym.
And it can be attached to the body. Your arms go up over a ridge. And
Also, replay crew, love you. You guys have had great comments in the comment section after we get past the first 6 that are always spam, that are never y'all, that every day we go in and spam bot, swat, and then we get to all our comments. But somebody shared in the comment section what Lucas Machine stood for, so appreciate it and thank you. It's in yesterday's comments, but yes, it's been very helpful for all of you saying, I know that from the pit. Yes, that too. I don't think they ever did it. I don't remember them doing it in Grey's Anatomy, but so many things happen in Grey's Anatomy. Thank you, Susie, said Lund University Cardiac Assist System. Appreciate it. All of our medical folks, it's rough. So we saw the defense cross-examine Dr. Scorti-Bello about the Lucas machine, and we know that the Lucas machine was used here, and some of the damage to the body that Dr. Scorti-Bello attributed to hypothermia, I would imagine this doctor is going to be attributing to the Lucas machine because it was asked then.
There is a plunger, and it goes around your back, and so it just plunges, and it does mechanical resuscitation and chest compression, compressing the chest right over the lower sternum, about 2 inches or so, and it's very helpful
Brutal.
in a situation where the manual compressions, where the attendants and the ERT people, they get tired continually compressing
It's
for a
hard.
long period of time. So the mechanical device was invented to prevent the EMT fatigue when administering chest
CPR
compressions.
is hard to
When you
do.
mentioned the sternum area of
Yes.
the body,
But again, in this case, they weren't using the Lucas machine for resuscitative efforts. They were doing resuscitative efforts till he was declared, but they were keeping blood moving around. But it's clear from the paramedics that this was not a scene where they thought that there was a chance of survival, if that makes sense.
I'm saying, are there organs beneath the area that's being compressed by the mechanical Lucas machine?
Oh, absolutely.
What do those organs include?
Well, ideally they include the heart because that's what's supposed to be pumping the blood out, but it's also in a circular area that's right below the sternum, which includes the heart. But what is also under there is the esophagus and the interior of the stomach. So this area is right under where the machine is compressing as well, as long as, in addition to part of the head of the pancreas, which is also right there under the lower sternum. And what can happen with the Lucas machine pushing in for 100 times a minute for a depth of about 2 or 2.5 inches, that these organs right underneath of it get compressed between the Lucas pump
They get squished.
and the bony vertebral bodies that's along your back. So you have the Lucas machine compressing these organs, and they're compressing them against the vertebral bodies of your bony vertebral column in the back. So you can get other injuries, organ injuries, that is a complication of the automated mechanical resuscitation. You can get cardiac ruptures, you can get ruptures of the liver, because all those organs are clustered
now
right
hitting
there.
your
And that
bones.
machine is pushing those organs in between the pump and the back of the bony spinal column.
Doctor, in your review of the medical records, was there any indication that an automated chest compression machine, a Lucas machine, was used
Yep.
on Mr. O'Keefe?
Yes.
And there were
Maybe we
rib
can take this
injuries
down.
consistent with that.
Yes.
All right. He has to approach, which means he's going to show Brennan whatever he's approaching about. A lot of you have commented today about how easy to understand this witness is. I agree. I find this witness very easy to follow.
Documents that I'd like to show you first.
I just pulled up a question as Jackson just walked up. Banj? Bang? Yes. In the chat said, EDB, please answer. Yes. Are the lawyers allowed to bring things up in closing that weren't brought up in trial? No. Nope. They cannot. It has to be in evidence. And third-party culprit is something that is not going to be in closing. It has not come into evidence. They're not going to get a jury instruction on it. They didn't last trial. They're not going to this trial. But no, if it is not in evidence, they cannot argue it. We've seen this in a few trials where we've seen those facts not in evidence objections. And it can be hard in a retrial on the lawyers to parse what is in evidence this trial and what is not, especially with that pared down presentation of evidence from the Commonwealth, but the defense team and the Commonwealth team both have enough lawyers on the team that parsing out a closing with what is in evidence, I think will be helpful. So no, they cannot bring up facts that are not proven in evidence.
That
Yes.
document, and then after you're finished, familiarize yourself. First one and the second one.
So all the butt dials you haven't heard about, yes.
Yes.
The
Taking the
phones,
first
all of that.
document
No, they cannot bring it up.
Addresses the Lucas machine.
Yes.
How do you recognize that photo or those series of photos and graphs?
These are illustrations I put in my report, and one shows a generic patient with the Lucas machine in place around him to do the
Showing
chest
how it works.
compressions. Then I have a photograph of the actual apparatus of the Lucas machine itself. Then I show
Photos are helpful.
what's recognized as medical complications and injury from that machine. It shows, I have an example of a CAT scan of a section through the body horizontally, right where the plunger goes into the chest. And it shows in another patient hemorrhage around the pancreas and around the top of the stomach. Then I have a diagram also taken from our medical literature that shows the direction of force that compresses those organs between the resuscitation paddle and the vertebral body and the backbone.
Doctor, are those photographs and graphs taken from peer-reviewed literature in the medical field that's normally relied on by other medical professionals?
Yes.
Your Honor, I'd move for the admission of that first document.
Right, subject to redaction?
I don't think so. I think that that one is not objected to.
Okay. All right, so would you hand that to?
Sure, thank you.
So not subject to redaction because it is agreed to.
227.
These are exhibits regarding the Lucas machine. Creek asked, how is the cat doing without their favorite? He's been hanging out with me a bit more, but, you know, he definitely came yelling when Travis was on the phone and told Travis exactly what he thought of him.
Doctor, I know
gone.
that's a little bit small and far away. We'll enlarge it as you need.
Okay.
It's not an eye test. Can you tell me what we're looking at? Yeah, let's take
It's
the top
not
half
an eye
of
test.
the document. What is that to the left, and then what's the machine in the
Okay,
middle?
so what you see on the left is a anonymous patient showing how the Lucas machine is placed onto the patient, where the arms are pulled up
Thank
and
you, Westall.
clasped against these rigid
are
mechanical
photos of the
bridges.
Lucas machine.
And then here is the engine which puts the pump, and that's the pump which just goes up and down to do the chest compressions. And so that's how it's affixed to a patient.
To be clear, Doctor, that is not Mr. O'Keefe. That is
No, this is
Could be a model.
an unknown person.
Okay. And then what are we looking at in terms of the actual machine to the
Yeah,
right?
this shows the actual machine before it's put on a patient. You can see how it encircles the patient, and then there is this circular pump, which is the compressor pump.
If we can look at what is that a picture of? The
pump.
The highlighted portion.
That's the circular part that actually is projected down onto the body.
That makes contact with the chest.
Correct, and it has a spring in there that the engine above it gives a certain number of compressions per minute.
And you said on average the compressions per minute would be about what?
Now, they should be around 100.
Okay. If we could go to the bottom half of the page of the graphics on the bottom. What are we looking at in this photograph?
And we're looking at, on the left side, we're looking at a
Organs.
CAT scan, which scans a person who's had some injury from the Lucas compression machine.
His body's squished.
And it's a cross section. So the arrow here is pointing.
A number of you are asking about Recessa Annie or CPR Annie. I do not know CPR Annie's relation to Rescue Randy, but I have no judgment. But I do not know the interrelatedness between Recessa Annie and Rescue Randy. I do not know.
To the head of the pancreas and the area of the esophagus, and then the machine would compress down onto that, And the important part is that, I don't know if that's working on there, the little thing that looks like at the very bottom, that's circular and then has a little, looks like a little steer head, that's the vertebral column, and that's bone. And so the pump is pushing in that area where the arrow is pushing those organs against the bone.
Is it just me, or does it well, in the drawing, it looks like the Snapchat little ghost situation, but she said steer head, so we're going to leave it there.
Vertebral column. Excuse me.
James, that's funny.
And that's an actual patient that had that. Then on the right, it shows the schematic of the blue arrows indicating the force coming down. Then we see the organs, and the red arrows show how the pancreas can get hemorrhage, and also some of the esophagus that goes into the top part of the stomach. And we see that's, I can't really see where that, I think it stopped.
May I approach you?
Yes.
Oh, no, you've got it.
I feel like they're fighting over the pointer again.
And
Victoria said, are we going to get to ARCCA
um,
today? I think we'll get to Dr. Rentschler
today.
today.
At the bottom, with those three little things projecting from it, that is the vertebral body, which is made up of bone. So you can see how the chest compressions, not only hoping to save the life by keeping the heart blood functioning, can also cause some injuries and damage, not life-threatening usually, to the other organs there.
We can take that down.
I've seen a number of questions about closing. I'm going to answer this one, and then we'll get back into the testimony. But the defense can say who you hadn't heard from, things you hadn't seen. You didn't hear from Trooper Proctor, those sorts of things. But there is still a motion pending. I talked about this morning before we started with court regarding whether there will be a jury instruction on that. So there are things where the defense can point out the questions that haven't been answered. The prosecution can't say, well, the defense didn't prove this to you, because that's shifting the burden onto the defense. They don't have the burden. So the way the prosecution can do that is different than the defense. Hopefully that makes sense.
Taking a look at the second document that's in front of you, do you recognize what's depicted in that document?
Yes.
What is that?
This is a picture of Mr. O'Keefe's chest while he's at the hospital, which shows a lot of the resuscitation equipment.
Is that a true and accurate depiction of the of Mr. O'Keefe at the hospital based on your review of the medical file?
Yes.
I'd move for the admission of that.
Liz asked, is it preferable to do closing before the weekend?
Oh.
Ask me as we get further along. Kim said in the chat, I tell people CPR usually at least breaks your ribs. You can survive broken ribs, but not your heart stopping. So you need your heart to be going. I will have more fulsome opinions about when they should do closing when we get through the witnesses, because it's really going to come down to timing.
Permission to display briefly.
There was a question about whether John died at the hospital.
Taking a look
or before
at
they found
the
his body.
Photographs to the left and to
Before
the right.
they found,
do you see
he was
any
deceased when they
indication,
found him.
on Mr. O'Keefe's body that is suggestive that the Lucas machine, where the Lucas machine was situated?
Yes, as I pointed out here with the blue arrows, that big circular mark there is the mark on the skin where the compression pump compressed the chest of Mr. O'Keefe, and it caused some rib fractures, and it also caused those reddening of the stomach and some hemorrhage in the pancreas.
We can take that down. Doctor, based on your review of the medical records, did you calculate the approximate number of compressions that Mr. O'Keefe would have been subject to based on that Lucas machine?
Yes.
What is that calculation?
His body was found around 6 a.m, and he got to the hospital around 6:37, I think. So if they put the Lucas machine on him when they got him into the ambulance, and it's compressing at 100 times a minute, and that is from the time of the body being discovered to the time at the hospital, that's around 37 minutes. So if you multiply 37 minutes times
I mean, it's gonna
100
be a little less
compressions
than
a
that,
minute, that's around, over 30,000 compressions that would have been done to Mr. O'Keefe's body in the course of his resuscitation efforts.
Doctor, do you have an opinion as to what caused the hemorrhaging that we saw on Mr. O'Keefe's stomach lining?
Yes.
What is that opinion?
It was from the blunt compression of the Lucas machine.
Is that opinion to a reasonable degree of scientific certainty?
Yes.
You indicated earlier that there is a difference between someone dying of hypothermia, complications associated with hypothermia, and a body that's already passed away just cooling, correct?
Correct.
Do you have an opinion as to a reasonable degree of medical certainty as to whether Mr. O'Keefe suffered from
I'm
hypothermia?
sure the math will come up on
I do
cross.
have an opinion.
What is that opinion?
He did not experience hypothermia.
Did you observe any signs of frostbite?
No.
No one did.
Did that have any weight concerning your opinion, overall opinion, as to whether or not Mr. O'Keefe died with complications associated with hypothermia?
Well, if someone dies due to exposure to low temperatures, you expect to see not only the Wisniewski's ulcers, but you expect to see some frostbite changes in the extremities.
Based on your overall review of the medical records associated with Mr. O'Keefe, were you able to reach an opinion and conclusion as to the cause of death of Mr. O'Keefe?
Yes.
What is that opinion?
He died
Force injury to the head.
of brain injuries and skull fractures due to blunt force trauma of the head.
Do you hold that opinion for Mr. O'Keefe's cause of death to a reasonable degree of medical certainty?
I think
Yes.
Jackson's probably almost done.
I want to shift gears for a minute, Dr. Laposata, and talk about
And then he said shift gears.
patterned injuries elsewhere on Mr. O'Keefe's body. You've obviously talked about your training
I
and
thought that would
experience
be
as
the
it relates
end.
to recognition of patterned wounds,
But okay.
correct?
Correct.
That's something that you were trained in when you were training, correct?
Yes, it's
I wonder if the reason Jackson did all of those opinions is because it is easier and we're not going to get into as many potential objections and sidebars. So leave that opinion kind of as it is and then get into the opinion that, well, there might be a little bit more objecting about. Maybe not.
very basic to the discipline of forensic pathology.
And have you also trained others during the course of your 40-year career on the issue of wound pattern recognition?
Yes.
You've taught courses and given lectures, is that right?
Yes, I have.
I'd like to show you Exhibit 167 with the court's permission.
Okay.
Hillary in the chat asked, how does this doctor have opinions about how John died when
Do you
the
recognize
other
what's
coroner
depicted in this
didn't?
photograph?
The other coroner did have a cause of death. It was the manner of death that was left undecided. The cause of death from Dr. Scorti-Bello was the blunt force injury to the head, causing the brain swelling, brain damage, and the skull fractures. And then secondarily, hypothermia. That was what Scorti-Bello said for cause of death. Manner of death is what Scorti-Bello said. She could not attribute it to homicide versus accident, etc. So that's why it was left undetermined.
Yes.
How do you recognize it?
Is a photograph of the right arm of Mr. O'Keefe.
Did you review and consider this photograph and others in coming or forming your opinions, coming to your conclusions and opinions in this case?
Yes.
In order to come to your ultimate opinion and conclusion, or opinions and conclusions in this case, is it important to take all of the injuries that a decedent may have suffered into account rather than one or two piecemeal?
Now, you have to look at the whole picture to understand what happened to the body.
Why is that? What's the importance of that? It may be obvious, but explain that for the jurors, please.
Well, when you're looking at changes and injuries to the body and trying to understand what happened to the body, there are different patterns of injuries on different parts of the body. And by trying to separate those and understand what patterns were caused by certain things, then you're able to put together a sequence of events that happened to the body prior to death.
What role do photographs play in a forensic medical examiner reviewing the medical evidence and coming to opinions and conclusions? How important are photographs?
Oh, those are huge. It's standard practice to always document at the postmortem examination important findings with photography.
And charting.
Were the photos in Mr. O'Keefe's case useful in coming to opinions and conclusions concerning his injuries altogether?
Yes.
What about the injuries to his right arm?
Yes, those photographs are very important to understand those injuries.
Do you believe that there is a patterned injury on Mr. O'Keefe's right arm?
Yes, there is a pattern injury there.
Have you ever seen, in your experience, either being taught or teaching, patterned
He is
injuries as they relate to animal
taking
wounds?
each small step towards what he wants to ask.
Absolutely. Very common.
Do animal wounds include both claws and teeth, dentin?
Yes.
So bite marks and claw marks might be two different types of patterned wounds that you may see in your evaluation, just
Correct.
in general?
Correct, because when an animal approaches the body, there may be damage from the claws and also from the mouth.
Do you expect to see punctate wounds as well as linear abrasions?
Yes.
Do you expect to see certain bite patterns as well?
Yes.
What types of injuries, let's talk about animals in general, what types of injuries do animals produce on the skin of human beings?
Well, animals can produce, if you're talking about, mammals, can produce injuries from their claws, where you get parallel scrapes of the skin from the claws applied to the skin, or you can see a pattern from the jaw configuration of the animal. And most animals that attack or get in contact with the body have canines. So there's two canines on either side that make paired marks, and that would be called a pattern injury.
Are you talking about the canines of the canine or the canines of the K9? Which type of canines are we talking about on the teefies? She's just a delight in the way she testifies. She's like, the teefies. I love it so much.
So it makes parallel sort of gouges, and as the canines move in a horizontal pattern or a vertical pattern, the space between them can change. The other thing you see in a animal bite is you see not only the canines that come out, but depending on how the jaw is applied to the body, you can have little dot-like imprints in sort of a U-shaped pattern, which are from the incisors, the little incisors of the animal. So you look for punctures, you look for paired gouges, which would be the canines, and then you look for arced patterns of little dots, which can be the application of the incisors of an animal bite.
What is an incised wound?
An incised wound is a wound due to cutting from a sharp object.
Would you expect to see
Incised wound, not to be confused with incisor teeth, and canine teeth, not to be confused with canine, the species or genus. Damn it, it's been a really long time since high school. Chat will let me know. Chat is bait. Just look at the chat. They're correct. Canine, the teeth, not canine, the animal and not canine the police dog. Lord, today.
Incised wounds from an animal bite or claw marks?
No, they don't cause, they're not like knife wounds. They cause more of a scraping injury.
Do you see the injuries that you're looking at in Exhibit 167, are these more consistent with incised wounds or the scraping abrasions that you just talked about?
Sustained.
What?
Were you able to determine from your review of the medical records whether the injuries that you see on Mr. O'Keefe's...
The ME can talk about whether these are abrasions or lacerations. Okay.
right arm were pre-mortem or post-mortem?
They were, oh yes, I can determine that. They were inflicted prior to death.
Do you have an opinion as to whether or not the wounds that you see, the patterned injury that you see on Mr. O'Keefe's right arm is consistent with an animal bite or claw marks?
Yes, it is, very much.
Thank you. You can take that down. May I have just a moment, Your Honor? Actually, Your Honor, may we approach very briefly?
Okay.
Sorry, Chad, I'm talking to Dr. B real quick because I thought they had more questions and then they went to sidebar. So Dr. B is on the phone. Dr. B, I'm streaming. But
no, I'm fine.
all right, bye. Dr. B is picking up Starbucks, but Dr. B did not respond when I texted because Dr. B, when I said, do you want anything? So before I put the order in, I wanted to make sure that he told me if he wanted anything or not. So let's zoom past the sidebar. She should be allowed to talk about this. Jackson has been literally tippy-toeing through this line of questioning. And if any of you are like, why doesn't my partner, whoever, answer the, yes, I don't know. The man does not live on his phone. His screen time is like 10 minutes a day. So he does not see it. Oh, chat's like, bring enough for everybody. You know what, chat? We could do a code. I mean, there are like 50,000 of us in here. Tomorrow we will do a Starbucks.
May I inquire?
Yes.
I have to figure out
You
how to not
indicated
have
that, in your opinion, the
attached to
wounds to Mr. O'Keefe's arms were pre-mortem, not post-mortem. His
chat
right arm, I
is
should say.
so-
Pre-mortem, not post-mortem.
Also, if I am not pulling up questions, I'm having some struggles with the chat software wise. I can see you guys in the YouTube chat, but the software chat is fighting with me. So if I'm just saying some things in chat and I'm not pulling it up, it's just because I'm having a little trouble.
Correct?
Correct.
Oh, Dr.
What's
B is
the
not on
basis
his phone
for
at
that
all.
opinion?
Well, a forensic pathologist has to be able to
So this is foundation.
differentiate changes that happen to the body while the person is alive versus things that happen after the person is dead. For instance, there is something called post-mortem predation, where if the body is out in the woods and dead, then wolves and such can come and make, quote, injuries to the body. But we're able to tell from our training and experience that those were made after death. The usual way we tell is that when it's made during life, the blood vessels that are damaged, the heart's pumping blood through, so you can see a reddish color and maybe some blood around it. Whereas if the body is damaged after death, the changes to that body and those, quote, injuries look more yellowish and kind of brown because the blood is not flowing. So that's how you can tell if something done to the body is while
Right,
the body
she
was
knows.
alive or whether it was done after death.
Do you have an opinion to a reasonable degree of medical certainty that the wounds on Mr. O'Keefe's right arm were pre-mortem?
Yes, they were done while he was alive and bleeding.
You talked about
Which is
death
consistent
investigations.
with
As a matter of
everybody.
fact, you mentioned something about what a forensic pathologist's role is in a death investigation to potentially send investigators back out to answer certain questions, correct?
Yes.
Did you see any evidence in the medical records or the medical examiner's complete records, that any effort was made to send investigators to the location to see if there were any animals at the location at or around the time of John
Oh,
O'Keefe's
I like that
death.
question.
Sustained.
I like that question.
Do you believe it's important? Well, let me ask it a different way. Would following up with investigators be an important part of any forensic pathology investigation?
Yes.
No, absolutely. You're working as a team to figure out what happened to the body.
Yes.
We talked about the theme and theory of differential diagnosis, correct?
Yes.
How does engaging in the process of differential diagnosis...
Y'all, I can't help with if there's wolves running around in Massachusetts or not. I assume they're not going to get there, but what do I know? I've spent a week looking at everyone local to me talking about a zebra running around. So I don't know. When I thought I was being trolled for like 2 days about the zebra running around on 24. So I have no idea. There's plenty of you from Massachusetts in the chat though. Yes, a zebra.
avoid
Yes, a
bias
zebra.
in an
Yes, a zebra.
investigation?
By after you have your findings and you sit back and think, well, how many ways could I get this finding? And so bias sometimes means, oh, I think it's this, and then you just stop. So that's a sort of a bias where you make a decision too quickly and you don't then stop to consider what other things could cause this same finding. So you have to consider not only what immediately comes to mind, but then you think, how else could we get this pattern of injuries?
Did you engage in a differential diagnosis as it relates to this case?
Yes.
Did you consider whether the injuries could have been caused by a motor vehicle accident?
I did consider that.
Did you consider whether Mr. O'Keefe's right arm injuries specifically could have been caused by being hit by a motor vehicle?
Yes, I did think about that.
Were you able to rule that out?
Absolutely. Not.
So the objection sustained, jurors strike that answer.
What?
Tell me about, well, let me ask it this way. Did you
He
come
could
to
talk
an
about
opinion or
consistent or
conclusion as to whether or
inconsistent.
not Mr. O'Keefe's injuries as a whole were produced by a motor vehicle pedestrian incident?
Sustained.
You indicated that you've done thousands of autopsies yourself,
Yeah.
correct?
Yes,
And you've supervised many times more than that.
correct.
How many of those autopsies that you've performed or supervised have involved motor vehicle incidents?
Now, hundreds.
How many of those hundreds have involved motor vehicle pedestrian incidents?
Almost as many.
Have you performed autopsies specifically on individuals known to be hit by vehicles?
Yes,
Have you performed autopsies on individuals believed to be hit by vehicles?
yes.
Have you engaged in differential diagnosis and
I
inferential thinking?
can't believe
in
lack of
terms of
foundation is what
developing
we're talking
an
about
opinion
here.
or
We've
conclusion to a
thoroughly
medical
covered
certainty
foundation.
about whether or not
In fact,
the
yesterday,
injury
the court fucking complained about how much background and training and experience we went through. We have thoroughly covered this. This is not a foundation issue.
that you see on a decedent are consistent or inconsistent with a motor vehicle pedestrian incident.
Yes, that's part of what we figure out as a forensic pathologist.
Did you do that in this case?
Yes, I.
Sustained.
As
What
to
are some of
approach,
the injuries
I have
that you
no idea what the
expect
issue is.
generally
Emily, what is she
to
doing? I don't know.
exist if a pedestrian is hit by a motor vehicle at speed, not 1-2 miles an hour, let's say 20 plus miles an hour?
Yes, one of the things you see is a pedestrian is, standing upright and is impacted by this blunt object of a automobile or a van or a SUV. And what you see first most is the tissue is crushed where the projections of the vehicle impact the tissue. And when you crush the tissue, that gives you a bruise. So that's the first part of the pattern of impact. It crushes the tissue, it gives you a bruise because it breaks the blood vessels underneath the skin. And then depending on how much more force is applied, the skin can break.
Right.
So I'm going to strike that. Next question, Mr. Jackson.
Why?
In addition to bruising, what else might you
I'm
expect
itchy.
to find in an individual who's been struck by a vehicle at speed?
So let's come over to sidebar.
What in the world? They're going to sidebar. The witness is more than qualified to have these conversations unless this is outside of what the witness turned over, which may well be the issue. But we will see. We don't have the expert's report. We don't have what the expert was disclosed to discuss, but we had earlier today where the court said that the witness can talk about consistent versus inconsistent. But you will also have courts that will say no cumulative experts. And the injuries not being from a car accident are already from Dr. Russell. But that's not what the court said or what the court put on the record.
May I inquire?
Yes.
I forgot where I left off, so I'm just going to pick up.
That's
Okay.
fair enough.
As best my memory can serve me. It has been suggested that Mr. O'Keefe's right arm, doctor, was injured by contact with the right rear taillight of Miss Reed's 2021 Lexus LX570.
No, I'm allowing that in.
Thank you. As Mr. O'Keefe, it was struck as Mr. O'Keefe was standing and the Lexus backed into him. That was a postulate put forward. I want to find out from you, do you agree with that?
Well, that's something to think of.
So,
Oh, I'm sorry.
yes, I'm going to strike that question.
She's allowed to be asked about the Commonwealth's theory. The poor witness is like, I'm so sorry. Ma'am, it's not you.
Question and answer.
How did we get from no, I'll allow that to I'm striking that?
Let me ask it a different way. Let me ask you a different question. Do Mr. O'Keefe's pattern injuries on his right arm, do they correspond to injuries that could have been produced by irregular fractured plastic pieces impacting his arm?
No, not at all.
It was the word taillight, wasn't it? It was the word taillight. It was the word taillight, wasn't it? Because the court's order from yesterday was that the expert could testify about injury from pieces of plastic, but that she couldn't testify about what the taillight was made out of. That was yesterday. The issue was the word taillight. Is anyone fucking confused that the plastic that we're talking about is taillight? It's just so incredibly extemporaneous. The jury knows we're talking about a fucking taillight at this point. Why are we dancing around the difference between plastic versus taillight on day 30? The jury knows that the Commonwealth's theory is that the arm was injured by pieces of taillight. It's in evidence. Oh my God. It's just the witness is not opining about the chemical makeup of the taillight, But we all know it's a taillight. It's just dumb. I don't have other words for it. It's just dumb. Juries don't like it when they feel like things are being hidden from them. And Jackson has been known to, like salt and pepper, push it with his questions. That's not what's happening in this direct examination. Jackson is not overstepping. He's not gone full, like coming in on a wrecking ball. He has been incredibly mindful about asking these questions in the right way. And it's still like the goalpost is moving. It's just wild. The word taillights, I'm allowing it. And then, oh no, we're striking it. And then ask it a different way. It's just, Your Honor, why don't you just write the questions you want him to ask then? Why don't you just write it out? Just tell him how he's supposed to do his direct examination. At some point, you have to let the lawyers answer questions that are appropriate. These are appropriate questions. This is not too far. It's not too much. It's not outside of what her rulings are. Just let him ask the questions. I could see it if Jackson was absolutely just pushing the bounds, which we've seen him do. That's not what's happening. You want to just give him a list? Just give him a list then. The rephrasing of this question a million times is so stupid. It's just so stupid. Emily, why? I don't know why. It's just dumb.
On his right arm.
It's got to be the word taillight. I'm backing this whole section up. I'm so annoyed. I'm so annoyed. Michelle said, Emily, how do you really feel? And I'm so annoyed. And it's because it doesn't matter. It just doesn't, my throat is even pissed off. It just doesn't matter. The difference between the word plastic and taillight at this moment does not fucking matter. This doesn't matter. It matters to ask the question, but the difference between those two words does not matter for the jury. They know.
That was a postulate put forward. I want to find out from you.
I'm going to back up his full question and just let the whole interlude run.
It has been suggested that Mr. O'Keefe's right arm, Doctor, was injured by contact with the right rear taillight of
That's
Ms.
the
Reed's
issue.
2021 Lexus LX570.
No, I'm allowing that in.
Thank you. As Mr. O'Keefe, it was struck as Mr. O'Keefe was standing and the Lexus backed into him. That was a postulate put forward. I want to find out from you, do you agree with that?
Well, that's something to think about.
So,
Oh, I'm sorry.
yes, I'm going
It's
to
not
strike
her.
that question and answer.
Let me ask it a different way. Let me ask you a different question.
And for the lawyer to try to
Do Mr. O'Keefe's pattern injuries on his right
constantly
arm,
reset is
do they
dumb.
correspond to injuries that could have been produced by irregular fractured plastic pieces impacting his arm?
No, not at all.
Why do you say that?
First of all, those injuries are patterned injuries from an animal bite. We have the canines, we have the incisors.
All right, so I'm going to strike that, and let's see you at sidebar.
She turned over these opinions. The court said she was allowing these opinions in. The court said she was allowing her to say animal, not dog. The court said she was allowing it. Are we not allowing it now? Like, what has changed? She is allowed to testify within her expertise. She said animal. I'm going to back that up one more time. But she said animal bite. What did she say after that?
Say that.
First of all, those injuries are patterned injuries from an animal bite. We have the canines, we have the incisors.
All right, so
The teeth. The canines, the teeth. The canines, the teeth.
I'm going to strike
Because
that,
Chad is Bay.
and let's see you at sidebar.
The TVs. This is not a situation where they are trying to push things into evidence. I don't like it when lawyers do that. We have talked about it. Everyone is being exceedingly careful and within the rulings that have already been made by the court. And then even when they're within the rulings, the court is like, what? The amount of patience and skill it takes as a lawyer to not just give up at this point can't be understated. Newer lawyers would give up and just be like, well, fuck. That's not going to happen with any of the lawyers in this court. They're too experienced. But it is incredibly frustrating to have to then continue to argue things the court has already said were coming in yesterday and today. And you can't just tailor an expert so far that you can say exactly these 7 words. Those are the only words you can say. It's an expert opinion, and the expert's not trying to like jam extra stuff in there too. And we've seen experts do that. This expert's not trying to just cram in information. And the jury has to be like, why does this keep getting stricken? We've already heard it. This isn't new. The jury must be so annoyed. I'm so annoyed. He's been within the court. He's been within the rulings.
In your report, Doctor, you indicated that Mr. O'Keefe's patterned injuries on his right arm do not correspond to injuries that could have been produced by irregular fractured plastic pieces impacting his arm. Do you recall putting that in your report?
Yes, I wrote that.
Do you stand by that?
Yes, that's my conclusion.
And you also wrote his arm had no...
So now he's just leading because everybody's just said, okay, just read the report, it seems. So now he's just reading in the opinions from the report. So we've gotten all the way to, you can say these 3 words. It's just too controlled of a direct examination. The witness has been professional. The attorneys aren't pushing it. This is just so frustrating.
May I, Your Honor?
Yes.
In your report, Doctor, you indicated that Mr. O'Keefe's patterned injuries on his right arm do not correspond to injuries that could have been produced by irregular fractured plastic pieces impacting his arm. Do you recall putting that in your report?
Yes, I wrote that.
Do you stand by that?
Yes, that's my conclusion.
And you also wrote his arm had no tissue bruising from impact injury. Do you remember writing that?
Yes,
Do you stand by that?
I do.
You also wrote, neither did his skin show any array of irregular, unpredictable, randomly scattered cuts and scrapes at various angles and depths. Do you remember writing that?
I did.
And do you stand by that?
I do.
And again,
You
this
also
is not,
wrote that you know
he's now just reading in the opinions from the report because the court wants it said this certain way. But it's not the witness's fault.
Mr. O'Keefe had no bruising
just reading
on
it
his
in.
arms or torso. Is that right?
Correct.
And you also wrote, in particular, Mr. O'Keefe did not have bruises on his legs, correct?
Yes, correct.
And you indicated that that was shown by dissection of the leg tissue and muscle at autopsy. Is that right?
Yes, there was a special leg dissection done to look for bumper impacts.
You reviewed the entirety of the medical records associated with the autopsy,
Yes,
including photographs,
taken to the hospital, yes.
okay, and autopsy photographs,
Yes,
and other data and documentation, correct?
yes.
Are x-rays an important part of an autopsy generally?
Oh, yes, usually
I
there are
wonder if this is
x-rays
his last
taken
line of
of the
questioning.
body prior to the examination.
What do x-rays show? Why are those important?
They're important because they show foreign material in the body, like a bullet. They also image the skeleton, so we
testified about
can
this
look
yesterday.
for fractures of the bones.
I have no idea what that noise is in court. Literally none. I have no idea what the attorneys are doing. What are you doing to the microphone, Jackson? For fuck's sake. Oh. What? Do you see?
Isn't that fair?
Ah! Well, I don't know how my feed jumped. Hi, Andrea. I have no idea what happened. I was just trying to pause Jackson, and the entire feed just jumped over to another feed. It's like feedception. I have no idea how that happened. Streaming is dynamic. I have no idea what the feedception was about. Now I'm trying to back up to where Jackson was standing with all of the... There we go. At least it's an easy demarcation of noise. I literally have no idea what happened. But sure, okay. I mean, at least YouTube has good taste. I'm not mad about that. I've still got my volume turned down because Jackson is doing whatever in the world he's doing. With these. What I was trying to do is pause this so I could say the microphone, if you can see my little pointer, the microphone's right under there taped onto the lectern. There we go. A scroll of something. The dramatic slow pull is hilarious. I don't know what's happening. The dramatic,
approach.
Okay.
the dramatic slow pull. I don't know what these are. Are they enlarged x-rays? I don't know. Maybe they are. I thought there were no x-rays done. Who knows?
Yes.
Wait, no, what is it? And now the jurors are fascinated because they're going to sit here like me going,
Yes.
what is it? Okay, they're approaching. Okay, they're approaching for a minute. I wonder if the jury's going to take their morning break. And back to OnlyFan. Back to OnlyFan. All right, fan, hello. All right, back onto the record.
May be seated.
Dr. Laposata, you can step out, okay?
Well, the jury's obviously out. The doctor is stepping out. And now what?
All right, I did receive another motion this morning for a curative.
My assumption is that the jury is on morning break. Dr. Laposata is stepping out, and the judge is now going to talk to the lawyers about the curative instruction that we heard Alessi argue about from yesterday, because the curative instruction about the hoodie of John O'Keefe was not curative. It was minimal. So I'm not surprised there was another motion. It sounds like we're doing this at the break. This has been such an incredibly disjointed day of court.
Instruction. I'm not going to even consider this today. We can consider this at
What do you mean you're not even going to consider this today? It needs to be done close in time. Why are we not doing it close in time?
All right, I did receive another motion this morning for a curative instruction. I'm not going to even consider this today. We can consider this at the charge conference. So that's where we're at with that. All right, work it out. If you can't work it out, let me know. I'll come out before the jury.
All rise for the court, please.
Okay. So the jury went out, the doctor went out. I presume they're on morning break. The court said I've received a motion regarding, I don't even remember what she said because my brain has started buffering, the curative instruction regarding, I'm assuming, John O'Keefe's hoodie because that's what we know is coming. And the court said, I'm not doing this today. We can deal with it at the charge conference. The charge conference means the jury instruction conference when they talk about the jury instructions. And then the court told the attorneys to just work it out. That's not regarding the charge. That's likely regarding what they approached about in court, the big papers that Alan Jackson had when they went to sidebar. That's not going to be regarding the curative instruction. What an incredibly disjointed morning it's been to the morning break. Dr. Laposata's opinions came in through mostly Jackson reading in her report directly that the injuries to John O'Keefe's arm are not consistent with flying pieces of plastic, that they are linear abrasions, they are consistent with claws and teeth. We heard her testify to. Whether it was stricken or not, I can't even remember because there was so many starts and stops. That John O'Keefe died primarily and solely from the blunt force injury to the back of the head that caused the injury to the brain and the fractures to the skull, that hypothermia was not present, that the indicia of hypothermia was, in fact, in her opinion, caused by the Lucas resuscitative machine, that the injuries to the arm happened prior to death, not after death, based on the way that the injuries to the arm reacted, which we've heard from the other experts as well. And I think that's where we got towards the end of direct examination, I think, as we got to the morning break, and the court saying, I'm not addressing the curative instruction request now. So it looks like the morning break is actually fairly extended. We didn't hear the court say how long she was sending the jury out for, but the attorneys come back onto the record, and we're going to scroll through this together. The attorneys come back into court, and it looks like they are right up at sidebar before the jury comes all the way back in. So after the morning break...
Yes.
We're back in court. He is asking to retrieve back the giant scroll, and here we are.
Miss, we need that marked for identification.
I need all three of them marked for identification.
Okay, and we'll do that afterwards. Just please go ahead.
You see any x-rays?
I did.
What were the x-rays of?
The x-rays were taken of Mr. O'Keefe at the medical examiner's office when they were...
There were x-rays of John O'Keefe.
X-rays of his chest, his arms, and his legs.
Did you specifically review x-rays of his right appendage? Hand, forearm, arm?
Yes, they were included in the x-rays.
Have you seen x-rays before?
Oh, many times.
How many times?
Thousands, probably.
Is part of your job to review x-rays
Oh,
to make
absolutely.
a determination of whether or not they indicate broken bones, fractures, hairline fractures, things of that nature?
Yes, it's part of the medical legal autopsy to study the x-rays of the deceased.
why did the Commonwealth's witness then, Welcher, say that there were no x-rays? So we can't know if there were breaks to the small bones in the hand or the wrist or the arms. We can't tell if there were small fractures. I mean, there weren't any compounded fractures. There was no bone sticking out of the skin. That we know. But Welcher went on and on and on about the fact that, well, we don't know. There are no x-rays. They didn't take any x-rays. The fuck? Here they are. The x-rays. Well, you know, I had been really kind of pressed about Welcher testifying again because it was exhausting. But now I am so curious. So how did Welcher not see the x-rays?
That's done in the ordinary course of being a forensic pathologist, is that right?
Yes,
Are you trained on how to read x-rays?
yes,
You have to be a radiologist to read an x-ray as a medical doctor?
no,
Medical doctors do that all the time, correct?
yes, it's part of general medical training.
And is it also part of specialized training for forensic pathologists?
It falls under the rubric of general radiology that a doctor knows. There are some specialized areas in forensic where you have to understand like decompositional changes that you can see on an x-ray that aren't something that you would see in a clinical
Well, then these must have
setting.
been part of the coroner file.
Taking the appendage one item at a time, did you look at Mr. O'Keefe's x-rays of Mr. O'Keefe's right hand?
Yes.
Did you see any defect in the bones of the right hand?
No bony defects, and the tissue was normal.
Did you take a look at the x-ray of Mr. O'Keefe's right arm?
Yes.
Did you notice any defects at all in the bones in the right arm?
No, the bones in the right arm were intact.
No breaks,
Correct, no breaks.
fractures, hairline fractures?
No,
Did you look at the upper arm x-ray, Mr. O'Keefe?
yes.
Did you note any defects in the bony structure of Mr. O'Keefe's upper arm?
No, the bones were 100% intact.
No breaks,
I mean-
fractures, hairline fractures?
Correct, none of those.
I'm not surprised that those are the results from the x-ray based on everything that we know. I'm surprised that all of a sudden there's x-rays when the other expert said that there's no x-rays, because the prosecution would have turned these over to the defense. So how did we get all the way through Brennan and his witnesses saying there's no x-rays? Okay.
Is there any indication in your mind, based on your review of those three x-rays, the hand, forearm, the arm, that arm had suffered any kind of bone
Well-
trauma at all?
Sustained.
Oh,
Was there any indication?
Antoinette, the Commonwealth expert Welcher is coming back for rebuttal anyway. Coming back from rebuttal anyway. So no, it's not that it opens the door for them to be recalled. It's that they're still on rebuttal, but we still have to get into Dr. Rentschler, and Dr. Rentschler is the biomedical engineer. So this lays the groundwork for Dr. Rentschler to testify. Welcher was the biomechanical engineer for the Commonwealth, and he was allowed to talk about the injuries to the arm and the rest of it. But he said there were no x-rays, so we can't know. We can't know if there's small breaks or small fractures to the arm, the wrist, the hand, because there's no x-rays. That testimony is fucking locked and loaded. On and on and on. He's like, they should take x-rays. Did the Commonwealth not give the x-rays to Welcher then? Because he said he reviewed the entire ME file. I have so many fucking questions. But this is great foundation for Rentschler.
Based on your review and your expert opinion, that his arm had been broken, fractured.
No, the bones were intact. No breakage, no fractures.
Thank you.
That's the end of direct.
examination.
That shouldn't feel like a mic drop. The fact that there's x-rays shouldn't feel like a mic drop. There should have been x-rays. The fact that it feels like a mic drop just illustrates how wild the evidence has come in this case. No fractures, no breaks, no defects.
Good afternoon, Dr. Laposata.
The bones were intact.
6 minutes till the afternoon.
Ma'am.
Good afternoon, Dr. Laposata.
I had to rewind.
6 minutes till the afternoon. Good afternoon.
That's okay.
What do you mean that's okay? Sir, you can't even just say, you're absolutely right. Good morning. She gave you an opportunity to actually have a very human moment. And even then you're just like, come on. It's funny. You smiled. Good Lord.
You wrote a report in this case, doctor?
Yes, I did.
Do you think that based on your analysis, was Mr. O'Keefe thrust backwards? Is that what you determined looking at his head injury?
That he was, I didn't understand you had your hand in front of your
Sure,
mouth.
I'm sorry.
Yeah.
She is so done. Oh, sir, she's just going to clock you up one side and down the other. Sir, you had your hand in front of your mouth. Couldn't hear you. Damn. See, the thing is, when Dr. Welcher was giving it back to Alessi, he came off like a total dick. When she was giving it to him, she's just like, but sir, can't you just speak to me clearly? That's funny.
You talked about a head injury that Mr. O'Keefe had.
That's
that he
funny.
suffered from.
Yes.
That caused his death.
Yes.
Was that caused by being thrust backwards?
Yeah, the motion was upwards, down.
Okay. And the way you just showed it could be a fall.
Correct.
Did you have an opinion looking at his wound that he was thrust backwards?
You asked that.
What do you mean thrust? His body went backwards. There may have been some applied force to it.
I don't know about thrust. I'm asking if you have an opinion. Your words. Do you have an
Your
opinion?
words. You said thrust 3 times. Not her words. Your words.
About thrust?
What do you mean thrust?
Unless it's in her report somewhere.
Did the forensic pathology diagnosis mean Mr. O'Keefe's body was thrust backward?
If you want to say thrust as indicating movement, that it went backwards, then you could say it was thrust.
May I approach?
Yes.
I'm showing you page
Stuck in a
2 of your
thrust
report,
loop at the
Dr.
moment.
Laposata.
Yes.
I'm just going to ask you to read it, not out loud, and then I can ask you the question. I appreciate it, but I want to
Yes.
take a look.
Yes.
Are you familiar with that?
No, absolutely.
So, Dr. Laposata, what did you mean when you described that Mr. O'Keefe's body was thrust backward from a standing position?
I mean that he was standing upright and his body had momentum and went down and hit at the back of his head. So when it was thrust backwards.
You cannot tell forensically.
So it is in her report. All right, Brennan, I apologize. It is her words. Absolutely apologize. Her words, which is exactly why the Commonwealth is picking up on them, because their expert said this is common from a just standing fall backwards. If her report says thrust backwards, of course they're going to seize on that as that there is some level of force. So if it's her word, it's more than just a fall backwards. It indicates some kind of force connecting with the body. Now, I imagine when he asks her what those things could be, we're going to get back into it. But I made a mistake. It is in her report. To be fair, I don't have her report to review, so there is that.
See how much momentum he had, can you?
No, we don't do those analysis.
If you can't tell if anything caused that momentum based on the head injury, can you?
What do you mean causative?
It doesn't necessitate it.
His body went backwards.
Yes. And so the amount of force causing him to go backwards, that's not something you can determine from the head wound, is it?
No, I can't tell you the amount of force. It was significant because he had the massive skull fractures.
Did you say it would be significant?
Yes, significant force.
So what he's getting to is it going to be more force
In
than just
modern medicine, there are a number.
a standing fall? The problem Brennan has is that his expert and Welcher both said a standing fall was sufficient force, that there doesn't need to be more force than just standing up and going backward. Both of their experts said that. Both of them said you don't need the additional force from a car, a shove, a push, a dog jumping on you, any of it. Standing and falling backwards is enough force, according to the Commonwealth's experts. So is he trying to undermine what his experts said by saying that there needed to be more force, like force from the vehicle? Is he trying to undermine his experts?
Number of different machines that can help us see the brain, like a CAT scan, perhaps?
Sure.
MRIs?
Yes.
Would you agree with modern medicine that the use of MRIs and CAT scans and other tools give a clinician equal, if not better, opportunity to examine the brain as actually cutting it and holding it in your hand?
No, the actual gold standard is the pathology, to be able to have the brain in your hand, look at it with your naked eye. And we have conferences in the hospital where we meet with radiologists and say what we find at autopsy and see if their radiology was correct.
Can CAT scans and MRIs show contusions on the brain?
They might.
Subdermal hemorrhages?
Subdural hemorrhages. Yes, they can.
Herniations?
No, I just want him to say incisors to her, because she's going to correct everything he says. And we know how much that can be. Everything he pronounces wrong is going to get clocked by this witness.
MRIs show contusions on the brain?
I backed up. I wanted to see it
they
again.
might.
Subdermal hemorrhages?
Subdural hemorrhages. Yes, they can.
Herniations?
They can.
Do you have any doubt about the modern medicine and the use of MRIs and CAT scans? Do you
Also, subdermal and subdural are actually a significant difference when they're talking about brain scans. So
they're inadequate in any way?
Well, I'm not a clinician, so I don't use those to diagnose diseases in living patients.
Dr. Laposata, have you ever had any experience studying the brain in real time, clinically?
I mean, she does it in real time all the time. Are you mean when the brain's
opening
alive?
somebody's skull and treating the injury before the person dies?
Oh, he's trying to
No,
differentiate
I'm not a
her. and-
neurosurgeon.
You don't have any neurological...
No, sir. I'm not a neurosurgeon. I mean, I was the chief medical examiner for the entire state of Rhode Island. No big deal. But I'm not a neurosurgeon, sir. That was fucking funny.
Logical expertise, do you?
I'm not a neurologist. I'm not a neurosurgeon. I'm a forensic pathologist.
Do you have any clinical experience at all where there's an acute head injury and you're making an effort to observe it and analyze the injury as it progresses in an attempt to save the person's life?
I don't treat or diagnose living patients.
Right.
I understand, but as far as your background, have
You don't
ever
understand
had any experience?
if you're asking that.
Clinical experience showing the progress of an actual brain injury and trying to treat it?
I understand the physiology of what happens to the brain when it is impacted by something, whether it be a bullet, a boulder, a fall. So I know what happens to the body to cause the changes from that trauma. I don't treat people for those injuries.
Right, you don't want to take their brains out when they're still alive. That's
Observing a brain that's in
not
trauma
conducive.
and making determinations of how long it's viable or whether the person will expire. Do you know the process that a neurosurgeon would go through in order to fight to preserve the person or save the person? Do you know the step-by-step process that they would undertake?
To do what?
To try to
Save their life.
operate or save somebody from a
no,
head
that's not what
injury,
she
from a
does. She
brain
just said that.
injury.
I'm going to allow it because of prior testimony.
Well, it depends on what the brain injury is. If you have head injury and you have bleeding on the brain that's pushing the brain one way or the other, it would be a subdural. Then a neurosurgeon would come in and try to take
Aspirate
that
it.
blood away so it doesn't compress the brain. So that's something that neurosurgeons do to treat head trauma. They can also put in drains into the ventricle of the brain, and that can relieve pressure in the brain because that brain swelling is a bad thing. So those are some of the things neurosurgeons do.
They can take off part of your skull to allow more room.
Brain injuries.
And can they remove part of the skull to relieve pressure?
Oh, yes, they can do that. It's called a craniotomy. They can take out part of the skull if they need to.
So there are a number of different steps that a neurosurgeon can take when someone suffers acute brain trauma to try to save the person, isn't there?
Well, the job of any doctor is to try to save a human life if you treat living.
Not you, ma'am. The job of some doctors. You are not in that category of doctors. You are not treating to save. You are treating to answer questions.
Patients. So
Not
certainly
treating, diagnosing.
a neurosurgeon would evaluate the patient and decide if there's any treatment needed that could improve the patient.
When you've had cases in the past as a medical examiner where there have been issues regarding brain injury, wouldn't you agree that you have sought outside consultation with people who have a higher degree of specialty in brain injury than you?
At times, I'm sure.
Sometimes what we do is when we're examining the brain, we can call in for a conference and have a neuropathologist come in and review the brain with us.
And back when you were a medical
Hey, Brennan, like the neuropathologist, y'all didn't call like that one?
examiner, you did that on a number of occasions, didn't you?
Yes, that's routine.
The reason why is because there are different specialties in medicine, and some are different and separate than your specialty, correct?
Of course.
In a neurosurgeon or a brain surgeon, it would be a different specialty than yours.
Yes.
And they're focused on the brain, yes?
A neurosurgeon does brain surgery.
On cross, what's the over-under on Jackson asking, did you review a report from a neuropathologist in this case?
And so,
I'm saying,
how many
I'm saying
times
we're
in
at like a
your career do you
98%
think that
chance. He
you've
asks it.
assisted the help of neurosurgeons to take a look at brain study to help you?
I've never needed to speak with a neurosurgeon to look at a brain. Sometimes we call in neuropathologists and we have a forensic neuropathology conference where we look at brains with the interns and residents.
How often would you call a neuropathologist?
Maybe once a month we would have a routine conference.
And again, the neuropathologist that's dealing with a person's brain.
When she's saying that there's a routine conference, my interpretation of that is that they send all their cases out to neuropath and then they take a day to do, or a half day to do case review and go through all the different cases. So it's not that they're consulting one case a month. It's that every case that they send out gets brought up at conference once a month. That's how I interpret that. I don't know if it matters for this case, but I would imagine they probably have more than one
After they're already died.
case.
Correct.
So it's not a clinical setting or a clinical experience of actually watching the brain at work and seeing the injury as it progresses.
They're dead,
We
Brennan.
don't do neuropathology like that on living people. The person is deceased.
You had an opinion to the jury today, and you said that you believe that Mr. O'Keefe died within 15 minutes.
If they're not dead, she is not coming across the witness, the patients. They're not. They shouldn't be at the morgue if they're alive. That would be very bad. It's part of why the warm and dead thing needs to. She's the ME. She's the ME. She is the ME.
Yes, I think that process would start within 15 or 20 minutes.
Is that to a reasonable degree of medical certainty, that opinion?
Yes, based on the severity of the
This is
injury
the
and the brain
process of
swelling.
death. He's going to ask her about the cold.
You're aware that there are numerous level 1 trauma centers around the country that deal with brain injury, right?
Sure.
And the idea is that people suffer all types of brain injury, and if they are
Brennan's
given
getting
medical
at
attention
if
in a
this was
reasonable amount of
survivable.
time, there's a chance they can be saved. Yes?
Well, it's possible, but many are so severe that they cause death no matter how fast they can get medical attention.
In fact, every day when people get the right attention or proper attention, they're brought to level 1 trauma centers around this country to try to help them or save them. Isn't that fair to say?
I would hope so.
Do you think?
Sure.
When you looked at Mr. O'Keefe's brain, obviously it's after he already expired, correct?
It's after it was
Obviously,
in
yes.
And so you didn't
formaldehyde.
have any clinical observation
No one did.
of the progress of his injury that night, did you?
I was not observing him. I did not observe how he got his injury.
No one did.
When you gave an estimate or you give an opinion about how long he was alive
And when I
for,
say no one did,
are
I'm
you
saying no one observed the progression of his injury based on the testimony in this case.
aware that there's certain tests that are done by neurosurgeons when people are suffering brain injuries, but there's an attempt to save them?
He's not trying to undermine her. He's trying to get back to the timing from Dr. Wolf, hungry like the, not Dimples. So he's trying to get back to Dr. Wolf, giving a larger amount of time. And I think he will argue this as to count 2 and count 3.
Sure.
Have you ever heard of a Guzman coma score?
So not undermining her.
Glasgow, you mean?
No, but it's Glasgow, but you've heard of Guzman?
It's called Glasgow Coma Score.
Have you ever seen...
She's not letting him get away with anything, but he is trying to support his witness's testimony.
Sure.
Have you ever heard of a Guzman coma score?
Glasgow, you mean?
No, but it's Glasgow, but you've heard of Guzman?
It's called Glasgow Coma Score.
Have you ever seen the assessment that a level 1 trauma center goes through when they're trying to save somebody with a brain injury?
I'm generally familiar with the emergency procedures to save somebody's life.
Have you ever read any statistical studies attempting to correlate the brain injury with the time somebody would live for?
I'm aware of that, and I see that in my practice of people who have survived brain injuries and die of something else. Then I can look at the brain and understand how the brain can heal or react to injuries.
And many people who suffer coup conquer coup will go into a brain surgeon center, and many of them
brain
pass after
surgeon
time,
center?
don't they?
Now, every
Level
case
1
is
trauma center?
different.
Right. Some might live for an hour, hours, weeks, months, or survive the injury. Isn't that fair to say?
It depends on the case.
In this case, you don't have any objective criteria
Brennan.
to identify
so
the
over
amount
it.
of time Mr. O'Keefe would have lived if he had the appropriate
The
help.
Guzma
Isn't
was
that
the
fair to
last
say?
straw for her.
I don't think it would have been effective because there were massive skull fractures to the base of the skull, and there are cases where the amount of force and energy applied to the head causing skull fractures, breaking the neurons, causing the brain swelling. Despite rapid medical treatment, those people cannot be saved. They can't effectively stop the brain swelling.
Many people can't be saved. Did you know that about 1/3 of them do get saved?
I don't know what you're talking about. 1/3 of everybody has different sorts of injuries. 1/3 of what?
With a clivus fracture, coup contre coup. Are you aware that 1/3 of those patients survive if they get the proper treatment?
It depends on the amount of force.
Okay. Are you aware that a study would show? Have you ever read
What
a study
study?
by Isaac Wolf on clivus fractures?
No.
Have you read any studies on clivus fractures?
Clivus fractures? Yes, I understand what clivus fractures are. It's a part of the base of the skull.
Okay.
And
And
it
have
Wait.
depends-
you?
Oops.
Damn it.
Okay, go ahead.
We're going to get back to occiput boner, aren't we? Oh, at some point we're going to get back to occiput boner, aren't we? And my skull's not even in my office today. Darn it.
Did you want to?
No,
say?
you go ahead.
Oh, I'm sorry. Have you read any studies that tell you, with the proper treatment, despite these potentially catastrophic injuries, that 1/3 of patients can survive?
No, but that's not the case we have here.
And so, in this case, I asked if you had any objective criteria.
She's like, no, because the case we have here is me reviewing an autopsy. So
Yeah. You don't have any objective criteria about the progress of Mr. O'Keefe's wound that can be a basis for you to conclude that he would have died in 15 minutes. Isn't that fair to say?
that's a fair
No,
question.
I understand what happens to the brain when it gets that sort of injury. I understand the time course and the physiology. I've seen hundreds of individuals who've had brain injuries. Some survive for a longer period, some die earlier, and it depends on the amount of force and the amount of brain swelling. And in Mr. O'Keefe's case, we had the massive skull fractures of the base of the brain and immediate swelling and subarachnoid and subdural. So he had a large force applied to his head, which caused the brain swelling and the and the progression of the brain stem down through the foramen magnum that stopped the brain. It was a very forceful impact.
You examined his brain after you looked at photographs. You can't tell us objectively when his brain swell started.
It started immediately after impact.
And you can tell us what the progress of that brain swell was by looking at his postmortem photos.
By looking at the postmortem photos and the postmortem examination, I can tell the degree of force from the extensive skull fractures that were present.
What was the degree of force?
It was medium to large.
Well, that's a wide range. What do you mean? Quantify medium
So I'll
to
strike
large,
the comment.
please.
Ask the question, Mr. Brennan.
What does medium to large mean?
Enough to cause a lot of fractures to the skull. He didn't just sit down and lie down.
If he sat down and lied down,
Right.
he probably wouldn't have
Died.
fractured his skull, correct?
That's obvious, yes.
Right. And so when you're telling us you can identify that he immediately died or died within 15 minutes,
She didn't
I'm
say
asking
immediately
you for
died.
objective criteria. For you to give that opinion, I'm asking you what objective information you have. And so you said that there was
She's not going
a
to
large amount of
answer
force, correct?
biomedical engineering questions, Brennan.
Sure, but because there were massive skull fractures, and
And-
there's a lot
Right.
of energy transmitted to the brain, starts swelling immediately
How do you know this wasn't medium force and not large force?
because of the extensive number of skull fractures.
So are you saying it was medium or large force?
Medium to large.
Okay. How much force is that? Can you quantify it?
No.
What other objective criteria do you have?
All I've heard her say over and over again is extensive fractures to the skull, extensive fractures to the skull, extensive fractures to the skull. Okay. Yes, there are extensive fractures to the skull.
To support
Right.
your opinion that Mr. O'Keefe died within 15 minutes.
My training and experience of seeing thousands of deceased people from head injuries and knowing some of their clinical course when they get immediate medical treatment, they don't survive.
But you would agree many do.
Depends on the case.
And in this case, you didn't have any opportunity to observe the progress of Mr. O'Keefe's injury that night, correct?
Correct.
I'm going to allow.
Asked and answered.
I wasn't there.
You had-
The body told me what happened to it.
You have no assessment of the development of his brain injury and how much time it took that night, do you?
I do, from understanding the significant skull fractures.
Well, now
and
the body
swelling
told
of
me
the
what happened to
brain
it.
And the compression of the brainstem, that all happened very rapidly because of the amount of force that caused all those skull fractures on the base of the skull that actually then hemorrhaged into his upper eyelids. That's a large amount of force.
Was gross edema found on his brain?
I think it was swollen, yes.
But was that a finding?
Yes.
Where did you see that finding?
Well, in order to have the herniation of the brainstem, the brain swells.
That's not what he
Where
asked.
did you see that finding?
I can't answer that. I just know it from understanding, looking at the pathology.
So at the end result, at some point, Mr. O'Keefe had gross edema.
In order to get the brain stem hemorrhages, the only way you get that is because the brain has swelled, and there's no,
Right.
after injury, tissue swells, and there's no place for the brain to go when it swells except down into the natural hole in the bottom of the skull where the spinal cord goes down. So that's where the pressure goes. So that seeing
The
the
damage to the
brainstem
spinal cord
herniation
means
tells you
it
that
exists.
the brain
Right.
has swollen a lot.
Undoubtedly, but it doesn't tell you when it began to swell or the progress of that swell, does it?
I don't know what you mean.
You see inevitably because of the swelling, there's the suffocation, but when you see that, you don't know when the swelling began or how quickly it progressed. You can't tell that from an autopsy.
Yes, you can, because of the severity of the skull fractures. I know there was a lot of force, and that force applied causes you to go unconscious, then your brain swells. If there was just like one skull fracture,
I don't know.
then that
I was trying to get a better pause. I don't know why Hank doesn't just go the other direction with this cross-examination. I don't understand why he's fighting with her over the 15-minute window. Leave it after 2 questions and then argue Dr. Wolf knows brain progression of injuries better because he observes brains and injury progression all the time. Fine. Leave it alone. I don't understand why he's not leaning into her saying that there's a substantial amount of force. More force than just falling backwards? Isn't your theory, Hank, that he was hit by a car? Doesn't that help your theory? Why aren't you asking her more about that? Why are you still going through the checklist of 15 minutes, 15 minutes, 15 minutes? Ask her. Substantial amount of force. Okay. Like a car? Isn't that what you're trying to prove? Why aren't you just asking her that? Don't discredit her. The jury's going to like her. I don't understand. She keeps saying substantial amount of force. She's actually given more to him on that than his experts did. But no, he's going to fight with her over 15 minutes.
that's a little bit different, but this
Okay.
was massive skull fractures on the base of the skull. So there's a lot of force applied. So I know because there's a lot of force applied to cause the skull fractures that the brain would swell rapidly.
You would be unable to identify the rapidity of the swelling if you don't know the amount of force. Isn't that fair to say?
Well, I do know the amount of force because of the amount of skull fractures.
In what you know is, in your words, medium to large force.
Yes.
You've heard of periorbital ecchymosis,
Yes.
and that's sometimes called raccoon eyes.
Well, periorbital ecchymosis just means bleeding and bruising around the eyes.
And you saw the bruising around Mr. O'Keefe's eyes, didn't you, in the photographs?
Well, it wasn't bruising caused by blunt force trauma to the eye. It was bleeding in the upper eyelid because the plates above the eye and the base of the skull were fractured by the skull, by the brain hitting it.
It's
So,
different.
and that's a result of basilar skull fractures and not the application of force directly to the eye.
Would you agree it takes a few hours for the bleeding to accumulate in the person's eyes?
No, as soon as you break the skull bones and the heart's pumping, the blood comes out of those injuries. And it starts to accumulate right away. It starts within minutes, you can see it.
So you would disagree?
So the heart would still be pumping to get that result, because Dr. Wolf said that that could take days, I think. He said hours to days. She's saying that would happen much faster because of the fractures. That's a very different timing.
With the suggestion that it takes at least 1 to 2 hours for that bleeding to occur in the eyes. You disagree with that?
I do disagree with that. It starts immediately.
Do you have any studies that you've relied on or literature or support for that?
I understand the physiology of what happens when you get those skull fractures and the density of the blood vessels. And if your heart is pumping, you pump the blood out those broken blood vessels into this small area above the eye. And
Brennan, that's the point you want to make too, that his heart is still beating. Why are you fighting with her when there are things you can use in this cross? So to cause that, how long would the heart still be beating for? I do not understand this strategy at all with this witness.
it can happen within minutes.
Do you have any studies or literature to support that?
That's my training experience. I can't cite you a particular article at this time. I could certainly go look it up and bring it to you.
Okay. Let me ask you questions about the wounds to the back of Mr. O'Keefe's
I mean, the
head.
jury can see
Yes.
that it happened.
You see a linear abrasion?
Yes, vertical lines, yes.
Now, would you characterize this as a classic wound caused by falling backwards and landing on your head?
What do you mean, every wound is different.
Every wound is different?
Sure, every person's different,
Well, if every wound is different, then there's no pattern recognition to wounds looking the same if every wound is different. And I saw a number of you asking about a punch to the eye. The bruising, the darkness to John O'Keefe's eyelids is not from a punch. It's from the skull breaks and the damage to the brain. That, from those breaks, that's actually pretty classic symptoms of that. It's not the type of black eye you get from a punch or injury to the eye like that. It's from exactly what she described, from the breaks of the bones behind the eyes. But again, if everything is different, then there's no pattern. He's now asking about pattern recognition, and she's fighting with him on that. Ugh, this cross is just going to go all over the place, isn't it?
way you get injured is different.
And so if somebody falls backward on their head and suffers the basal fracture, the wound from your perspective can look different.
It depends on the impacting surface.
Fair.
Wounds on the same surface, say two people fell on the same surface, could they have different wounds on the back of the head if they suffered the same injury?
In theory, if they fell, if they rotated their body, if you could reproduce something exactly, then you would see the same wound patterns.
This wound pattern is typical of falling backwards on a hard surface, isn't it?
We know it's from falling backwards and striking something hard.
Can the frozen ground be hard?
A frozen ground can be hard, but it doesn't fit the pattern in this injury.
We'll get to that,
That's
but
not what
it's
he
not
asked.
hard enough to cause a basal fracture.
It can cause a skull fracture.
The frozen ground is different than a sheet of ice, right? It's not smooth and flat like a sheet of ice, is it?
Well, ice
It
isn't
could
exactly
be, I guess.
smooth either.
You mentioned there's some granular patterns in this wound.
Yes.
didn't you?
Yes.
The area in front of 34 Fairview, the frozen ground, do you know if there was any impediments in the lawn that was frozen?
In the what? Oh, the lawn?
Yeah. Yeah, sorry.
Yes, I saw the scene photographs
Mm-hmm.
of when the snow was removed, and it was like winter lawn grass, so it was some green, some brown that was pushed down, and like straw that was going different directions, which wouldn't give you that pattern.
Did you see the exact area where Mr. O'Keefe last moved?
I saw that general area, and there were a lot of photographs, yes.
You say general area. Can you tell us that you saw
Ma'am, did you see any photographs of exactly where John O'Keefe was found that nobody took? Really?
photographs of the spot where Mr. O'Keefe was lying when he was found?
Yes, that general area.
Could you see the ground where his head was? Can you identify that?
Yes, with the scene investigation, they shoveled the snow off of that area.
And you had never had a chance to go out to that scene yourself, did you?
No, I just looked at all the photographs.
You cannot see what's under the grass and the dirt, can you?
Well, dirt's under the grass.
Well, do you know if there's any rocks or impediments or bumps?
What?
It was a smooth surface covered with grass.
It was a smooth surface? The front lawn was a smooth
It was
surface?
a flat surface
Flat.
covered with grass.
Okay, and do you know what was under the grass, whether there was any pebbles, rocks, debris?
I didn't see any.
From the photo.
Correct.
But you don't have any firsthand knowledge that exact area where he ended, what the turf was like, do you?
I saw photographs of that lawn where they removed his body from.
So you're relying solely on the photographs, is that fair to say?
Correct.
Do you know if Mr. O'Keefe was wearing anything that could
The
cause
hat.
abrasions when he landed to cause that scraping pattern in addition to the linear abrasion?
He did have a baseball hat on, but that would not cause the pattern.
The area of the abrasions, is that in the area of the level of where a baseball hat would be on the back of somebody's head?
It could be.
If somebody hits the ground and falls backwards, can they slide?
If they're on an incline,
What if they're thrust?
well, if you fall backwards and you fall backwards on an incline, your body might move.
Well, what if you fall backwards on flat ground? Does the body, can it move after it falls?
Not really, maybe a little. If from the momentum of the impact, it might move slightly, but not really.
So when a person falls backwards and lands, you don't think their head has any room for movement?
Not significant.
Well, not significantly, maybe just a quarter inch, half inch.
No, it's possible.
And did you see the scrapes around the wound?
It's a
of
good
Mr.
question
O'Keefe's
about the
head?
hat.
Of course I saw them, yes.
And they're all within, what, about an inch?
What are you describing? What part? Are you describing the tearing, the laceration of the scalp, or the vertical abrasions?
The vertical abrasions,
There were maybe an inch, inch and a half.
inch and a half? Do you think that if someone fell backwards and landed on their head, they could move an inch and a half?
Well, he landed on something that had a ridge on it to cause the laceration in the scalp, and then with a little bit of movement, those vertical scratches were caused by some kind of like pebbly-like surface.
You mentioned that the orbital bones were broken and you had opined that it was caused by the brain. Do you agree that a brain is very soft, consistent with, for example, tofu?
Oh, gross. What do you mean?
What? I'm backing that up. What? A few of you have asked, they never found the hat. They did find the hat. The hat was in the yard when they were shoveling. But they did not grab the hat when first responders were there. That's funny.
Do you agree that a brain is very soft, consistent with, for example, tofu?
Oh, gross. What do you mean? It is soft.
Is it that soft? Is that the texture of
Well,
it?
it depends on what kind of tofu you have.
Okay. Do you think that the orbital could have broken when the break on the back of the head split the skull and then would cause the orbital break instead of the brain?
What?
The orbital plate fractures, if you look at the base of the skull after you take the brain out, you can see the fractures go up from the back to the front into the orbital plate. Sometimes when you fall backwards, the brain can also slap those orbital plates and cause some damage, but I could trace the fractures from
the
the
back.
point of impact along the base of the skull to the part of the skull over the eyes.
Do you think the base of the skull
So
break,
it
when it
broke.
separates, could have caused those orbital fractures?
That's what she said. No, not the break
I don't
caused each other.
understand
The
your
force
question.
to the back of the head caused all the
When
breaks, is what
Mr.
she
O'Keefe
said.
incurred that head injury,
Yes.
the basal fracture, do you think that the pressure, the damage from that basal fracture, the separation, could have caused the orbital breaks in his eyes?
Well, the fracture of the plates above the eye, when the blood is still pumping, there's a space there where the blood can come down into the upper eyelid.
That's not what he asked.
So you described the brain as causing that break. I'm asking you, could it have been from the basal fracture, from the skull fracture?
Yes, the fracture that was caused by the impact to the back of the head,
Radiated.
radiating to
Right.
the front of the base of the skull.
So when you told us on direct it was from the brain that caused
said
those
it-
fractures, was that just a summary?
Not what she said.
Or was that to a reasonable degree of medical certainty?
Well, sometimes the
Can
brain can
happen.
also, in a fall, flap and hit those. But in this case, I could also see that the skull fracture started at the back and came to the front. But it could also be contributed to by the brain hitting those delicate bones.
I guess my question is, when you've provided the opinions generally of what you believe and what you've seen, are these general opinions or are they actually specific opinions based on the facts of this case?
What?
They are opinions based on my examination of this case, but all that's based on my 40 years of training and experience.
But when you told us about the brain causing those orbital fractures, you would agree with me, at least now anyways, that it very likely could have been the basal fracture that caused those breaks.
Yeah, both.
It could have been both?
Sure,
Okay, could it have been just the basal fracture?
that's possible.
When you offered the opinion to a reasonable degree of medical certainty, had you considered the basal fracture as the source of those breaks?
Of course.
Is there a reason you didn't share that with us and you just said it was the brain?
That's not what she said.
I had no
To my
reason
memory.
not to share it.
Okay. Was there any depressed fracture to Mr. O'Keefe's skull?
No.
Can you tell us a little bit?
That's a good question, too.
About a depressed fracture. Depressed fracture is different than what we saw with Mr. O'Keefe, isn't it?
A depressed fracture is when something fractures the skull and then pushes the skull and moves the skull inward. This just had a fracture, but it didn't move the skull inward.
And you've seen depressed fractures in your practice over 40 years, did you say?
Of course.
In those 40 years, depressed fractures can happen from sharp objects,
Sure.
pointed objects.
Sure.
Flat
Someone
objects.
hit a person in the back of the head with enough force, with like a hammer, for example. That could leave a depressed skull fracture, couldn't it?
Certainly, you can hit somebody
or
on
a
the head
pipe
with a
or a
hammer
brick
and
or
cause
a-
the fracture, and then the continued force will move that fracture into the brain.
There was no depressed skull fracture in this case, was there?
Correct.
Right.
You gave some opinions today about you gave some opinions about wounds on Mr. O'Keefe's arm. I'd like to talk to you a little bit about that.
Sure.
Could we have that photo brought up, please? Do you see all of those superficial abrasions?
Yes, I see patterned injuries.
Right. Would you agree that they're superficial abrasions?
Yes, they go along the skin surface.
How many punctures would you identify in that photograph?
Let's see, there may be some punctures like around the elbow, consistent with the teeth puncturing. Most of them are the teeth scraping along the skin.
I'm not going to ask you what you believe the cause was. I'm going to ask you just about the wound.
Well, she said teeth scraping against the skin.
How many punctures do you see?
Well, this doesn't show, there are other photographs which show more of them, but there's the little dot-like areas, you could call an area of skin puncture.
Can you tell us from this photograph how many punctures you would say are in that photo?
I didn't count them.
Well, did you suggest that there was more than one puncture on that wound?
I think I see more than one, yes.
Pardon me?
I see more than one on there.
Okay, could you give us a count of how many punctures you see?
Well, without looking at all the photos, I couldn't give you a correct number.
Okay. You've written a report, haven't you?
I what?
You wrote a report,
I did.
and in your report, you described many of those abrasions as punctures, don't you?
Yes.
And a puncture isn't just a scratch. A puncture is a penetration of the skin, isn't it?
Yeah, a point-like penetration.
A puncture has a very
None of those were
specific
penetrating.
medical meaning, doesn't it?
Yes, it's a point-like
Yeah, none of those were-
penetration of the skin.
None of those are
And
penetrating.
according to you, there are many punctures in that wound.
Yes, I can see 1, 2, 3, 4, 6 or 7.
Can medical professionals disagree on opinions about wounds and causes?
I suppose they can.
You also gave some opinions that you did not believe that Mr. O'Keefe's scratches were caused by having some impact with broken pieces of plastic or glass, correct?
Correct. They weren't caused by that.
Broken plastic or glass can cause a number of different angled wounds, can it?
It causes an array of irregular, random injuries.
It can have infinite different patterns, couldn't it?
Could.
There's nothing to hold a wound from a broken shard to be north or south or east and west. It all depends on how the force is impacted on the body, true?
I'm not quite clear on your
Okay,
question.
I'll try to do better. When you're talking about shards of broken glass or broken plastic, there is no set direction that they may cut somebody, is there?
Well, it would depend on the case and how those occurred.
It can happen in many different forms as far as depth, yes?
Well, anything's possible.
How about length?
What about length?
Wouldn't that change? Couldn't that change depending on how the injury occurred, the length of the wound?
Sure.
And
Okay.
in this case, you talked about your opinions of injury relative to a motor vehicle, didn't you?
That was something I considered.
It's something you considered. Did you know much
Okay.
about the details of the motor vehicle in this case?
He's not going to be able to limit this redirect as much as he thinks he wants to because he's getting all into
When
it.
you considered your differential diagnosis, did you consider whether there was any DNA on the vehicle?
I didn't look at any of that.
I'm sorry?
I did not look at any DNA.
Do you know if there was any hair on the vehicle?
I don't
Really?
know.
Did you consider the scene itself where there may have been a debris field? Did you take a look at the debris field in this case?
I know there were photographs of various pieces of plastic around the area where the body was found.
And do you remember where those pieces were found?
Somewhat, yes.
Did you have an opportunity to consider other evidence like a shoe in the area near where Mr. O'Keefe was found?
I know one shoe was on his foot at the hospital, the other was at the scene.
Do you know if his hat stayed with him after he landed on the ground?
The hat was in the area where his body was found.
Did you take a look at his pants, the back of his pants?
I looked at that, yes.
Okay, what did you see when you saw the back of his pants?
Well, because he had bled from the back of his injury and he was on a hospital gurney, some of that blood came down, so some of the blood was on the back of his pants.
Did you see anything else other than blood on the back of his pants?
I don't remember.
I'm sorry?
I don't remember if I saw anything else.
Did you look, when you were doing your differential diagnosis, did you look at any evidence other than physical evidence? Did you look at any data evidence?
I don't know what you mean, data.
Like data you'd find on a cell phone?
She is
No.
so put out with him.
Did you look at any of the data evidence from...
And the way she's put out is so different than some of the other experts and the way they get put out with witnesses, but she is so over it, which is just kind of funny. That doesn't mean that there aren't good lines of cross here for him. I just don't understand why he's fighting with this witness instead of working with this witness. And again, the defense was limited in their direct examination. They're not objecting to Brennan getting into this in cross because he's just throwing open doors that they're going to get to ask about. So they're not going to stop him at all. If he wants to mention it all, the defense will be happy that they're mentioning it all. But he fought so hard to keep stuff out, and now he's just walking right into that line of questioning. So what the fuck was the point of all of the objections and all of the fighting? If he's just going to go there anyway, what was the point?
the defendant's Lexus?
No, other than looking at the contours of the back to see if it had impacted Mr. O'Keefe.
When you were doing differential diagnosis, did you look at any information that would tell you what the speed of that impact may have been or allegedly was?
Well, it didn't hit him, so it doesn't matter.
Well,
So you didn't care to know?
when I said she wasn't trying to force information into her answer, we have walked past that door now into she is forcing information into her answer. I'm surprised he didn't react more. She's like, no, I didn't want to look at all this. I want to see an expert, want to look at everything. It sounds like she's working from the car didn't hit him, so why do I care? Which is not where you want to see an expert come from. I want to see experts start with anything is possible and then shift backwards. But he's walked her right into it didn't hit him and that's where I started. Interesting.
Anything about the car, the data in the car, because you had already formed your opinion?
It did not hit him, so it was not relevant to my opinion.
Is that a different way?
By looking at the
Well, that is the response to Welcher, isn't it? Welcher said that is what happened. That is what happened. So I started with he was hit by the car and worked backwards. And she's like, that isn't what happened. So it's not relevant to me. So I didn't go through any further diagnosis or any other evaluation because that's not what happened. So it'll be interesting to see how he gets to, or how on redirect, Jackson now gets to not tiptoe around this nearly as much because of how Brennan questioned. So where Brennan is trying to move her answers to is very different than where we were in direct, which is interesting because it's going to give a lot of room on redirect that they didn't have on direct.
body, I could tell that there was no evidence of.
I'm going to back that up and let her finish, but it is the way that Brennan is trying to move her questioning.
Matter.
So, and that's what we're talking about. We're talking about what Brennan is trying, where Brennan is trying to move her questioning. So I'm going to back up and let them do that whole sequence of questions.
When you were doing differential diagnosis, did you look at any information that would tell you what the speed of that impact may have been or allegedly was?
Well, it didn't hit him, so it doesn't matter.
Okay. So you didn't care to know anything about the car or the data in the car because you had already formed your opinion?
It did not hit him, so it was not relevant to my opinion.
Is that a different way?
By looking at the body, I could tell that there was
Right.
no evidence of impact with a vehicle.
Is that
So
a-
whether the vehicle was going slow or fast is not relevant.
And so you didn't try to get any information about.
And she sees where he's trying to push, she sees where he's trying to push her questions, right? He's trying to push the questioning into confirmation bias of he wasn't hit by a car. So she can see that Brennan is trying to push the questioning in that direction.
The speed of the vehicle, it was totally irrelevant to you?
Correct.
And did you also disregard, well, let me ask you, do you ever look at statements?
I look at witness statements if they're available to me.
Were any of the defendants' statements made available to you?
Oh, Brennan, buddy, have you not learned? You didn't, did you? Real surprised that this is the choice. Real surprised that this is the choice. Did you watch any of the defendants' statements? Uh-oh, Brennan, danger, danger.
I did hear some of them.
Did you consider the ones that you heard?
Of course.
Which ones did you hear?
I really can't answer that. I don't know what you'd have to give me an example.
She's like, be more specific, Hank.
You said that when Mr. O'Keefe was first incurred his injury, you think that he was unconscious?
Yes,
Oh,
I
he
think
walked
that
away from it.
the severity of the impact made him
Interesting.
immediately unconscious.
So if hypothetically Mr. O'Keefe incurred his injury sometime around 12:32, is it your opinion that he never moved again until he was moved physically by somebody else?
Well, I don't know the exact time that he got the injury on the back of the head, but after that time, he could not carry out any purposeful activity.
And that's consistent with every witness that testifies about the medical.
May I approach sidebar, Your Honor?
Okay.
Well. Brennan dipped a toe into did you watch any interviews and then backed right off of it. I'm surprised he even asked it, truly. I'm surprised he even asked it. She is like, try me, because no, I don't care how fast or slow a car was going. When I look at someone and say they didn't get hit by a car, she's like, I don't care about the rest of it. But he's trying to narrow her into that line of questioning. Wait, what is happening? You were at sidebar. Where are you going?
All right, so jurors, rather than keep you here while we do things, I'm going to excuse you for lunch. Lunch will be about 15 minutes.
Lunch? What?
Or an hour, and when you come back, we will go straight through the afternoon. We're going to do everything we need to do now.
Chris, please follow me. Close your notebooks, please.
Well, now what? All right, the jury's out to lunch, which is super early for them, and the court's going back on the record.
May be seated.
All right, so Mr. Brennan, if you can briefly tell me what it is you want to introduce through this witness.
What now?
To remind the court, on direct examination, the defense promoted Dr. Laposata's credentials, including specifying her successes with the station nightclub fire and her running of her office. I have an audit from 2005 State Department of Rhode Island, Department of Health. In that audit, it paints a very different picture than was presented on direct examination. In that audit, they investigated Chief Medical Examiner, and they compiled the history of statistics for the medical examiner, which was Dr. Laposata. There were no reports, incomplete reports, and unsigned reports of over 1,500 individuals between June 30th, 2000 to June 30th, 2005. So in that 5-year period, there was an extraordinary number of individuals that weren't properly attended to, showing negligence, if not malfeasance. It was recommended that the standards, policies, and practices of Dr. Laposata's office would need to change because of the extraordinary backlog of cases regarding autopsies. In addition, it was noted that the incomplete reports confirmed that there was significant concerns with the historical management practices of the medical examiner's office shortly after Dr. Laposata resigned. In addition, it was promoted that in the station nightclub fire, Dr. Laposata had a heroic effort, and in her testimony, she also noted that there was a failure, or implied there was a failure because the medical examiner or somebody did not go to the scene to look at the turf in front of 34 Fairview Road. She suffered the same criticism for hours and hours after the station nightclub incident. She was contacted with a request to come to the scene.
She said she
refused to come to
sent
the scene,
an
did not
investigator.
appear for at least 17 hours, directly on point to the claims that she's making against other people is the same conduct she engaged in on a more extreme scale. She testified in Commonwealth versus Tompkins. In Commonwealth versus Tompkins, she was listed and testified as an expert, attempted to testify as an accident reconstructionist, which was denied. Inevitably, the court made
I don't know about
conclusions.
that.
Actually, in that case,
The other-
her efforts to be an accident reconstructionist were denied.
Probably more helpful.
Then she testified in a case called Patino. And in Patino, after testifying, she received great scrutiny and criticism from the court. The court noted on page 1025 of the transcript, when Dr. Laposata gave the testimony, she knew the boy wasn't like this because he fell off a bed. She knew the mother was lying. She read the text messages and knew the defendant had beat the boy. The only reason I conclude that she offered such testimony was to distance the defendant from causing those bruises, setting up an argument against malice, but instead destroyed her credibility. On cross-examination, she came across as a hired gun. Sometimes it's seemingly small things that impeach a witness's credibility. Inevitably, on the credibility determination by the court would agree. The jury gave greater weight to the testimony of Dr. Gilson and Snelling than they did Dr. Laposata for the reasons I addressed previously. The jury was justified in discounting her testimony and concluding the other doctors testified apparently impartial. While she appeared as a paid advocate, at least on this occasion, without impugning the witness's integrity, because that witness is known to the court, but in this case, when she testified, she was not credible. That's a direct credibility determination by another tribunal about her testimony. So I would like to, and that's why I came sidebar rather than ambush, to give the court notice that I'd like to get into the criticisms regarding
You
her
can't
run as
ambush. You have
medical
to show the
director that led to
defense
resignment after she was
anything
audited
for
and left
impeachment.
1,500 bodies unattended or incomplete. Also get into the criticism.
What were the dates on that?
For her handling or lack of handling of the station nightclub fire, and finally get into the credibility, adverse credibility determination in the Patino case.
So I'm not familiar with the Patino case, so I'll need a copy of that.
Yeah, you would.
All right, Mr. Jackson, I'll hear you.
Thank you, Your Honor. First of all,
You absolutely need a copy of the case to ensure that what Brennan is representing is what the court found, because this is impeachment evidence if it's as represented. And if this witness resigned because of an investigation, it goes to their credibility, and that can come in. So Let's see what Jackson
said that
has to say about
the
his
audit
expert.
established that, as the chief medical examiner, the audit revealed that she left 1,500 bodies unattended, was his quote. Bodies unattended.
That's not what he said.
That's absolutely not what happened.
That's not what
in
he
that
said.
situation. It was a political.
That's not what he said. He said that the reports were not complete. If he said unattended at the end, I was stuck on the reports not complete. So 1,500 bodies where the reports weren't complete or finished. If he said unattended, that's not accurate at all.
Political situation. The medical director for Rhode Island came in and took over. He began to change protocols and cut quality control.
So a different medical examiner?
1,500 bodies unattended was his quote. Bodies unattended. That's absolutely not what happened in that situation. It was a political situation. The medical director for Rhode Island came in and took over. He began to change protocols and cut quality control. He said he did not want a second set of eyes on any of the reports, not the autopsies. There was never a suggestion, ever,
It was
that an
about the
autopsy was
reports.
not performed efficiently.
Yeah. If he said it at the end, my takeaway from it was that the reports weren't signed or completed. That was my takeaway about the audit.
And timely. Never. The reports that were attendant to the autopsies it was a two-tiered set of criteria that Dr. Laposata put in place to establish quality control and quality assurance. First, the medical examiner conducts the autopsy and writes a report. Then the doctor herself, the chief medical examiner, because she is a perfectionist, determined that she was going to establish a protocol in which she would put eyes on every single report. Hundreds and hundreds of reports per year. In doing so, she had to prioritize which reports were going to take a priority, which ones were being subject to litigation, which ones were going to be subject to criminal cases, and which ones were never going to be subject to any review at all. For instance, if somebody was found, let's say somebody that was without family, etc., found and unidentified, there's no litigation attendant to that report, she would put that report aside and get to that report after she dealt with the reports that were on sort of on the front burner, if you will. After, by the way, none of the reports were ever not done. They were all completed. There were a small fraction of reports, according to the audit and according to Dr. Laposata herself, that had to take a back seat. When the medical director came in 2005, by the way, this is 25 years ago, right? These are autopsies that were performed, and the audit was performed for autopsies and reports dealing with the year 2000. It's 2025. This is 25 years ago. When the new medical director came in for Rhode Island, he said, I don't want any review of any of the reports because it's more efficient and it's faster to get the reports out in a timely fashion. She resisted and said, I will never, ever, and she was published saying this, I will never, ever sacrifice quality for speed. I want the highest quality coming out of this office. They had a difference of opinion. She walked away because he was asking her, the new medical director was asking her to sacrifice quality of the conduct that she was undertaking as the chief medical examiner.
She should be able to be asked about it.
Island. So it's a very different circumstance
she can explain
than was just suggested. No bodies were ever left unattended, ever. Certainly did not involve the other phrase that was just used is negligence and malfeasance. It was a backlog, and they had a very public.
I remember him
fight
saying
over
that.
it. Number two, with regard to the Station nightclub fire,
You're telling me
staff was on
that a political body of the government gets backlogged and that the bureaucracy infighting is a situation? Because that is about the reports. Oh, boy.
location immediately. She, as the chief medical examiner, was there the same day. So that's of no legal moment. It's of no consequence. It certainly has nothing to do with her opinions and conclusions in this case. The Tompkins case, we've already talked about that in voir dire, Your Honor. The Tompkins case dealt with an issue dealing with accident reconstruction, which she's not undertaking. I'm not asking her, and She ain't saying it.
I've excluded that part of it based partially on the Tompkins case.
Right. And I don't know anything about the Patino case. And what I would say is, given the fact, look, we don't know what the facts of that case were. We don't know what the trial was about. We don't know what the cross-examination was about. We don't know why she was called. We don't know what she looked at. We don't know why she was looking at what she did look at. We don't know why she didn't look at things that she might not have looked at. We don't know why her opinions and conclusions were ultimately rendered. We would have to have a trial within a trial, which I would be happy to undertake if someone gives me a file. Happy to do that. But I don't think we want to do that. I don't think the court wants to do that.
Your Honor,
Also,
let's spend some time on
I don't think that
this.
attacking this witness's credibility is in good faith by the Commonwealth. Mr. Brennan himself has hired Dr. Laposata personally no fewer than 4 or 5 times.
What?
Maybe 3 or 4 times. He knows her qualifications. He knows the quality of her work. He's actually undertaken to consult with her as a medical examiner and a consultant. So I don't believe that these last 2 issues are in good faith. I don't believe the station fire has anything to do with anything because she was late, according to Mr. Brennan, in coming to the actual location. She was there the same day, and she had an entire staff that was there immediately. And in terms of the audit, it's a 25-year-old political fight that isn't quite what Mr. Brennan made it out to be. So I don't think any of these things are relevant for cross-examination. I'll submit.
All right.
I just want to make a note that Attorney Jackson has a way with words to just inflate or make things up. I have not hired Dr.
I'm going to gain him up. He's saying Attorney Jackson has a way with words to conflate and make things up. I'm going to back this up
Examination.
because I wanted to gain up the microphone or gain up the audio because Brennan's not going to go back to the podium. What?
All right.
I just want to make a note that Attorney Jackson has a way with words to just inflate or make things up. I have not hired Dr. Laposata 4 or 5 times. And so that is just a mischaracterization which he likes to do for the public. But the reality is I've used her a few times, and the last time I used her, I'm not going to disclose why I don't use her anymore because it would be unfair without her in the room. But the suggestion that somehow I'm endorsing the qualifications of this witness, I am not. That's what I'm going to say on the record.
Okay. So the first 2, the
Okay, hold on.
the backlog.
I want to hear what he said at the end of his statement because the beginning of the audit, my takeaway was that was all from reports. So I'm curious to hear what he says at the end. Am I questioning that Brennan misspeaks in court? No, I'm not. Not at all, because he's done it numerous times. But I'm curious.
Dr. Gilson and Snelling than they did Dr. Laposata for the reasons I
This is the end of that case. I want to hear what he said about the audit, though.
addressed previously. The jury was justified in discounting her testimony and concluding the other doctors testified apparently impartial. While she appeared as a paid advocate, at least on this occasion, without impugning the witness's integrity, because that witness is known to the court, but in this case, when she testified, she was not credible. And that's a direct credibility determination by another tribunal about her testimony. So I would like to, and that's why I came sidebar rather than ambush, to give the court notice that I'd like to get into the criticisms regarding her run as medical director that led to resignment after she was audited and left 1,500 bodies unattended or incomplete. Also, getting
Unattended or incomplete. I heard that as the reports based on what he said earlier, but I understand interpreting that as meaning there are 1,500 people whose autopsies aren't done vis-a-vis the reports being incomplete. No, I understand that interpretation. I do. I interpret that as he was talking about the reports. No, I know he said bodies, but when he said unattended or incomplete, he's talking about the reports not being done and signed. So that's how I interpreted it. I understand the other interpretation. So that's why Jackson said, no, autopsies were done. I was modifying it by what he said before, but no, it's fair interpretation for sure. But the jury's not in for this. So 1,500 bodies unattended or incomplete is 1,500 autopsy reports to me. But I understand, again, the interpretation. I understand why Jackson said, no, the autopsies were done. This was paperwork not done. All right, let's see what the court has to say, because then he says, I did not hire her, I used her. I don't know how you have an expert if you don't hire them.
into
Like, what does that even mean? when he said, I did not hire her. I've used her a few times. They're experts. You
25
don't, you have to hire them. Like, I don't even understand what you mean. I've never hired him.
Dr. Laposata 4 or 5 times.
I've worked what?
All right.
I just want to make a note that Attorney Jackson has a way with words to just inflate or make things up. I have not hired Dr. Laposata 4 or 5 times. And so that is just a mischaracterization.
I have not hired Dr. Laposata 4 or 5 times.
Likes to do for the public, but the reality is I've used her a few times, and the last time I used her,
I've used her a few times in the last time. Well, she's an expert. The expert doesn't come in if you don't hire them.
I'm not going to disclose why I don't use her anymore because it would be unfair without her in the room. But the suggestion that somehow I'm endorsing the qualifications of this witness, I am not. That's what I'm going to say on the record.
Okay.
And he's like, I'm not going to tell you why I don't use her anymore. What in the world?
So the first two, the backlog issue, if we can call it that, with the ME's office, I'm going to allow the Commonwealth to get into that through questioning. Same with the station nightclub fire, based on the testimony already in evidence. Those two areas, and Mr. Jackson, without leading, you can certainly go back and rehabilitate her. But those two will come in. I'm not going to do anything with Tompkins because I used it for the basis of keeping out what appeared to me to be biomechanical engineering opinions of this witness, and she's not qualified to do that. So I have not read Patino. I will read it over the lunch break and see if we get anywhere with that. Okay, so I need a copy of that. I want you to give Mr. Jackson a copy as well. Okay?
So we're not done with this.
Okay, so, all right.
The only other thing, I don't know if you want to handle it now or after lunch or later, because I want to address the issue of the 3 posting.
Okay, so let's mark those now.
Sure.
I don't know what. They are marking the large exhibits from earlier.
Can we mark them all as one, A, B, C?
I have no preference one way or the other. It's just 3. They're all
Mr. Jackson, if you can I just see it?
Of course.
The large exhibits presumed to be X-rays, but I don't know if they are.
ID, yeah.
All right, so those are being marked for identification.
Yeah, it would be, yeah.
And then we'll see where we get. Oh,
You know what, show me that one again too, please.
that's loud. All right, I turned that down. They are marking those large exhibits. Oh boy, with the motions or the discussion of impeachment evidence before lunch. And a lot of you that live in New England, and we have a lot of you here, all know or are sharing in the chat that the station fire became a political hot potato.
H, quadruple H, and
It
I.
wouldn't surprise me if the jury was aware as well.
All right. All right. Mr. Brennan, there's no objection to these coming in through another witness, so you agree that they'll be coming into evidence?
I'll stipulate
All right. And what's the objection to them coming in through Dr. Laposata?
it's not part of her report or opinion. She's gone beyond her report, talking about the fact that she's studied x-rays and given an opinion. I think that suffices. It really, I think, is beyond the scope of her testimony to begin with. I'd be gracious with it. stipulate to these, I'm sure Dr. Rentschler will utilize them if stipulated.
So you'll stipulate to them prior to Dr. Rentschler?
I will.
So you can use them with Dr. Rentschler?
I expected that I could because he certainly used them in his analysis and opinion. But I should be subject to the entry of evidence in the defense case in chief by, I understand I can use them in Dr. Rentschler's testimony, but I want to use them with Dr. Laposata. She's a medical doctor.
Would you
consider them for purposes of her opinion? I cannot understand.
So what do you want to ask her about them?
It shouldn't
I'll use
matter.
the X-rays that you reviewed. Yes, that's it.
We already asked her
Okay.
that.
So go ahead.
If that's all he's going to ask, I won't have a problem.
Okay. Yeah, I have no problem with that in that form.
That's it. Literally, these are the X-rays that we talked about a little bit earlier. Yes. This is the right hand. Yes. That's the arm. The forearm. Yes. That's the upper arm.
He wants to verify
So
them.
they're
The defense wants to verify them before they use them with Dr. Rentschler, with the medical doctor. Fine.
cumulative, but if they're coming in anyway, I will let you put them in.
Thank you.
All right.
They're not
So the
cumulative.
last thing is
They're
Dr.
not how are they cumulative? We've not seen the x-rays the entire time. Ugh. It shouldn't be that hard of a fight if they're coming in anyway.
Rentschler, I need to hear argument from both sides. I have a new PowerPoint, so I'll hear both of you. Mr. Brennan, I'll hear you on your...
Okay, let's distill what just happened, because the jury's out at lunch and the court is doing the work that needs to be done with the attorneys after sidebar, where Brennan is arguing to bring in impeachment evidence to question Dr. Laposata about, and the court ruled on 3 of the 4 items, 2 of the items being criticisms of her as the head of the ME's office in Rhode Island. When Jackson argued against it, he said, look, these things are explainable. Well, if they're explainable, that's fine to allow the questioning to come in. The reason the court is allowing those questions to come in is because it's similar things that Dr. Laposata criticized here. It was brief, but said, no, you should have someone go to the scene. It should be a continuing investigation. It should be a team that works together. And so if there's criticisms like that out there regarding certain things, the prosecution can ask about it. I have a feeling that her answer will be, yes, when this started happening, I walked away from my job. So I don't know if that's going to end up being the serve that he thinks it is over the way that coroner reports were getting completed or not completed when she was the head medical examiner and a new party came in. So that's going to come in an impeachment the same way Jessica Hyde was questioned about the case when the court didn't allow her to testify to certain aspects. And that might also come in because the court has kept out one case where the court questioned the doctor's testimony. The second case where a court found her to not be credible, the defense hasn't read it. The court hasn't read it. They're going to read it. That is how Hank Brennan represented it during his argument. The other parties are going to read it and see if she's questioned about it. So with the investigation or the audit of the office of the medical examiner, it seemed like the time range that audit was done was not the entirety of the time she was there. So that will be interesting. The criticism of her not rolling out to or her office not rolling out to the fire seems, well, I've got questions about it because she said we had someone on scene. If the criticism is that she personally didn't go out, but investigators from the ME's office were out, I think it's silly for the prosecutor to ask about. We're going to have to see because, well, you didn't go. Okay. Well, she's the head of the office. If individuals from the office went, does she really need to be there? We'll see how that line of questioning goes. And then there is one other case that they're going to read over lunch. and we'll see if the court lets that in to question the witness for impeachment. So we will see. But I don't know if either of those things are going to come in the way that Brennan thinks that they will, because this witness is not giving him an inch at all. And also the head of the state's medical examiner's office is not who I would expect to arrive at things necessarily. I would expect the lead investigators from the office to go, but we will see. Then the court's going to read the case law. And now we had the court marking the presumed at this point x-rays on the large paper. And now we are getting back into what Dr. Rentschler will test about, presumably after lunch at some point today. One would hope. So let's hear their argument about Dr. Rentschler.
Motion.
Because there's a new PowerPoint. Oh, a lot of you are asking me, shouldn't this have come up during voir dire? No, it's impeachment. It doesn't need to come up during voir dire if it's impeachment.
We've received the most recent update to Dr. Rentschler's PowerPoint. There are some additions, different analysis in that PowerPoint. This is within 24 hours of him testifying.
When did you receive
There
it?
are opinions on page 6 and 8 of his May 7, 2025 report. And there are a number of numbers that we have objections to. Dr. Rentschler just generally shouldn't be allowed to express opinions and conclusions about what he thinks about the case or about other witnesses.
All right, so I'm looking, I think, at the new,
Do you have a copy of the new one?
from today, page 6.
But didn't they ask Rentschler? There was objections a couple days ago about things in Rentschler's PowerPoint. It doesn't surprise me if Rentschler updated his PowerPoint to adhere to the objections. So
what I have are just photos with measurements, so I don't know what the testimony that corresponds with those. I've read, obviously, the report of Dr. Rentschler from May 7th.
Okay.
That does not seem to detail everything, and that's no criticism. I'm just saying it's a scant report, so I don't know what the opinions are regarding these.
I'm sorry. Yep. Please.
I didn't want to speak over Mr. Brennan, I apologize. I just wanted to let the board know that we're talking about action now. We went through, based on Mr. Brennan's suggestions last night, and significant.
Right. So I can't gain this up because Brennan is just flipping papers on top of the microphone. What I heard Jackson say is we took Brennan's objection and went through and significantly reduced the PowerPoint.
Significantly edited the entire thing. Literally every single slide that you got a problem with. There were a couple.
He said we went through and edited every single slide that he had a problem with.
So we disagree with me, but it's very, very.
I see that a lot of the hearsay's been removed.
And I can identify this report as helpful.
Thank you.
I'm sorry?
I can identify this report as helpful, the ones that were changed.
All right.
It made streamline this.
Okay.
So what do you both, I'm going to hear from Mr. Brennan first. What are you objecting to as the report now stands?
I have a most recent copy of the report now.
So they edited it based on your objections, and there are now further objections, is what it sounds like to me. And these are regarding the PowerPoint from Dr. Rentschler.
So 9 through 27,
Slides 9 through 27 or pages?
slides 9 through 27 now have Dr. Rentschler identifying and attempting to match different abrasions with different holes in Mr. O'Keefe's sweatshirt.
Oh, I was
And
wondering
so
if they were going to do that.
basically what he is trying to do is to suggest that there are a different amount of abrasions relative to the amount of holes, or perhaps he might want to testify about that the holes in the sweatshirt were in a different place on Mr. O'Keefe's arms than the
This
abrasions.
sound is killing me.
The reason why this is concerning is because there is no background for him regarding fabrics. This is a different and new opinion that we have not prepared or obtained an expert for. We probably have very little time to get somebody to rebut this analysis regarding fabrics. I don't see anything in
Don't you have Welcher coming back?
his CV or his history that allows him to equate the number of holes in fabric with the number of abrasions on somebody's arm. It does not consider or account that there could be multiple wounds from one hole, or there could be holes that don't create wounds. So whatever the implication is going to be by Dr. Rentschler, we're not very sure, but it obviously would require some type of expertise, which I do not think that Dr. Rentschler has a foundation for. So those are 9 through 27.
We need Al Woods.
Generally,
She would know.
and then specifically,
Fabric
I can run
specialist.
through quickly the individual objections I have. Slide 6 tries to define the theory of the alleged incident. Doesn't say whose theory it is. It implies it's the government. It's an improper suggestion.
Hold on.
What is your theory?
Okay, so which one of 1, 2, and 3 on 6?
1 is objectionable. What's the core issue of the case? It's an ultimate issue for the jury. An expert reconstructionist or a biomechanical engineer shouldn't be defining.
What? I'm backing up to hear what he read about what he's objecting to.
Ultimate issue for the jury.
Oh, I need to go back one more. That's an ultimate issue for the jury. What did you say?
1 is objectionable. What's the core issue of the case? It's an ultimate
Oh, what's the core issue of the case?
issue for the jury. An expert reconstructionist or a biomechanical engineer shouldn't be defining the core issue of the case. And then 3, first event is alleged contact between the rear of the Lexus and Mr. O'Keefe's right arm. Again, that's offering an opinion that doesn't have facts and evidence, not in a position to draw that opinion.
And is 2 okay? Before you move into the whole slide,
No, on number 6, all 3 of them shouldn't be there. Asking what the core issue is in the case, Dr. Rentschler and no expert should be defining what the core issues in the case are. They should talk about their training experience, any testing, observations, evaluation, and then give their opinions, not core issue in the case.
all right?
Slide 9 outlines perhaps
I think that rephrasing core issue of the case is the issue. But they can say, we were asked to look at the opinions of Dr. Rentschler, who opined this, 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 this. And so we were evaluating those. I think that is just a wording choice.
his process.
Fine.
The first step of the analysis to determine if the arm injuries are consistent with the physical evidence. Evaluate the abrasions and compare the evidence. I suppose this is what he's done. This is one of the less offensive ones. Although unnecessary, it doesn't provide an opinion. I could live with that. The next
Okay.
one,
You could live with what?
number 9.
Okay.
Number 23. Again, this gets into that new core opinion about trying to identify or, I think, compare the abrasions to the different wounds. I think the part that's objectionable is the words measurements, question mark. I'm not sure if it's implying failure of somebody else. It seems to be an opinion, and I'm not sure of the context.
There's a question mark around measurements because there was a question as to where the fuck they are. That's all.
Context of it. 24.
Oh my gosh.
The expert is trying to define what Dr. Welcher had done.
That's what they were
And
asked to
maybe they're
evaluate.
saying he conducted his testing based on the position of Dr. Welcher's arm. I think that would be an appropriate comment, but it's not clear what they're saying. The pain transfer test, number 2, is the only test noted with respect to the arm.
So without the
They're evaluating the paint transfer
text, are you
test.
objecting to this
No.
slide?
No.
Okay.
Okay.
31 posits questions regarding ultimate opinions. I think it's inappropriate. And then 32,
Ultimate opinions like, I don't know, that is what happened? Like that? Can you read it? Because we don't know what it says. Just for the
I think
record.
is improper because it ultimately endorses or vouches for the witness's credibility. I think he certainly can give an opinion
He can give an opinion.
that the evidence is inconsistent with the injuries to Mr. O'Keefe's arm, but I don't think it should be on the slide bolstering his opinion.
What?
33. Again, it's posturing the weight of the evidence. And it's resigning the government to a particular study, one study. It's really a commentary on the government's case. It goes like this. Number 1, Dr. Welcher only did A, and second part, A is insufficient. So that's really what this is saying. It's commentary, it's hearsay, it's inappropriate. 34,
How is his opinion hearsay?
I think if one said that that's what he did, I, Dr. Rentschler, took a step to determine the kinematics of Mr. O'Keefe's arm during the alleged incident and asked how would this arm move, I think that would be appropriate. But he shouldn't be giving a opinion on what steps should have been taken by Dr. Welcher. Number 2 on slide 34.
Isn't on rebuttal Dr. Welcher just going to come in here and say they shouldn't have done it this way, they shouldn't have done it that way, they should have done it my way? Isn't that literally what's going to happen? That's what experts will say. They should have evaluated this, they should have done this testing. Okay.
And number 3, I don't have a problem with. The next one is 46.
Well, we went from 34, we didn't go to 41. I'm very disappointed. I know 3 of you will get what I'm talking about. It's fine.
Again, this is bolstering the expert's opinion by putting it in writing on a slide. I think some of these opinions are appropriate for Dr. Rentschler to share with the jury.
Well, I'm glad
But
you
his
think so.
final ultimate opinion shouldn't be endorsed on a slide. 47. Again, this is self-endorsement of the success of his tests and giving his opinion about his success.
He's allowed to give an opinion. Isn't he hired because he's giving an opinion?
Number 1 and 2, I
Isn't
think
that
are
like the
inappropriate.
point?
Number 3 has really no context standing alone. And number 4, if he notes that's his next step, I wouldn't have a problem with number 4.
Alley Cat in the chat and a number of
slide.
you asked, why didn't he bring this up before now? Because he got the PowerPoint modified today. That's
54.
why. And he's going to testify today.
Again, number 1 gets into his opinions. Number 2, he gives an opinion about a different expert, a medical opinion. And number 3, it's again self-endorsement on his own opinions. So all these are opinions either bolstering himself or somebody else's work. I don't think it should be in a slide. 55.
Are you reading it?
I think it's accurate.
real
I think it's
time?
proper testimony. I don't think it's proper for a slide. Same with 56.
Yeah, it seems like he is
I don't
reading
know
it
that he has the basis
in
for
real
number
time.
1.
I thought everybody wanted to get to lunch.
Number 2, I don't have a problem with on slide 56. And number 3, again,
No?
it's bolstering his opinion. So I think 1 and 3 are improper. 2, not. Slide 58.
How much longer are you going to be? Are we going every slide then? Every one?
I
We're
don't know
doing
what
every
the
one?
basis for number 1 is. I suppose we'll have to see.
I guess we are.
If these are Dr. Rentschler's views, I don't know how they're relevant to the Commonwealth's case, but certainly I think he has the experience to make these conclusions, but it shouldn't be in a PowerPoint. He shouldn't be commenting on the reports of another expert in a PowerPoint, number 3. And number 4 is ultimately an opinion that he's self-endorsing. 66.
We're literally going like slide by slide and page by page.
Again, it is an opinion. I don't think it's an admissible opinion, and it shouldn't be in a slide. He's trying to draw a conclusion on what the jury should conclude based on the Commonwealth's evidence. He's not in a position to do that. 67. Parts of this are objectionable. I think that he certainly could testify. He hasn't seen any simulation by Dr. Welcher, but posturing it about in a manner that suggests there should be doubt in some way is inappropriate.
I don't even know what it says.
68,
but
I don't think Dr. Welcher's report was introduced. And putting in a fraction of a report, I can't appreciate the significance of it. It's hearsay. Perhaps there's a reason he'll be able to point to the report or talk about the report. I understand that, but putting in a random page from a report is hearsay. Should not be admissible. I don't know if there's going to be a conversation about trying to introduce the entire report, but one page will take it out of context. 72. I think the expert has a basis for the opinion. I don't think ultimate opinion should be in PowerPoint because it's self-endorsing. 74. Again, it's a conclusory opinion, bolstering. Some of these can be said but shouldn't be in PowerPoints. Same thing with 75 and 76. They're ultimate conclusions. And so I'm not in agreement with all of the conclusions that the expert may try to introduce, but testifying about an ultimate opinion and putting it on a board to self-endorse shouldn't be permitted. And those are my objections.
Okay,
Okay.
Ms. Little?
Thank you, Your Honor. First of all, there are, if I stand here only because I would be able to reference the PowerPoint.
Yeah, that's fine.
Thank you.
I think Jackson told her to go to the podium and she said, I want to reference the report. And the court said, that's fine. I'm going to try to gain this up a little, which means we're going to have more white noise.
No additions, just to be clear, the PowerPoint, the only changes that we made were directly in response to the objections that were filed by the Commonwealth. We did delete a large section, trying to accommodate some of their concerns, as well as shortening some of the opinions. So those were the only changes. I just wanted to make clear to the court, there are no additional opinions that have been set forth in the PowerPoint. With regards to slides 9 through 27, that was not one of the issues that was identified in the Commonwealth's motion. They objected to slide 9. There's half of those slides are not referenced.
I do agree. It's a new objection. I just don't know when there's an objection raised how a biomechanical engineer is qualified to testify to tears in clothing.
So this is is a direct his testimony is going to be based on his knowledge of forces and forces applied to certain objects and how that results in injuries.
And I understand that, but some of the specifics that he says, I'm just saying I had a concern, so I understand it's new.
I think that we'll be able to satisfy the court's concerns by laying the proper foundation.
All right, so we can come back to the fabric
foundation.
argument or whether it's beyond his scope of expertise. But actually, Ms. Little, if I can just ask you, and I can hear you later, as I assume everybody wants lunch and we're coming back in at about 20 of, quarter of at the latest. Can you just explain to me why these slides, if Dr. Rentschler is permitted
for
to
lunch.
express these opinions, why we also need them on slides? That's the problem I have.
I think that's a great question, Your Honor. And the reason we didn't do these on slides is because we objected to Dr. Wilkins coming in on his PowerPoint.
So I looked at that yesterday.
Copy of the specific opinion that was placed up on the screen with regard to his opinions and conclusions. That was done over the defense's objection.
So which one? Because I did look last night at that.
It's hard to hear what Miss Little's saying in the court, but what she is saying is we objected to Welcher putting his opinions on his slides, and the court allowed it over our objection. So then if we're putting opinions on slides, we're putting opinions on slides.
That and did not see it.
It's slide 136, Your Honor.
Oh,
The totality of the evidence.
Hold on one second.
if it exists, Miss Little's going to have it in her hand.
Is it a conclusion page?
She brings the receipts.
I don't know. I just.
Hold on.
But it's page 136. It's
On page
entitled
136.
Lexis if done. And it states the totality of the evidence is consistent with the right rear corner of the big 2021 Lexus impacting John and Mr. O'Keefe, striking the rear posterior aspect of his head on the frozen ground.
Okay.
So if he's allowed to do that in the trial,
So that is different than what
The court's like, okay, so that is different. How is it different?
I said he could be asked on his ultimate question, right? But it still came in?
that came in.
Was there, I'm sorry?
Yes, that came in over the defense.
Came in over objection. The court was just about, did you hear it? The court was just about to say, was there an objection? They said repeatedly, it came in over the defense objection.
All right. Because what I did note is that I was very careful to say exactly what the ultimate question could be from Mr. Brennan. In fact, there were objections. I sustained them twice, so I wrote out exactly what could be said, and Mr. Brennan asked a variation.
She's saying, I wrote out exactly what question Welcher could be asked. Also, don't do that. Like, don't do that with any of the experts.
Of the first one, and there was no objection. So I didn't remember that this came in. All right, so I will take a look at that. What I would like to do in the interest of time, so maybe we can talk about that in the conclusion page, but where he outlines everything else, there's so many pages with text that I may not have a problem with testimony regarding this, but why do we need testimony and text so much here?
This is to assist the jury.
It's what?
This is to assist the jury. There is a significant amount of information that needs to be relayed.
Okay.
It's an 80-page PowerPoint. This
Okay.
is solely to make sure that this goes efficiently and effectively. I think it's helpful for these. We've narrowed down the text on the slide significantly as the court can see from the proposed PowerPoint.
Okay.
Just to the major issues. I think we've streamlined this a lot, but I think having the PowerPoint will allow us to make this go smoothly and quickly.
All right, so I will look at these.
Did you notice the words Elizabeth Little used? Did you catch what she said? It's very hard to hear. Doing it this way will allow it to go smoothly and quickly. If you can't find an attorney that can read the room, just ask Attorney Little. Attorney Little is bringing in the magic words. Smoothly and quickly. This will assist the jury, and we can go smoothly and quickly. Your Honor, it's going to take a lot longer if we do it the other way. But if that's what you want to do, Could do it the long way.
What I'll try and do is if there are any changes in the first 15, I'll try and get those done during lunch, and then we can have this argument afterwards.
Thank you, I appreciate that.
All right. All right, we'll see everybody no later than 1:15.
Oh boy. All right, we are at the lunch break. And the argument over what ARCCA expert Dr. Rentschler will testify to in his modified PowerPoint. The defense made clear to the court that this PowerPoint was modified based on the filed objections by the Commonwealth. The Commonwealth raised some new objections about whether or not ultimate opinions could be on the PowerPoint slides. And at the end of that argument, Attorney Little said to the court, well, with Dr. Welcher, we objected and these were on his slides. And the court said, I had forgotten that that came in because I had so narrowly written out the questions that could be asked of Dr. Welcher, which again, why are we so tightly constraining the questions that can be asked of experts? It is wild. And Welcher was not listening to any of the attorneys, and Brennan was trying at times to sidestep around what Welcher was saying, and Welcher was just not picking up what he was putting down. But Welcher will be back as a rebuttal witness, so that's delightful. We have a long lunch ahead of us, but not too long for you and I because we have Zoom room, and we have to still finish up with Dr. Laposata. And I don't know how far we're going to get on that or how far we're going to get into Welcher's testimony today based on all of the argument that is going on regarding what can be in a PowerPoint, what can't be in a PowerPoint. But Attorney Little said, Your Honor, if these things stay in the PowerPoint, it will go smoothly and quickly. And I don't doubt that, but we've got to finish the cross of Dr. Laposata, which is going to come in with at least some of the impeachment information that the Commonwealth asked for. So now that we are at the lunch break, the jury should be back just shortly, actually, from the lunch break, seeing that the court was on the lunch break so long. I am going to take, what time is it? I'm going to take 10 minutes till 1:25 Central to run to the restroom, grab some food, check in with family. So that's what we're going to do. Lawnards, hydrate, get some food, stretch, answer like those 3 emails that you need to get taken care of because we'll be back on jury duty. The jury got a very long lunch. The court worked through the lunch quite a lot. The attorneys are probably not going to eat at all. I've got some coffee, but I definitely need some food today. Like as we are getting closer to the end of the case, you can feel the tension in the courtroom just ramping up, can't you? I'm ready to get to Dr. Rentschler's testimony. I'm very curious to see how Dr. Laposata will be dealing with Attorney Brennan because she is not putting up with his shit. But the way she fights back with him is very different than the way like a Welcher would fight back. So it's interesting to watch the difference in the witnesses and how they push back on the attorney questioning. Today. So I will be back in 10 minutes. Lawnards, we will get to Q&A at the end of the day. I'm hoping we will get through the testimony smoothly and quickly. I do need to remind you that if you want to stay in the loop with the witnesses that are coming up when we get to the rebuttal case and when we get to closing arguments, if you're like, I am out on the rebuttal case, wake me up when we get to the jury instruction and charging arguments. Perfect. Lawnard app is for you. Free iOS and Android. Just the app will take care of you. The app will let you know so you don't miss the things that you want to see most. Let's put on some music. Let's take a quick lunch break. I will see you back here in just a few minutes. We will send out an app notification when we are back, but it is also going to be quick. And don't worry, I'll let you know when we are back. So quick lunch break for me. And I will see you guys in a few minutes. download the Lawnerd app so you know exactly when we're back from break, and you can get a notification from us when witnesses take the stand that you've been waiting for, when something unexpected happens in court, and during verdict watch. The Lawnerd app has all of your live court notifications to keep you in the loop. LawnerdApp.com, free for iOS and Android. And while we're on break, don't forget to hydrate, get up and stretch. Take care of yourself. Trial days are long days. Trying to stay in the loop with this trial? I know sometimes it's hard if you miss a day. That's why I've got daily case briefs dropping over on the Emily Show YouTube channel and the Emily Show audio feed on your favorite podcast app, so you can stay in the loop even when things get busy. break, but don't forget to download the Lawnerd app so you know exactly when we're back from break. The Lawnerd app has all of your live court notifications to keep you in the loop. Take care of yourself. Trial days are long days. Hey Lawnerd, court is still on break, but don't forget to download the Lawnerd app so you know exactly when we're back from break, and you can get a notification from us when witnesses take the stand that you've been waiting for, when something unexpected happens in court, and during verdict watch. The Lawnerd app has all of your live court notifications to keep you in the loop. LawnerdApp.com, free for iOS and Android. And while we're on break, don't forget to hydrate, get up and stretch. Take care of yourself. Trial days are long days. Let's turn our music off and get ready to head back to court. How's everybody feeling? Did you get something for lunch? I hope you did, because we're coming back into cross-examination, which I'm sure is going to be a little bit feisty. I saw a lot of you ask, so over the lunch break, can the defense tell the witness, hey, by the way, after lunch, they're going to ask this? No, they can't. They cannot. They are not supposed to have contact with their witnesses. I mean, scheduling is, I think, the exception there. While the witness is on the stand, they can talk about it beforehand, but not after. The witness would know, the witness would be aware of the cases they've been a part of, etc. And then the defense would be aware too. And it seems that Brennan's aware, because Jackson's saying, well, Brennan's hired this witness before. And he's like, I haven't hired her. I've used her, which is the weirdest iteration of I've worked with her, but you're a private defense attorney. So how does that even happen? Today is much, but I'm very interested to see where this goes and what happens on redirect. And I think this is going to be most of the rest of the day. It's a lot. And I imagine cross-examination is going to be a lot. Cindy Williams said, I ate. Did you? No, not yet. No, I grabbed food. We've got some beef sticks, some cheese, and I have the rest of my coffee, which I need to finish before the beef sticks and cheese, because otherwise that's a really bad profile. And I have some chips. So there is lunch prepared. It is basically a Lunchable. It is there. We've got to finish the coffee first. Did I grab the emotional support cats? No, they're hanging out with Dr. B. They're hanging out with Dr. B. All right. Are you guys ready? Are you ready? Yes, I am too. I know it's kind of it's an afternoon snack. And then when we are done, I will eat and then dinner. It's very much what I'm used to when I'm in trial. Bigger breakfast, dinner, not a lot in the middle of the day. It just is. So that's what it is. Oh, I didn't grab the skull. If I need to grab the skull, I will. I didn't grab the skull for sure. All right. We ready to go back to court? I think we are. Let's get back to court. But yes, Dr. B has the cats with him. They're just hanging out while he's doing stuff.
All right, the jury is coming over.
The court is going to tell them what she thinks of the case that she probably read over lunch.
Just wanted to tell you what I was able to do during the lunch break. So, Mr. Brennan, you argued for 4 points of admission.
Yes.
Regarding this witness. I'll allow in 1 and 2. I've had a chance to look at 4. I think I already told you I would not allow in.
She said no on 3
because I've already considered it. I've now looked at the 4th one, the case. I'm not going to let you get into that during cross-examination. If the door is open and you think you can get into it after redirect, please come to sidebar. All right. And also, I had a chance to look
not
at the
allowed.
actual exhibit regarding what came into evidence.
Before the lunch break, the Commonwealth argued there were 4 things they wanted to be able to get into with Dr. Laposata. The court said yes to 1 and 2, no to 3 and 4, which are the cases. So 1 and 2 is stuff that happened while Dr. Laposata was in her position. Part of the reason that is coming in is because the defense went through a substantial list of accolades and awards and things that she had received. So it is fair that the Commonwealth then gets to come ask, but there was also this audit and there was also this. So the court said yes to 1 and 2, no to 3 and 4. And now this will be moving on to, I think, the exhibits is what the court said.
From Dr. Welcher and Ms. Little, contrary to what you said and what Mr. Alessi was nodding to, page 136 did not come into evidence. It's a blank page. So
Okay.
That PowerPoint did not come in. I had a chance to look at Dr. Rentschler's PowerPoint, and at least for now, maybe you can persuade me otherwise, any text that has hearsay on it that you say will help assist the jury, what I want to say is I think we have to give the jury some credit here, okay? They have been listening to this case intently for weeks. I don't find that anything that you've recommended here comes in to assist the jury is necessary to assist the jury.
All right, that's
So
going to
before
get
Dr. Rentschler testifies,
that's going to
those
get
slides
pared
that
down on the
have-
slides.
that were objected to that have text are out.
Can I have a moment just to examine the Dr. Welcher PowerPoint?
No, not right now. You can look at it, yes. You can look at it while we're bringing the jury in.
Okay.
We have 4 copies of the PowerPoint, and I know that
The court pulled up the PowerPoint of Dr. Welcher that the court was provided with and said that the slide that they were talking about was not admitted into evidence, that it is blank. It was one of the slides because the defense objected to a number of those slides and they were redacted. The court is saying that this was a redacted slide and it did not come in. And then Attorney Little asked for time to
Mr.
review
Alessi,
it.
please. One 136, 137, and 138 are all blacked out. All right, are the jurors on their way, right?
Okay. We're waiting for the jury to come up. It sounds like the witness is on the stand. And that the slides that the defense argued were out. The thing that helps, I think, all the attorneys in this case is that they can go back and watch it. But if all the PowerPoint came in, the court will have the one that came in. And if the one that came in is blank, then the one that came in is blank. So, as the jury is coming in, we're going to zoom. The court is on the bench. The witness is on the stand. That's the witness on the stand. That's not the court. That is Dr. Laposata. You guys are like, what is the court doing? That's Dr. Laposata. That is not the court. All right, the jury's walking in, so we get the only fan.
Right, Mr. Brennan, whenever, I'm sorry.
Thank you. Good afternoon, Dr. Laposata.
Good afternoon.
Am I on point now?
You are.
You were asked on direct examination.
Did he say, am I correct now? He said, good afternoon, Dr. Laposata. Am I correct now? I think that's what he said. Brennan. What? I had to back that up.
Good afternoon, Dr. Laposata.
Good afternoon.
Am I on point now?
You are.
Oh, am I on point now? Okay. Did he need to think about it? Or is this trying to mitigate the fact that you're going to go after her credentials? Because I don't know how that's going to go.
You were asked on direct examination about your qualifications.
Oh, it's going right into there.
You were a medical examiner for the state of Rhode Island. Is that fair to say?
Yes, I was the chief medical examiner.
For 20 years?
12 years.
I'm sorry, 12 years.
12 years.
When's the last time you worked as a medical examiner?
In 2005.
When's the last time that you conducted an autopsy?
I've done probably a handful of autopsies, private autopsies in my consulting practice.
Since 2005?
Correct.
When do you think the last time you did one is?
Maybe 4 years ago, four or 5 years ago.
4 or 5 years ago?
Yes.
Okay. Since you left the medical examiner's office, have you had any specialized training in brain injuries?
It's all part of keeping up with the medical literature and knowing the forensic pathology literature, reading medical literature. So it's a continuing endeavor to keep yourself educated with medical updates.
Since you left the medical examiner's office, have you had any specialized training in brain injuries?
I've not gone to a course on brain injuries.
Since you left the medical examiner's office, have you taught any students on brain injuries?
Yes.
Have you given any classes or seminars on brain injuries?
Yes, I have.
And coup counter coup, how many times have you experienced that as a medical examiner, that condition?
Personally,
I myself
never.
haven't experienced it, which was good. But in
I myself am very happy to not have had a TBI. Thank you so much. It's not delightful. TBIs are tough, and then no one really knows what's going on. And then TBIs are tough, man. But I love the patting of the hair, because there's two ways to interpret that, right? How many of you experienced? Well, none.
Coup counter coup, how many times have you experienced that as a medical examiner, that condition?
Well, I myself haven't experienced it, which was good. But in cases, hundreds of cases, it's a common injury.
You said you did differential diagnosis. That is to exhaust any potential bias you have, correct?
Well, a differential diagnosis is to think, how many ways can you get this finding? And it does help prevent bias.
Did you say on direct examination part of the benefit of differential diagnosis?
She said start
is
with
to
how
make
we
sure
could be
that
wrong.
You don't have a bias?
Yes, yes.
In order to eliminate bias, you're supposed to look at all reasonable alternatives, correct?
Yes, that's part of it, making a differential diagnosis.
So you don't just look at a person's body, come to a conclusion, and ignore other evidence that would kind of defeat the purpose of differential diagnosis, wouldn't it?
Well, you always have to look at all the evidence.
And so if you didn't look at all the evidence and you disregarded some of the evidence because you had already made up your mind, that really wouldn't be the proper...
No. Looking at all the evidence and disregarding the evidence are not the same thing. You can look at something and say, this is not reliable. It's not the same. I hate the way he conflates things in his questions. Simple questions.
Some of the evidence because you had already made up your mind, that really wouldn't be the proper study of differential diagnosis, would it?
Right, I don't do that.
I'm sorry, ma'am.
I don't do that. I always look at all the evidence.
And would you look at all the evidence even if it was contrary to whatever opinion you want to give in court?
Well, the evidence allows me to come to an opinion. So it's not like I decide on some opinion I want to give and then look for the evidence. The evidence is going to tell me what happened to the body.
So you would never say, like, I don't need to look at that evidence. If it's presented to you, you would look at it and study it and consider it in differential diagnosis?
Sure, it may or may not apply, but I look at it.
Because if you did that and said, well, I don't need to look at this, and it was relevant evidence, that would defeat the whole idea of differential
He's
diagnosis.
trying to catch
correct?
her about
Well,
the
you
speed of the
always
car
want to look
from
at all
earlier.
the evidence that's going to help you decide what happened to the body.
If you were to ignore relevant evidence because you already made your mind up, that could create some type of bias, even if you're not recognizing it, correct?
Well, I don't make my mind up. I make it up on all the evidence I have. Then if something else other evidence comes up later, I have to reevaluate everything and consider that new evidence.
When you were talking about car collisions, I don't want to belabor the point, but you didn't major in physics, did you?
In what?
You didn't major in physics, did you?
No, I took physics, but no, didn't major in it.
Okay. And the last time you took physics was probably, what, undergrad?
Correct.
Don't start asking her when the last time she took physics is. Stop it.
Thank goodness.
You
The last time you took physics was undergrad. Yes, thank goodness.
No, I took physics, but no, didn't major in it.
Okay. And the last time you took physics was probably, what, undergrad?
Correct. Thank goodness.
You have no study in biomechanical engineering?
No, I'm not a biomechanical engineer.
Understood. You never taught courses in accident reconstruction, have you?
Only in terms of looking at the injuries on the body and showing how that they could or could not have occurred from impact with a motor vehicle.
And that makes sense to me because a lot of courses will have multiple parts. So I could see her being a part of a course on accident reconstruction to talk about the medical legal side of autopsy injuries and what you would expect to see. Like that makes sense. But is she teaching the full course? No, but it makes sense that she would be a part of courses on that subject. But didn't we talk about this in direct and in cross?
Have you taught classes in accident reconstruction?
Only as far as it would affect the findings on the body.
Do you know what I mean by when I say accident reconstruction?
Well, accident reconstruction meaning, and I'm telling you that my expertise in accident reconstruction is restricted to looking at the body and then understanding how impacts may or may not have occurred to the body. I don't take a car and look at mileage and such like that.
You don't do any studies of the actual vehicles, you're focused on the body?
I'm focused on the body, but I also look at the vehicles to look at the points of impact that might be possible.
You do not have any advanced study in biomechanics, do you?
No.
Okay. Now, you had mentioned that when you were in the medical examiner's office, you had a number of higher profile cases?
Mass
every
casualties, what
case
she
is
said.
important because somebody's dead.
You pointed out some pretty specific ones on direct examination. Were those more important, the ones that were highlighted, or is that the same as every other case?
She didn't say they were more important. They were high volume Ask your question. Just ask your.
I don't know what you're talking about.
Well, you had mentioned the Egypt airline crash, station nightclub fire. Those were highlighted or pronounced on direct examination. Are they equally important as every other case?
Oh, absolutely. Every person is my patient.
You talked about some of your commendations. The station nightclub fire, you received quite a bit of criticism on that, didn't you?
Well, there was a flurry of negative press without any basis.
You had mentioned that a doctor, a medical examiner, should have gone out to the scene to look at the area where John O'Keefe was found to make observations.
You want to bet this isn't the first time she's been asked about that? Because she has testified since that happened. So I imagine that she is more than prepared for the same questions that people are always going to ask. She's like, right. Same questions.
Did you suggest that in any
People are
way
going to
on
ask.
examination?
You have to know what the scene looks like, and usually that is documented in police reports and in police photographs who document the scene.
The station nightclub fire, that had numerous victims, didn't it?
Yes, 100.
And you received criticism because you were repeatedly requested by emergency responders and police officials to come to the scene, and you refused?
That's incorrect. First of
Okay.
all, nobody called me to come to the scene, and medical examiners are not first responders. As soon as I got a call that there was that fire in the nightclub, my investigator went right to the scene, and I was in constant communication with him throughout the early morning hours of that horrible accident. And I went into the medical examiner's office because I had to start getting ready to run our office 24 hours a day to not only take care of the poor individuals who expired in the nightclub fire, but also the regular work of the medical examiners. So there was no need for me to go to the scene because I had my investigator
right.
there. And my job would be at the office to get things all set up to handle the influx
Increased
of
workload,
deceased.
Did you receive criticism that over 17 hours there was an effort to have you come to the scene, but you refused?
There were,
I'm going to allow it in a different form.
It's asked and answered because she said her investigator was there, which I think he said, which I think she said in response to Jackson's question on direct, which also makes sense. Plus, with arson, there's a lot that has to be done. And I'm not saying this was arson. I should just say with fire. The only reason I dealt with fire cases is because I dealt with arson cases because they were crimes. But with fire cases, there's a lot of scene securing that has to happen before you can even go out to the scene. There's so much else involved in that. It doesn't surprise me that she went back to the office to prepare the shift in work if they have an ME investigator. That makes perfect sense. So fire cases take a lot. Okay.
yeah, that's incorrect.
Hold on,
Oh, I'm sorry.
Oh, no, I didn't mean to scare you.
Oh,
The court said I didn't mean to scare you. I think the court likes this witness too, right?
Scene, but you refused?
there were,
I'm going to allow it in a different form.
yeah, that's incorrect.
Hold on,
Oh, I'm sorry.
Oh, no, I didn't mean to scare you.
Oh. Okay.
Hold on for a second.
Okay.
Ask him to.
The whole courtroom laughed at, I didn't mean to scare you.
Differently, Mr. Brennan, please.
That's funny.
Did you receive criticism that officials?
I'm going to allow it based on the ending, pursuant to the ending. Let's get it.
Did you receive criticism that for over 17 hours officials were asking you to come to the scene and you refused?
It was untrue. It was printed in the newspaper. We looked up all the phone records and provided it to the newspapers and showed that nobody called me to go. I would have gone if I needed to. I had my investigator there. It was just bullshit. No, it was erroneous.
Well, Brennan, you've now given this witness multiple delightful moments in court. Brennan, your impeachment has never been so delightful, Brennan. You have walked into this witness having multiple moments of being charming. more charming, sir, than you. Sir, impeachment normally are oh shit moments. And here, the impeachment is like, so you were criticized for doing your job? And I love that she said it was bullshit and got nervous about it. I'm backing it up. That's hilarious.
Asking you to come to the scene and you refused?
It was untrue. It was printed in the newspaper. We looked up all the phone records and provided it to the newspapers and showed that nobody called me to go. I would have gone if I needed to. I had my investigator there. It was just bullshit. No, it was erroneous stuff.
Was there other
It was
criticisms
bullshit.
in 2005 before you left the office?
No, there was a flurry of stuff in the papers. There were union issues, new director of health, new governor. So yeah, there was a little flurry of stuff, which was not substantive.
So you inevitably did resign in 2005.
Yes, because my budget was going to be cut, and I knew that if I had to get rid of a medical examiner, we couldn't do a good job for the state, and I'd done it. I'd been chief for 12 years. I'd been on call 24 hours a day for 12 years, which was an honor, really. But then if I couldn't do a good job, if we cut the budget, I had to get rid of a medical examiner. I couldn't serve the people of Rhode Island well, so I resigned.
Did you resign shortly after the audit?
Generally, impeachment is there to make you like a witness less, to make you trust a witness less. Do you like or trust this witness less or more than before we went down this line of questioning? That is my question to you at this point. Well, counsel, I got stuck in a bunch of bureaucratic budget bullshit. And so instead of dealing with the bureaucratic budget bullshit, I left. Okay.
It's in criticism?
No.
Same year?
Oh, I don't even remember.
After you resigned, you opened your own company?
Yes, I started an independent consulting practice.
How much of your business is consulting?
It's a consulting practice.
Yep. How much of your business,
All.
of your income is
100%.
consulting?
It's consulting.
Do you consult in both criminal and civil cases?
Yes, I do.
Also, has anyone in the chat, and I don't know this jury's experience, we don't know their jobs. Anyone in the chat want to walk out of your job over being told to cut budgets, terminate people, take over the jobs of 4 people, do it all yourself all of a sudden? Like, oh, your internet speed's fast. You can do the job of these 5 people that have been laid off. Anyone ever had to make do and wanted to walk out of their job? Right. Anyone worry about government budget cuts and how that impacts people's work? Right. Brennan, it's not a serve. It's just not a serve.
What percentage of cases are criminal cases?
So many of you. Right.
It's maybe half and half.
Half criminal, half civil?
I don't keep track of it in that way, but that would be a guess.
I'm sorry, I'm sorry, I didn't hear you.
I don't keep track of numbers of civil or criminal cases that I'm consulted in. If I had to give an estimate, it would be half and half. I've worked on over 1,000 cases in my private company.
And fair to say you get compensated for your time?
Yes, I get paid for my time.
Dr. Laposata?
Did you get paid $300,000? I've got questions. So many of you are like, yeah, I have faced that. And a lot of you made the point, if this is a younger jury, they might not have had the experience of having a consistent job. Because a lot of people deal with the constant restructuring and downsizing and moving. It's a very fair point. I don't think these things are a serve. I just don't.
You had mentioned that there were some scratches that you had taken a look at on Mr. O'Keefe's body. If we could have Exhibit 165, please.
Notice he didn't ask how much she was paid.
Now, would it be fair to say, Dr. Laposata, you do not know the genesis of that cut on Mr. O'Keefe's right eye?
I do not know what caused it. I can tell you what didn't cause it, but I don't know what did cause it.
You said that was from blunt force?
It's from application of blunt force to that little area that broke the skin.
When you were asked a question about whether
Also,
that
because I've called out so many camera operators when they do things that are annoying, this camera operator has very quickly caught on to when they're showing things that shouldn't be up on screen. And it's been really appreciated.
was consistent with a
I like it.
punch. You opined that it was consistent with a punch, yes?
It could be consistent with a punch.
You weren't saying it was consistent with a punch to a reasonable degree of medical certainty, were you?
That would be within my differential diagnosis.
It could be consistent with all
So yes, he just walked into her saying yes. He would have objected if the defense asked, and now he asked and he can't object.
other types of blunt impact, or many other types of blunt impact, couldn't it?
That's correct.
Ground, perhaps?
No.
No, an object?
If it was an object that could get into that area under the eyebrow, yes.
You mentioned the spoiler on the back of Miss Reed's Lexus. Do you remember that?
I remember that.
Do you know how tall John O'Keefe was?
He's around 7 foot, 5'11", I think, 7'2", something around in.
Did you just say 7? Ma'am, no. No, he's not 7'2".
There.
No, he's more.
Ma'am, he. Nope.
John O'Keefe was?
He's around 7 foot, 5'11", I think, 7'2", something around in there.
Does she mean
He's
72
more
inches?
Closer to 6'1". Does that make sense?
Sure.
Okay. And that spoiler.
Easy. Brennan did not go after her over it. And I think she did mean 72 inches, which would be 6 feet. But Brennan didn't go after her for it, and now he can't say spoiler. So it is where it is.
On the Lexus, do you know how high off the ground that is?
No.
Did you ever try to measure it or ask for photos or any information about that?
I looked at the photos.
Did you ever ask for any measurements or try to take any measurements?
No.
Could I have Exhibit 166, please? Did you see this cut on Mr. O'Keefe's nose?
That's a scratch. It's not made by a sharp instrument. It's not a cut. It's a scratch.
Is there any scratches on the left side? Do we have a photo of the left side? Please. And that you say that's a scratch, not a cut?
Correct, because a cut means it's made by a sharp thing, like a knife, and a scratch is made by something that's kind of rounded that has a little point on it, but it's not sharp.
Do you have any information or basis to say where that scratch came from?
No.
Did you do any differential diagnosis on that scratch?
I don't know what caused that. There could be a number of things that caused it.
There was no scratch on the right side of Mr. O'Keefe's nose?
I don't see it one, no.
Could you zoom in, Ms. Gilman? So the only scratch was on the left side?
Looks to be, that's not a good photograph because there's some blood obscuring the skin.
Yes.
If my memory serves me, there is a scratch on the left side of the nose and maybe a small scrape on the tip of the nose.
And we can go back to the left side? And you said that could not have been caused by a sharp object?
Correct. It's not an incised wound. Incised wound means a bladed, sharp cut. This is a scratch, not made by a
sharp
blade.
item. Right.
Were you aware the defendant made a statement that she pulled a piece of glass from the defendant's nose?
No.
And you would say that that wound is inconsistent with being caused by glass or a sharp object?
It would not be caused by a blade. It could be caused by a piece of glass that was thick.
Like safety
I
glass?
thought before I offered you that statement, you had said that it could not have been caused by glass. Do you now have a different opinion?
I don't remember saying it couldn't have been caused by glass.
Didn't you say it couldn't have been caused by glass or a sharp object?
A sharp object.
Would
Like a sharp object, like it's not
You
an
can take that down, please.
incised wound made by a blade. It could be caused by something sharper that's thicker, but does not have a thin blade. So it could be caused by a thicker
Like 5mm pieces of sharp plastic?
piece of glass.
If somebody is deceased, does any blood pressure from their heart still move in their body?
No, they're dead.
If somebody removed a sharp object like glass from somebody's face, would they spurt blood if they've died?
If you're dead, there's no blood pressure. So if you're dead and you remove something, there may be some superficial blood, but it's not going to have blood flow because your heart's not pumping blood out of the cut ends of the blood vessels.
So it's not going to spurt if you pull something out of a person's skin if they've passed.
You wouldn't get a spurt of blood from arterial pressure.
Right.
I just want to ask you a very few questions about hypothermia.
Sure.
You mentioned that Mr. O'Keefe's body temperature at the hospital was 80 degrees,
Yes.
and there's different ways to take somebody's or body's temperature, isn't there?
Yeah, that was a rectal temperature, so that's a good representation of the body temperature.
Better than armpits?
Is the variance between a common practice of taking temperature and by somebody's mouth and rectal, is it about a 3 or 4 degrees difference, or do you have a different experience?
It can be different. A rectal temperature gives you a better internal body temperature. The oral temperature, if you're breathing in or if you just had something cold in your mouth, may not register a proper temperature. So the rectal temperature is the preferred temperature for a medical diagnosis.
98.6 is an important temperature, isn't it?
Yeah, it's our usual normal body temperature.
And so, is there a standard?
I mean-
Is 95 degrees considered hypothermic?
If you have, then clinically you would start to worry that the person might be experiencing bad effects of hypothermia.
At 95 degrees?
At 95, you start to worry about it.
And could some of the things that happen is labored breathing?
Is what?
Labored breathing?
What,
He's
what
asking
about
what
labor
happens
breathing?
with
Well, someone
hypothermia.
is hypothermic.
He
If
just
they're
didn't
95
ask
degrees,
it
does
well.
it affect their breathing patterns?
Not especially.
Okay. Does it affect the way their respiratory system works?
No.
Does it have any effects on the human body if you're hypothermic at 95 degrees?
No. You're still okay.
You said bad effects just a minute ago.
If that temperature
You said at 95
continues to
degrees you start
decline,
worrying about bad
it starts to
bad
become
effects.
dangerous, doesn't it?
It can.
Mr. O'Keefe was evaluated, and at the hospital, his body
So what
temperature
effects?
from a rectal reading was 80 degrees at about, what, 6:37?
Correct.
Did you know that before he got to the hospital, first responders had him in an ambulance?
Of course.
Did you know they turned the heat up and put blankets on him and tried to provide warmth to him before he got to the hospital?
Yes, that would be standard practice.
And that standard practice would usually add temperature to the person, wouldn't it?
Well, it might.
So it's possible it could, but it might not.
It usually doesn't add that much.
I see. And so inevitably, at 6:37, Mr. O'Keefe's body was 80 degrees.
Yes, when he got to the hospital, his rectal temperature was 80 degrees.
And so that is a drop from the standard, or what's expected, of 98.6 degrees. That's a drop of at least 18.6 degrees.
Yes.
Okay.
You mentioned that Mr. O'Keefe, after suffering his head injury, would not have moved other than twitching.
Correct. No purposeful movement.
Were you aware that he had an iPhone with healthcare data on it?
No.
If there's no movement, assume for a second there's no movement of Mr. O'Keefe after 12:32:16, and he's found a little after 6 a.m. in the morning. That's about 5 hours or 5.5 hours, correct?
About.
Okay.
And if somebody is in the cold for 5.5 hours, that's consistent with dropping from 98.6 degrees to 80 degrees in body temperature, isn't it?
If the person is dead, yes.
If a person is outside in the cold and still alive, will their body temperature decrease?
If they can, people can die of hypothermia, but that's not the case
That's not
here.
what he asked.
Not the
though.
ultimate death, but if somebody's outside and they're alive and they're lying in the snow and it's below freezing, will they lose body temperature?
They will, especially if they're not bundled up well.
And body temperature can drop from 2.5 to 4 degrees an hour?
In a dead body.
Okay. In a living person, it can drop 1.5 degrees.
No. A dead body at room temperature will usually lose body temperature at like 1.5 degrees an hour. If a dead body is in a cold environment covered with snow and avalanche environments, the dead body can cool at 4 degrees per hour.
And so a person who is in cold conditions, starting to be covered by snow, less than freezing, they can lose body temperature when they're living, can't they?
If you're sure, you can. People die of hypothermia, but that's not the case here.
Well, someone could be alive, lose body temperature, and not die. That can happen, can't it?
Yeah.
Right. So if someone is in the cold, let's assume they're not.
I'm confused by Brennan's line of questioning because her answers earlier about what temperature you would lose if a body is deceased is more helpful to him than what he's arguing. The defense was arguing that he was moved into the snow and that he was killed somewhere warm. That's what they said in their opening. And she's saying, no, this is actually consistent. And the temperature drop is consistent with him being deceased and in the snow for that amount of time. And then instead of taking that point that was helpful to him, he's running back around saying, but couldn't somebody still be alive? I'm interested to see where he's going with
All
that.
They're in
right.
the snow, below freezing, not moving. Can that person lose body temperature if they're still alive?
Sure. They just lie there. They can become hypothermic and die.
Even before they become hypothermic, can they lose body temperature?
I think he's moving towards the ME's finding in his case that the hypothermia is a factor because he couldn't get himself out of the snow. Okay.
Well, losing body temperature makes you hypothermic. Thermic is temperature and hypo means below. So your temperature goes down and you're hypothermic because it's going down.
And people can survive from being hypothermic if they get the right care.
Sure.
And so in that 5.5 hours, it is consistent with a person being outside in the cold and starting at 98.6 and ending at 80. That's consistent with being in the cold for 5.5 hours, isn't it?
For a dead body, yes. That's how a dead body would cool in a snow-covered cold environment.
And it could also be consistent with somebody who is alive for some time and then dies, correct?
I don't understand your question.
Somebody could be out in the cold, under the snow, sub-freezing. They could be alive for some time. The body temperature could drop. And then when they pass and dive, their body
Why
temperature
is this point
continue to drop
important to
probably
you?
at a more rapid pace. That still fits within
No.
5.5 hours, doesn't it, Dr. Laposata?
No.
Because if someone can drop 4 degrees of body temperature in an hour,
A dead body.
yes, it would only take about a little over 4 hours if it was at 4 degrees to go from 98.6 to 80. Yes?
Correct, yes. So he was exposed to that cold environment for 4 to 5 hours.
If somebody was alive for a couple of hours, it's a lower rate, say they lose 3 degrees. And then, after that couple hours, they lose body temperature at 4 degrees. That would still be consistent with a drop from 98.6 to 30 degrees,
No.
to 80 degrees, wouldn't it?
No, you were saying a dead body cools in a cold environment
he's saying.
at maybe 3 to 4 degrees an hour. And that has nothing to do with a living body and how long they can stay at a body temperature.
Do you disagree that somebody could be alive, lose body temperature out in the cold, freezing temperature below 32? They could lose body temperature at a certain rate, then die, and then continue to lose body temperature. Is that possible?
Anything's possible. It's just what's important is what happened in this case.
I'm asking for your medical opinion, though, rather than to be an advocate. As far as your medical opinion,
So sustained, and I'll strike that.
as far as
Dr.
your,
Laposata,
Yes.
could you listen to the question, please?
Of course, thank you, Your Honor.
as far as your medical experience, could somebody be alive outside in the cold below 32 degrees, not moving, covered by snow, still alive, and lose body temperature?
Sure.
And then could they, after an hour, 2 hours, could they then die and continue
An hour to 2
lose
hours?
more body temperature?
Sure.
You mentioned your opinion about injury on Mr. O'Keefe. And at one point you said that his injury was inconsistent with a taillight, and you said because there was no damage from the bumper. Do you remember saying that?
I don't think I said it quite that way.
Okay. Do you remember how you said it?
No.
Do you remember discussing or raising the issue of a bumper as part of your equation, that the injury to Mr. O'Keefe was inconsistent with the injuries?
He has no injuries on him that are consistent with being hit by the back of the SUV. That includes the spoiler, that includes the bumper.
Okay, if we could play video E, please. I want to ask you, Dr. Laposata, have you seen this video before?
Brennan is, I guess we'll look at video E. Brennan is trying to align the cooling more with Dr. Wolf than with Dr. Laposata. I'm interested to see what video he shows her. Is it the one where the foot gets run over? Yep. It's not Randy.
No.
Thank you. You can take that down. Did you see anything in that video that would suggest any contact between that mannequin and the vehicle's bumper?
Objection.
I'm going to see you at sidebar on this for just a minute, please.
I mean, his whole foot got run over, like spun all the way around. But okay. Back to Rescue Randy and a sidebar regarding the video of Rescue Randy. I guess we'll see after the sidebar. I don't know how Brennan thinks
jurors,
that
I am
helps
going
him.
to strike the...
Oh, no. Jurors, I'm going to strike all of that. Okay.
All right, so jurors, I am going to strike the last bit of questioning of this witness and the video as it goes to this witness. All right.
Strike the question.
Dr. Laposata, after you received materials, did
She
you
said
ever
she'd never seen it.
ask for any additional materials?
Let's see, I always make sure I have all the scene investigation, autopsy, medical records, police and witness investigate and witness statements. So I felt I had a pretty complete database. I didn't get the x-rays until a couple weeks ago, so that was delayed.
That was newer?
Yes.
You said a medical examiner has to make a determination in 90 days. Is that the rule?
She didn't say that.
When you work in a medical examiner's office, when you get a deceased in, our national standards want us to have the autopsy report completed and all the associated tests done within 90 days.
Can investigations occur?
That was from Dr. Scortibello saying that that is the goal of the national organization.
And the additional accumulation of evidence happen after that 90 days?
Oh, sure.
Thank you, Dr. Laposata.
Oh, he's done with cross. That's a weird question to end on. It's like he thought the video was going to be a serve, and then the video wasn't a serve, and he was like, so you try to get them done in 90 days? She didn't do the report here. What a weird way to end that cross-examination. It was just like, okay. He's like, all right, well, done. It really is as if he just gave up and sat back down. Okay. And on to redirect. Sure. There's lots of ground for Jackson to question.
Yes.
Dr.
Okay,
Laposata.
hold on one second.
I think the person who just crossed over Jackson in court was heading up to the bench. I think that's one of the bailiffs.
Yes.
That is the kind of their main bailiff.
Dr.
Okay,
Laposata.
hold on one second. Jurors, when I strike something, that means disregard it. And what I've struck through this witness, the video that you just saw and some of the testimony means that if it's in evidence, it's in evidence, but it is not part of your consideration with this witness. Okay. All right, go ahead, Mr. Jackson.
May I proceed?
I think my speculation, I think one of the jurors asked the question of the bailiff that stands back near them.
Yeah. Thank you.
I think the juror had the
Dr.
question.
Laposata.
Yeah, I think the juror asked that. The juror was just like, what? Right, because it's confusing as fuck. It's like the video is stricken. What do you mean the video is stricken? What does that even mean? I think that was a question from the jury.
You were just asked a series of questions about body cooling, correct?
Yes.
Does a body, as it's cooling, does it know if it's indoors or outdoors?
No.
If there's a very cold environment, be it indoor or outdoor environment, would it still cool?
Oh, absolutely.
And it would cool would it cool at the rates that you earlier described?
Yes,
Even if indoors, if that indoors was cold?
absolutely.
Your Honor,
I wonder if we're going to see the jury asking more questions now because the court answered it immediately. I really wonder if the jury's going to be like, ooh, we can do that. Game on.
may we approach along with the Commonwealth very briefly?
No. Why? because he wants to get into the pictures and he wants to ask about the house that he wasn't allowed to ask before. That's why. I don't think they're going to get into it, but we'll see. Let's zoom past this sidebar. It's actually kind of a longer sidebar. That was a longer sidebar.
May I?
Yes.
Thank you. Dr. Laposata, stand back here for a quick second. Before I sat down the last time, I asked you a little bit about x-rays.
Yes.
And the effect of x-rays on
He moved on.
an evaluation by a forensic pathologist. Do you remember that?
Yes.
Are x-rays important for a forensic pathologist to consider?
Yes, they are.
Did you find any, you reviewed the x-rays, correct?
Absolutely.
I'm going to relegate my question to just the right arm of John O'Keefe.
Yes.
Did you find any deformities, defects, breaks, fractures, or hairline fractures of that kind on any of the x-rays that you reviewed?
None.
I'm still shook that there's x-rays.
Yes, I have a question for you. When you printed these, did you print them from a flash drive?
Oh, I thought the judge was what? I thought the judge was asking the witness. What the fuck? The judge is asking Jackson how he printed the X-rays. Okay.
Do you have them up on the,
We do have electronic versions of this.
why don't we do that instead of the big, the large?
As long as I can mark the large ones, I want those marked and moved into evidence for reasons that we discussed at sidebar.
So those
He
will
wants
be
the
in
big
your objection
exhibits
to
for
this
closing, I bet.
Okay, well.
And for his
even
next
if the
witness.
Commonwealth objected, I'll allow those in, but I'd prefer to give the jury flash drive would be.
That is me sighing, not the court. The court wants to give the jury the flash drive with the x-rays on it. He wants the paper. And he wants the paper marked.
On them instead of these big. So we will mark your flash drive, and you can just go ahead, do it in evidence. We'll mark the flash drive. The flash drive will go in with the jury rather than these very cumbersome additional pieces of paper. And you can go ahead and show them.
If I could, I don't want to have a full discussion in open court.
All right, jurors, we're going to make this one really quick.
They're proper evidence. He's allowed to bring in proper evidence. She doesn't want the big papers. She wants it on the flash drive, which is fine. But this should have been discussed outside the presence of the jury before they talked about this. They marked these into evidence over the break when the jury was out of the room. Don't piss with the attorneys in court over the evidence. Do it then. He asked to mark them when the jury was out of the room. Have the conversation then about whether or not they're also digital, so that if you do not want the court to have to store the large printouts, though I don't think there was any fuss about the lucite whatever that the clothes were put into, if storing it without damaging it because it's paper is an issue, have that conversation before the jury comes back in. Why are we doing this? Ladies and gentlemen, we're just going to approach real quick. This will be fast. Do it outside the presence of the jury. They've already been marked. Do it at the end of the day. Why does it need to be done now? The flash drive can get taken care of. This is not even a thing. Of all of the, we're not going to do this anymore. We're going to go straight through. We're not going to be to sidebars. It's just creating problems that aren't actually, this is not actually a problem. It's not actually a problem. If they want to use the larger exhibits, they can use the larger exhibits. for whatever reason they want to use them for.
I'll show these to you, and then I'll put them on an overhead. May I approach, Your Honor?
Yes.
This could have all been handled when they talked about this at lunch. None of this needed to be done now.
This document.
Yes, I do.
How do you recognize it?
I recognize it by the medical examiner identification of Mr. O'Keefe, and I recognize the x-ray of the right hand, the right wrist, the right femur, and I can also tell by the R designation here that that's the right side of the body.
Is this what you reviewed in coming to your opinions and conclusions concerning injuries to his right hand?
Yes.
Thank you.
So these now will mark whatever the next exhibit in A, B, and C.
A, B, and C, yes, Your Honor.
Right, and they're being marked. And they talked about it.
HHH is now 290.
They talked about it so much earlier in the day. Just do it then.
May I approach, Your Honor?
Yes.
I'm sorry. I couldn't hear you.
This, I don't know what's going on with the closed captioning. We're definitely not at Coachella closed captions.
May I approach?
Yes.
My brain hurts. But how many of you are like, what fucking x-rays? I know, me too.
This document.
Yes, this is a x-ray of the body of Mr. O'Keefe from the medical examiner's office. The R indicates the right side, and we see here the two bones of the arm. There's no injury to them. We see the pelvis bone. There's no injury to that bone. They're perfectly normal, and there's no abnormal soft tissue swelling. It's a normal right arm.
Thank you. I may have this marked as next to order B.
She definitely put her opinion in there. Chrissy said, Emily, you were calling it like baseball game. Yeah, that's the goal, is to call it like we see it as it unfolds. But for the court to be so hurried about other things and then to make non-issues an issue is frustrating. And we saw this happen last trial when the court told all the attorneys to pre-mark the exhibits. I spent the entire however many months of trial we were here bitching about it ad nauseum because every time the court's like, these exhibits need to be remarked. Right, you told them all to pre-mark the exhibits, and then you said, I don't want to do it that way, and made them all remark all the exhibits, and then it took longer, and then you were mad at everybody that it took longer. It's like somebody being like, reorganize all your books in alphabetical order. No, just kidding, I want them done by color. Why? And then yell at all of them for taking longer. Oh, we need to move this along faster. Well, why are we dicking around with this? It just, when there's a reason, I'm fine with it. When there's not a reason, it's aggravating. There's just no reason for it.
Doctor, do you recognize this document?
Autumn said, and then
Yes,
somebody
this is
coming back, no,
another
they need to be done by
X-ray at the medical
genre.
examiner's office of
Right.
Mr. O'Keefe. And again, it shows
And then
the
alphabetical
right
by author's
side.
middle name.
We see some of the ribs there. We see the shoulder and the humerus, the upper arm bone. And the upper arm bone is totally normal. There's no soft tissue swelling around it. There's no breakage or microfractures.
Thank you, Doctor.
These x-rays are going to be used with
Court's permission next to
Rentschler.
Some C is in Charlie.
Yes.
And those have been marked. Those are now in.
Dr. Laposata, that's all I have for you. Thank you for coming.
Anything, Mr. Brennan?
No, thank you.
I'm really surprised that the entirety of the redirect was dealing with the x-rays. Huh. I'm also really surprised that there are x-rays.
All right, Dr. Laposata, you are awesome.
Thank you, Your Honor.
We're on to what I presume is the defense's last witness. So that should be Dr. Rentschler. Andrea Payne Conley and many of you in the chat said, if the medical examiner took an x-ray, why didn't we hear about them before? Well, we did hear about x-rays before from Welcher, who said that there weren't any. And look here, x-rays. Wild. And this should be Dr. Rentschler next,
Is
right?
there anything else today?
Are we done for the day? No. No, we can't be done.
John, may we approach?
Okay, jurors, feel free to stand up and stretch.
Okay. They are approaching. The jurors are standing up and stretching.
Okay.
Are they calling Dr. Rentschler? Are they not calling Dr. Rentschler? What are we? Well, there we go.
You're so sure the other skip the court and jury.
I didn't hear them formally call Rentschler, but that's who they're calling. For those of you asking, will there be any other witnesses? I think this is it. I think this is the defense's last witness based on what they said yesterday. So Dr. Rentschler is witness 11. He is from ARCCA. We saw him testify last trial, but he is going to testify differently than last trial. There were some restrictions. So it's going to be new testimony than what we have heard. And we'll go into tomorrow's testimony, I'm sure, and they can deal with the PowerPoint over the afternoon or over the evening break,
All
I'm
right,
sure.
Mr. Jackson,
Might as well
whenever
get
you're
started with
Thank you,
background
Your
training
Honor.
and experience and
Sir,
stuff.
could you please, pull that to you?
So for all the questions, will the defense end with ARCCA? Yes. The defense will end their case with ARCCA. So this will be their last expert. This is the biomedical engineer. And I imagine this testimony will go into tomorrow. And then she will let the jury go partway into this witness and then handle some of the other argument later or in the morning.
A little on the
Gotcha.
tall side. Pull that
He
seat
is
right
a
up
little
under
on
your
the
chin
tall
if you can. And in a nice, clear voice, tell the jurors your name and spell your last name for us, please.
Dr. Andrew John Rentschler, Rentschler.
Sir, what do you do for a living?
I'm a biomechanist, a biomechanical engineer, and an accident reconstructionist.
Where do you work?
Biomechanist sounds so cool.
I work for a company called ARCCA LLC.
Tell us a little bit about ARCCA. What is ARCCA?
ARCCA is an engineering consulting firm. So we do litigation type work, both civil and criminal, where we look at, for instance, I do biomechanics. So I look at injury causation in different types of events, motor vehicle accidents, pedestrian, automobile
Do you ever do
incidents,
ski collisions?
sports related injuries,
What about
industrial
skiing?
accidents. We also do accident reconstruction,
Skiing.
as well as all types of really forensic type engineering. And we also do R&D, research and development, for private and governmental entities.
What's your current title?
I'm a vice president and director of biomechanics for the Midwest Division.
The director position that you hold, that's the official position at ARCCA?
That's correct, yes, sir.
How are you ARCCA's senior biomechanist?
I'm one of them, yes.
And how long have you held the position of director of biomechanics and human factors?
It's been at least 5 years. I don't recall exactly how long.
What exactly is it biomechanist or biomechanist?
Biomechanist, yeah.
All right, I'll get it right by the time we're finished. What is a biomechanist? What do you do?
Mechanist.
So a biomechanist.
I don't know if I'm going to use them interchangeably. I'm just letting you know now. I will use biomechanical and biomechanist synonymously.
Mechanist really looks at the human body, and we look at the response of the human body to forces and accelerations. We apply traditional engineering, but to the human body. So a mechanical engineer, for instance, might look at a piece of steel, and you know the dimensions and size of the steel. If you apply a force in a certain direction with a certain magnitude, that steel will bend and eventually it'll break. Was a biomechanist or biomechanical engineer, I do the same thing, but I look at the human body. how much force has to be applied in what direction to get a specific type of injury, whether it's a fracture of your humerus, a concussion, intervertebral disc injury. Any type of injury has what we call an injury mechanism. So we look at the response of how the body reacts to forces in different environments. Ultimately, our hope is to actually help prevent and mitigate accidents, motor vehicle incidents.
I have a few books that I have some burning questions about because I just can't figure out the mechanics. Could we just do like a lit review? Because there's things I'm looking at and I'm like, that would definitely cause some type of injury, but it seems to all just be fine. So I have questions. I'll
We
send a
look at the
list.
design of airbags and seatbelts, sporting equipment. How can we reduce concussions and injuries associated with that? So ultimately, we try to
Chat's like,
figure
yes,
out how to
please.
make the environment and the world safer for people in whatever type of interaction you might have.
Is that sometimes called injury causation analysis?
It is. That's one aspect of it. Injury causation analysis is looking at how an injury occurs. So if someone sustains an injury, as a biomechanist, I can look at the events surrounding that incident and determine how the injury occurred. Now, how someone was positioned, how much force had to have been applied to certain parts of their body to actually produce a given injury.
Why is injury causation analysis important in the broader field of biomechanics? Why do you want to know the causation
We would
of
like
certain
to
injuries?
do force
Well,
analysis
it's
too.
like I
That's
just
all I'm
said,
saying.
our main goal and interest is to really mitigate and prevent injuries from occurring.
We also
so
would
in order
like
to
to
do that, you
prevent
have to know
injuries
how they occur.
from occurring.
You have to know, for instance, hockey, we do a lot of work with the NHL, how certain injuries occur, cervical injuries, concussions, shoulder injuries. So if your intent is to prevent injuries in certain settings and situations,
Hockey's its
you
own
have to study
genre.
how the body reacts, how those injuries are created, and then you can determine or attempt to determine how to prevent them from occurring in different events and situations.
What sort of contracts or commissions does ARCCA routinely engage in?
We have a number of different contracts. We've worked in the past with the United States military. I helped design what we call the energy absorbing seat for the MRAP vehicles.
Oh my God, the siren.
For the MRAP, which are the mine-resistant, ambush-protected, armor-plated vehicles that they had over in Iraq and Afghanistan. And the issue there is that when they go over an IED, an improvised explosive device, it would blow the vehicle up off the ground. So we were seeing very severe accelerations
Spinal
and
injuries,
forces going
right.
through the vehicle, through the seat, into the soldiers' spines. And we're seeing severe spinal and head injuries as a result of that. So we worked with the military to design what we call an energy absorbing seat design. As the vehicle gets blasted up off the ground, the seat's designed to absorb that energy and that force from the blast and the movement of the vehicle and help protect the soldier's spine. We also, as I said, do a lot of work with the NHL. We work with the Department of Player Safety there, the National Hockey League. We look at the equipment, we look at helmets, trying to help prevent concussions, skate guards, how to prevent cuts and injuries
Didn't
due
they
to
rework
skates.
how the
One of the big
glass
things we
works, the
did was
rink?
actually redesign part of the rink.
Yeah.
It used to
remember
be
that from
at
last time.
the player area. At the end of the player area was a 90-degree stanchion of plexiglass. And what was happening was players were getting checked into the boards at the player area and then slamming up against the glass. And they were sustaining head and cervical injuries. I've mentioned before, it was actually the Boston and Montreal that caused the NHL to take a look at it, the hit of Chara on Pacioretty. He sustained a concussion and a cervical fracture. So they gave us part of the rink to the Winter Classic, the outdoor contest, and we used crash test dummies, hybrid 3, 50th percentile male dummies. And
So you used hybrid 3 50th percentile male dummies for the NHL? Because it's sufficient for hockey players? Okay.
threw them into
Seems like
different
it's fine.
configurations of glass. And ultimately, the new design
Okay. How did you just start throwing the crash test dummies into the glass? Was there a cannon? I'm so curious. We just started throwing them into the glass. Okay.
started the rink to the Winter Classic, the outdoor contest, and we used crash test dummies,
Threw 'em into the
hybrid
glass.
3 50th percentile male dummies, and threw them into different configurations of glass. And ultimately, the new design that we developed is a curved piece of spring-loaded Lexan or plexiglass. So now when the players get checked into the boards, it absorbs that impact and they glance off of it. And it's helped prevent and pretty much mitigate any type of head or neck injuries as a result of player interaction
They
at that part of the ring.
spring-loaded the ring?
Hockey players tend to be pretty big guys, right?
That's
They
cool.
do, yes.
You said you used the 50 percentile hybrid 3 as a crash test.
Right. Keep reading, Emily. That's exactly the next question. Used 50th percentile hybrid 3s to mimic NHL players, and that was sufficient? That was sufficient? It wasn't like 26% not sufficient? Weird.
Test dummy and ATD to do your work in furtherance of the NHL contractor commission, correct?
That's correct.
Did you need to use a hybrid 3 that was the same size as these big,
Right.
tall, 6'4", 230-pound hockey players?
No, not at all.
Why not?
There's a 95th percentile male dummy, which not many people have or use. The 50th percentile male is basically the gold standard for crash test dummies.
Look at that.
And you're probably most familiar with it if you see automotive manufacturers and the ads on TV where they put the crash test dummy in the car and run them into walls and flip them over. Well, they use the 50th percentile for all of those tests. And then they scale the actual injury assessment reference values to different size people. So they record the force off of that.
Also, by the way, I have huge issues with this because it leaves people who are not in size with the 50th percentile male dummy, and they don't do them with female size dummies, and they don't do them with smaller ones, which tends to leave women more injured in vehicle collisions because they always use the 50th percentile male dummy for testing things. Can we just use 2? Because the automotive industry doesn't, they just use math, but they don't actually test it. Can you use some of the smaller ones too? That would be great. That would be fantastic. That would be fantastic. Because there's like kids are in cars and like other people are in cars that aren't 50th percentile males. So I have issues, but that's with the vehicle industry, not with ARCCA. So I'm going to stop yelling because also like maybe just, can't we just use more? That's all. So.
And they might say, well, for the 50th percentile average person, you can sustain 180 Gs of acceleration to the head before you see a severe injury. And then they'll scale that and say,
They scale
well,
it
the
with
hybrid
math.
3 has to record, say, 300 Gs before someone twice that size gets hurt. So you just use one size
then they
dummy and then
scale
you
it up.
scale that to whatever
They
size
don't
person
scale it
you're
down
looking at
nearly
when you
enough.
actually investigate.
Is that undertaking of mathematical scaling, is that an industry standard in biomechanics?
Absolutely. And I mean, it's set forth in NHTSA, the National Highway Traffic and Safety Administration. They said
Bodies come in different sizes. Stop using math to scale them. That's all. Just more diversity in the testing. That's all.
well, the government sets the federal
I'll go
motor
yell at
vehicle
NHTSA
safety
later.
standards, and that's all the crash tests that vehicles have to go through. And during those tests, they have to
And the
ensure
government.
that the values on the dummy, on the head, on the neck,
We'll
on the
just go yell at
spine, on the
everybody.
arms are below certain values to ensure that they're safe at specific speeds. And they
Right.
scale, they have a certain papers, a lot of papers actually, which talk about scaling the values for different size people.
Is that an accepted methodology in the scientific community?
Oh, it certainly is, yes, sir.
Dr. Rentschler, do you specialize in any particular research and analysis at ARCCA to evaluate the relationships between crash injuries and crash forces?
I do, yes.
What about kinematics?
Kinematics is one of the specialties, yes, sir.
Fancy word, probably nobody knows. I didn't know it before I met some of the folks involved in this case. What does kinematics mean?
Kinematics is just motion of the human body. So it's looking at how the body moves in different situations. Whether you're in a vehicle and it hits a wall, how does your body move? It moves forward. Will it load into the seatbelt? Does the airbag deploy? Or if you're a pedestrian and you're struck by a car, how does the body move as a result of that interaction? That allows us to look at the loading to the body. forces are exerted on someone's body because their body's loaded by different objects or different forces. So kinematics is one of the first steps.
Yep.
If you're going to look at injury causation, you have to determine the kinematics of an event.
What are human tolerances?
Can we talk about distributed loads again? I've got questions.
Human tolerance is really just looking at how much force it takes to cause an injury. So there's been generations of testing to look at different forces. For instance, the humerus, the upper bone in your upper arm. How much force does it take to cause that fracture? They've tested the cadaver bones. There's a lot of research for decades out there looking at different parts of the body, the ulna, the radius, the two bones in your forearm, skull fractures. Almost any type of injury, again, has an injury mechanism, and in order to determine how it occurs, we have to look at tolerance. How much force can the body withstand before you start to see a specific injury occur?
Doctor, how long have you worked at ARCCA?
I've been with ARCCA now for about 17 and a half years.
How many cases have you been a part of in terms of investigating or conducting crash injury analysis?
Over my whole career, probably thousands of cases. I've been doing this since 2004, so for about 21 years total.
Dr. Rentschler, are you able to estimate how many of those cases that you just talked about, those potentially thousands of cases, have involved motor vehicle pedestrian circumstances?
Oh, I'm sure over the year there's been hundreds of cases. A lot of them are motor vehicle accidents, but certainly a large percent's automobile pedestrian type impacts.
What education,
they work in
training, and
civil and
background
criminal. That
qualifies
makes
you to
sense.
perform the duties that you just told us about as the Director of Biomechanics and Human Factors at ARCCA?
I appreciate.
Well, I got my
Look, if you are questioning witnesses in this way, where you give a little background on why they're here and then do their background training and experience, helps the jury already be bought in instead of going through all of their background training and experience first. Why are you here? What do you do? Do you have a cool job where you do cool shit? Tell me about the cool shit that you do. Now tell me about why you're qualified to do the cool shit. I hate it when lawyers do it the other way, because you're like, okay, but what's the point? The jury knows at this point, but it's just so much easier to do it this way.
Yes,
It is
in
my
mechanical
preference.
engineering with a minor in biomedical engineering from Carnegie Mellon University in 1995. I then went on to get my master's in bioengineering and biomechanics from the University of Pittsburgh in 2002. And then I got my PhD in bioengineering and biomechanics from the University of Pittsburgh in 2004.
2004. Thank you. Are you a member of any professional associations associated with your field?
He was just like,
I'm a member of SAE.
I like being smart.
The Society of Automotive Engineers, as well as the American Society for Mechanical Engineers, ASME.
Are you also a reviewer for an outfit called Archives of Physical Medicine and Rehabilitation in Biomechanical Engineering?
I have. I've done peer-reviewed articles for those journals before, yes, sir.
When you say peer-reviewed articles, you're
He's like, and I actually took physics in 4th grade. So whatever to Dr. Wolf Dimples, not hungry like the. So I'm just teasing. They are very smart.
Peer reviewer?
That's right. If you want to submit a scientific article to a journal, you'll write that manuscript and then submit it to the journal, and then they'll send it out to other experts or peers in that same field, probably 3 others normally. And then they'll review that transcript, send it back with any suggested revisions, and then usually the author will make changes, send it out again, and that's how it gets accepted. Usually it goes through several different iterations before a paper is actually published.
Have you received any additional training following your PhD, formal training or otherwise, in the field of biomechanics?
I have, yes.
Describe some of that for us, please.
Throughout the years, I've taken classes through the NTSB, National Transportation Safety Board, as well as SAE, as I said, Society of Automotive Engineers, and at different universities, Virginia Tech, different seminars and classes with respect to biomechanics.
Is that normal to, even for someone at your education level, a PhD, to take continuing education to stay up on issues in your field?
Yeah.
It is. You take continuing education and then also just working with your peers and when you work in a certain company, for instance, at ARCCA, we don't do just litigation, we do the research and development. We have an epic sports branch at ARCCA where we look at sports performance of athletes, how to help them perform better, whether you're a baseball player or volleyball player. So
No water
it's really the
polo?
experience and the work that you do that
We're
also
not getting
helps
wet?
keep
What's
you up
going
to
on?
date with technology and the different
I have questions.
different aspects of that field.
Does some of that additional education include biomechanics of high-impact injuries that was offered by the NTSB?
I'm teasing, Chad.
That's correct, yes.
Water stuff is a
Methodology and
whole
techniques
different
of crash data
situation.
retrieval offered by IPTM?
Correct, yes.
What is the IPTM?
That's the Institute for Police Technology and Management. It's actually a school down in Jacksonville, Florida. That
The Google moderation is so mad about the wet comments. I see them, chat. I'm so sorry. I'm trying to grab them, but Google's not a fan of water sports, apparently. But there are injuries. But trying to deal with the mechanics of those injuries would be different because water, but bones get broken, soft tissue damage. But yes, he's just like, volleyball. Isn't it always volleyball?
offers basically vehicle crash reconstruction and biomechanical classes.
What about human factors in traffic crash reconstruction, also offered by the same outfit?
Yes.
Did you take a course in automobile safety and injury biomechanics from, is this the one from Virginia Tech?
That's correct, yes.
Okay. Did SAE offer a course in injuries, anatomy, biomechanics, and federal regulations?
Yes, that was in Detroit, I think, where SAE is based.
And you took that seminar as well?
Yes.
What about vehicle accident reconstruction methods offered by the SAE?
He also didn't talk about gymnastics.
I've taken that class before, yes.
Linear momentum analysis offered by CAARS?
That was, yes, in a class out in California.
Motor vehicle accident reconstruction offered by SAE?
I've taken that class as well, yes.
Advanced collision investigations out of California law enforcement?
Yeah, I believe that was a 2-week class I took. That's the introductory class that they give to the sheriff's department and police officers out in California.
And what about the post-collision
Just
passenger
like for
vehicle
funsies?
inspection and seatbelt analysis offered by CARS, CAARS?
I've taken that as well, yes, sir.
Have you published in peer-reviewed articles and book chapters? You said you were a reviewer. Have you actually published yourself along with you and your colleagues?
I have published, and that was mainly when I was in graduate school, doing graduate work. I worked at the Human Engineering Research Lab. We helped people with disabilities, so we looked at people in wheelchairs, manual wheelchair users, looked at the forces acting on the arms, how to help reduce injuries, rotator cuff tears, carpal tunnel syndrome, things such as that. So I did publish primarily when I was in graduate school at the University of Pittsburgh.
When you were in graduate school, approximately how many publications
That's a
did
very
you,
cool focus.
participate in, either yourself or with colleagues?
Probably 10 or 12 papers and then some abstracts and I believe a book chapter as well.
Have you been qualified in other courts to testify as an expert in the area of biomechanics and accident reconstruction?
I have, yes.
Approximately how many times?
Oh, I've testified throughout my career probably over 150 times in both state and federal courts throughout the country.
I want to talk to you for a second, Dr. Rentschler, about how you began working on this particular case, the case that's before the bench.
I remember he
When
talked
were you
about the
initially
wheelchair
retained in connection with this
ergonomics last time. Also, Amy, all the wheelchair ergonomics in the world don't help if you just keep shooting them downstairs and stuff. Friend, just saying. But I remember them talking about the wheelchair ergonomics during the last trial too. It was a really cool focus. He has a very interesting career. I really love. I just want to hear more about his career. We need to move on to this case, but it's just really interesting stuff.
We
like
were
it.
initially retained. I believe it was for the first trial. It was I believe. Maybe it was the fall prior to that actual trial that was last year.
All right. When you were, by the way, initially,
The prior
were you
proceeding.
hired by the defense?
No, we were not.
Were you hired by the Commonwealth?
We were not, no.
Was that a separate agency that hired you?
It was, yes.
It wasn't an insurance company, was it?
It was not, no, sir.
Okay. What were you initially asked to do by this separate entity?
Initially, we were kind of constrained in what we were asked to do and to review, but we were asked to evaluate whether the injuries
kind of constrained
sustained by Mr. O'Keefe were consistent with being struck by the Lexus.
And who at ARCCA?
I think that's very helpful. This is the first time we've heard them say really what they were looking at. We were hired to look at if the injuries to John O'Keefe were consistent with being struck by the Lexus. I think that's the clearest we've heard them explain what they were looking at. And that's incredibly helpful.
What were you initially asked to do by this separate entity?
Initially, we were kind of constrained in what we were asked to do and to review, but we were asked to evaluate whether the injuries sustained by Mr. O'Keefe were consistent with being struck by the Lexus.
And who at ARCCA was assigned on the team to undertake this commission?
There was myself, Dr. Dan Wolf, and I believe Mr. Scott Klein was another engineer who was involved.
And did all three of you join in the analysis that ultimately ended up in a report that you authored, or the three of you authored together?
We did, yes, sir.
What materials did you review in furtherance of your initial consultation in this matter?
Obviously, I looked at the medical records. We looked at photographs of the vehicles, information about the vehicle, photographs of the actual incident scene, various information pertaining to the Lexus itself.
You know who Dr. Dan Wolf is?
I do, yes.
Is that the other person, the Dan Wolf, the Dr. Wolf that you just mentioned?
That's correct, yes.
Did you and Dr. Wolf look at basically the same set of information? You were provided the same set of information?
We did, yes. We were provided a tranche of information that all three of us looked at. Yes.
You might get the word of the day, sir.
Can you explain the difference between your area of expertise and Dr. Wolf's area of expertise? I don't want you to get into his analysis, just what area he covers. In other words,
excuse me, Alan Jackson, the chat, the honorable chat, we're just giving it over to the chat. Chat is now court. The honorable chat would like to clarify if that is Dr. Dimple Dan Wolf. So we just need a little further clarification.
The Lexus and pedestrian, Mr. John O'Keefe, correct?
Correct, yes.
What's the difference between the analysis that you undertook
You guys are funny.
and the responsibilities of Dr. Dan Wolf?
So Dr. Wolf really concentrated looking at the vehicle itself and the damage to the vehicle, the damage to the taillight, which is really the only damage we have to that vehicle. And so his analysis pertained to evaluating the force associated with producing that damage, what's consistent with causing that type of fracture and damage to the taillight itself. Whereas my part of the investigation was really looking more at the injuries and looking at Mr. O'Keefe and his kinematics and his alleged or any interaction between him and the vehicle, and whether that would be consistent with his injuries as well as the damage that we see to the Lexus as evaluated by Dr. Wolf.
Did you ultimately issue a report, an initial report summarizing your opinions and your conclusions following your analysis?
We did, yes, sir.
About when was that report issued?
I believe it was sometime in February.
What year?
February of what year?
It would have been February of last year, 2024.
2024, okay,
Correct.
thank you. Were you able to provide an analysis, given the information that you had, were you able to provide an analysis for the biomechanical aspect of the analysis of the case?
I was, yes, sir.
All right. Did you review medical records and other materials?
I did, yes.
Did you make note of anything with regard to Mr. O'Keefe's injury or injuries based on what you reviewed initially when you began your analysis?
I did, yes.
Can you describe what you noted in terms of Mr. O'Keefe's injuries?
There were really just two basically different areas of injury. There was injury to the head. There was a laceration on the rear kind of right occipital region of the head, which resulted in fractures, an occipital skull fracture, which is the rear part of your skull, as well as basilar skull fractures that propagated up through the skull. And then there were injuries which were noted or diagnosed to be superficial abrasions along his right arm.
What is a subscapular hemorrhage?
Subscapular is,
Yes.
yeah, with respect to the head, is that what? Yes,
as it relates to the head.
Yes. Well, so when we talk about there's subarachnoid, there's pia hemorrhages, but basically they're hemorrhages, and scapular is hemorrhage under the scalp, but above the skull. So subdural is within on the surface of the brain, but scapular means that it's a hematoma or bleeding that occurs under the scalp but above the actual skull.
Did you note subscapular hemorrhage in your analysis of Mr. O'Keefe's injuries?
There was, yes, I believe there was extensive subscapular hemorrhaging.
What about skull fractures?
There were, as I described, occipital skull fracture in the back of the skull. That,
Sir, we've been told by other experts that it was the occiput boner. The Dr. Welcher said that was the occiput boner, not the occipital bone. Just saying.
that then propagated forward the calvarium as well as the basilar or the base of the skull.
You mentioned subdural hemorrhage.
He knows the name of the skull.
As one of the issues that you would look at normally. Did you note whether Mr. O'Keefe suffered from subdural hemorrhage?
He did, yes. He had sustained a subdural hemorrhage as a result.
And also subarachnoid hemorrhage?
Correct, yes.
What about bilateral orbital ecchymosis?
He did, yes, bruising along the eyes, basically.
What does bilateral mean? Both?
Bilateral means left and right, correct.
Did you note a 1 centimeter or approximately 1 centimeter laceration to the upper right eyelid?
There was, yes, 1 centimeter, yeah, and so, you know, that's a little less than half an inch laceration right above the right eye.
What about abrasions to the anterior and left aspect of the nose?
There were some abrasions on the nose and then I believe a few lacerations as well.
Laceration on the right anterior tongue?
The tongue was lacerated, yes.
You noted with regard to one of Mr. O'Keefe's extremities, abrasions along that extremity.
Superficial abrasions, that's correct, sir.
Describe which arm we're talking about and what part of the arm.
It was the right arm, and it was from the forearm up towards the top of the shoulder. And there were various abrasions what were diagnosed as superficial abrasions along that kind of posterior aspect of the arm, the elbow, right, forearm, and the upper arm.
When you undertake an analysis, do you use biomechanics and kinematics both to try to evaluate whether or not a specific set of injuries are consistent or inconsistent with a proposed set of facts? Or
a lot of you are asking about the injury to the tongue. They didn't talk about it much, but it's not inconsistent with a fall backward like that. But they have not talked about it. They're going through the injuries he noticed, but that didn't come up with the ME or any of the MEs. So they didn't get into it very much.
I guess I'll just leave it there, a proposed set of facts.
Yeah, I mean, those are basic steps.
Sorry about the
to
yawn.
look at how an injury occurs. I mean, first you have to identify the injury, and that's by looking at the medical records and determining what the diagnosed injuries are. And then you have to determine the kinematics and the kinetics associated with a certain event. So how did the person move? How was their body moved? Did they interact with anything? And how did that result in loading or force being applied to the body? Those are basic steps
we know too
of
much about loading.
Biomechanical injury causation analysis.
How did you go about undertaking those steps in this particular case?
So in this particular case, we looked at how those injuries are actually produced or created. So occipital skull fracture, you need a sufficient force. You need a force of around maybe 1,400 or 1,600 pounds applied at the back of the skull to actually cause a fracture like that. The abrasions, superficial abrasions, and an abrasion is basically rubbing or scraping or friction that kind of scrapes away the top part of your skin, the epidermis. You have the epidermis, the dermis, and then the hypodermis. An abrasion is just gets into the top epidermis and doesn't get any farther. Laceration is an actual tearing or ripping of the skin, usually down past the epidermis into the dermis. And so that takes either a blunt object or a sharp edge, depending on whether it's an incision or laceration, to actually produce that type of an injury.
Did you look at patterns of injuries on Mr. O'Keefe?
Yes.
Did you also, the other side of that handshake, did you also look at damage to the vehicle, physical damage to the Lexus?
We did, yes. Our goal or what we were tasked with was to determine whether the injuries are consistent with the damage to the car. So clearly, you look at how these injuries are created, what injury mechanism you need to produce them, and then you look at the damage to the car. Can you line up contact between where those injuries occurred and how they occurred with damage to the vehicle?
What kind of materials did you review, in addition to, I'm guessing, photographs?
Photographs, yes, autopsy photographs, as well as photographs of the vehicle and the damage to the Lexus.
What about medical records, hospital records, things of that nature?
Absolutely. That's the first step, looking at the injuries to find what the injuries are, what are the diagnosed injuries, as well as it's important to determine what injuries don't exist, because that's also helpful in determining whether certain impacts may or may not have actually occurred.
Did you receive a full file from the medical examiner's office in this case?
I did, yes, sir.
Did you also receive police reports, follow-up reports, witness statements, things of that nature in this case?
We did, yes.
Did you receive any data concerning the vehicle itself, contained either in police reports or follow-up reports or expert reports?
We did, yes.
Mr. Jackson, I was just going to ask you to slow down the cadence of your voice a little bit.
It's late in the day and I'm doing it again, aren't I? I'll slow down.
I don't think he was asking questions that fast, but then again,
I forgot where I left.
I don't have a very good threshold for fast. The court is asking him to slow down for the court reporter. It is very late in the day. I do not have a good threshold for how fast lawyers are going. So I didn't think he was actually going that fast, but I also regularly get told to slow down. So I also listen to everything at like 1.25 plus. So it doesn't sound it doesn't sound fast to me, but it's late in the day and the court reporter is probably exhausted. It has been a long day and the court staff worked mostly through lunch. So it's a lot, but it sounded normal to me.
But let me ask you sort of openly, was there anything else that you considered and analyzed?
But it is late in the day.
At least building a database from which you would build an analysis?
Well, yeah, I mean, we review all the materials that are provided. To look at all the injuries, to look at all aspects of the vehicle, damage to the vehicle, information about what the vehicle may have been doing. Any other evidence that may help contribute to looking at what either caused the injuries or what may or may not have caused the damage to that vehicle.
When you and your teammates undertook this analysis, did you even know who we were?
Initially, we did not. No, initially, I personally didn't know anything about the case, and we were asked not to do any research or to look up anything about it. We were given certain parameters, certain information, and that.
I appreciate that it's like, here is the car, here are the medical records, here are the photos. Can you tell us what happened?
Was it?
I appreciate that.
Did you follow those instructions?
I did, yes.
Yeah, I appreciate that approach.
The undertaking, the analysis that you did, was it in keeping with the accepted methodology or methodologies in your field of engineering?
It was, yes.
Did you ultimately reach some opinions and conclusions based on that initial investigation or analysis?
I did, and we did it at ARCCA, yes. Myself, Dr. Wolf, and Mr. Klein did.
Did you reach any opinions or conclusions with regard to the force required to produce the occipital skull fracture that you noted with Mr. O'Keefe, his head being struck by the rear tail lamp of the subject Lexus?
I did, yes.
And?
Tell me what those opinions and conclusions were.
Well, again, we determined by looking at research and tolerance values that it would take about 1,400 to 1,600 pounds of force to cause an occipital skull fracture. Now, we were tasked with looking at, again, could that result from impact with the car? So one of the things we did is we took a head form, the head from a dummy basically that's
Right.
instrumented with accelerometers.
Dropped it.
And we dropped it onto a taillight cover to attain a speed of 15 miles an hour. And so that would be comparable to the vehicle striking the head at 15 miles an hour. And I concluded a few things from that. A, that the force wasn't sufficient, or the acceleration wasn't sufficient to produce enough force to cause a skull fracture at 15 miles an hour. And also, when you look at the position and configuration of the occupant, it really wasn't possible to get a skull fracture by hitting the taillight and not sustain any other significant
injuries.
fractures.
Right.
For instance, where the taillight's positioned to have an impact to the back of the head, you really couldn't have someone positioned in such a manner
They
to
wouldn't
strike just
also
the head and not have
neck and
subsequent
injuries.
concomitant injury to the neck or any other part of the body. So my findings with respect to the skull or the occipital skull fractures was that it likely did not occur as a result of contact, specifically with the taillight cover on the rear passenger side of the Lexus.
So as to the question of whether Mr. O'Keefe suffered the occipital skull fracture as a result of being hit by the tail lamp at 15 miles an hour, were you able to scientifically rule that out?
I was, yes, sir.
Was that to a reasonable degree of scientific certainty?
It was, yes.
Did you reach any opinions or conclusions regarding the abrasions on the right arm that you noted earlier on Mr. O'Keefe's body?
Yes, I believe my conclusions with respect to the abrasions are that it was inconsistent with contact to the tail light, and that not only that those injuries are inconsistent, but you would expect additional injuries, likely fractures to the hand and or the forearm, depending on the actual speed of the vehicle.
Other than the expectation that you would see fractures or other damage to the arm, what was the basis for your opinion that the linear abrasions would not result from impact with a non-damaged taillight traveling in reverse?
Well, you have to look at the kinematics associated with that, and that in order to get just superficial abrasions, that doesn't take a significant amount of force, but essentially that to have an arm contact the rear of the car, and we weren't really given any theory of how the arm contacted the car.
Right.
So initially,
So they were trying to figure it out.
We weren't privy to any theories or allegations of how this may occur. So just generally speaking, looking at the
I really appreciate that what it was is this is the information we have. This is what the car looks like. This is what the injuries are. This is what the medical records show. Can you tell us what happened? I really appreciate that approach. And I think he's breaking it down well of this is what we started to rule out when we were asked, can you tell us what happened?
the arm, how it would contact the car.
I like the ruling
and
out
subsequent,
process.
Movement and interaction with the light cover. My opinion was that the injuries would be inconsistent, or the injuries that Mr. O'Keefe sustained on his right arm and didn't sustain would be inconsistent with actual interaction with the taillight.
Doctor, were your opinions and conclusions, along with those of your colleagues, reduced to a report?
They were, yes, sir.
Was that report, to your knowledge, ultimately turned over to both the defense and the Commonwealth in this case?
To my knowledge, it was, yes, sir.
I'm going to change gears for a second and bring us forward to the spring of 2024, after February of 2024, moving into the start of 2025.
Those were the
Did
prior
the
opinions
defense
of
at
ARCCA
some
that we
point
just
reach
went
out
through.
to ARCCA and contact you and Dr. Wolf?
They did, yes.
That was back in 2024 after the spring, correct?
That's correct, yes.
At some point, did the defense engage you specifically to testify
Yes.
this year?
This year?
This year, meaning
Yes.
This
trial.
year.
For this trial, yes.
Okay.
Yes, correct.
Were you asked to conduct further testing in furtherance of your potential testimony in this trial?
We were, yes, sir.
And were you provided additional materials from the defense in furtherance of your potential testimony and your testing?
We were, yes, we were provided additional material with respect to, yes, the theory of how this may have occurred and how Mr. O'Keefe may have sustained his injuries, allegedly.
Included in the materials that you were provided in anticipation of your testimony in this case, in this trial, were you provided anything
They're not going to get
from
through
a
much
company
more than
called
this today.
Aperture?
We were, yes.
What were you provided from Aperture?
We were provided a written report from Aperture, a PowerPoint presentation, about 140 some pages from Aperture, and then file material, I believe, what was reviewed and the results of some testing that Aperture had conducted with respect to this case.
Was it your understanding that the Aperture PowerPoint was authored by a particular individual?
Yes, sir.
Who authored that PowerPoint as far as you knew it?
As far as I'm aware, it was Dr. Judson Welcher.
Your Honor, may we approach briefly?
Okay.
I imagine it's going to be, and is this a good place to stop? Because they are getting very close to the end of the court day, and now we're going through a larger chunk of testimony that they're going to want to do the larger chunk of testimony together, I would imagine. So they are approaching, but I suspect we are right about at the end of the day. I'm going to zoom as much as I can. There is not. That is a very long zoom. Can we just, how long are y'all at sidebar?
Because we did. That was about scheduling.
The court says that was about scheduling. Okay, what's the schedule?
So jurors, that was about scheduling. We picked up a lot of time today. I think it was because we did spend less time at sidebar and less time doing things outside your presence.
I just don't believe it anymore. We picked up a lot of time today. It's not like we're driving to try to beat the estimate on Waze. Like, what do you mean we're picking up a lot of time today? What? This is the end of the day. We picked up a lot of time today. Okay.
So we're back on track, and we're going to let you go for today, and we're expecting a full day tomorrow. I can tell you, the lawyers tell me that we're definitely winding down. Okay, so please, those same 3 cautions, do not
That I do
discuss this
believe.
case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it and let us know. And please continue to be very careful with your social media use. So we'll see you ready to start at 9 o'clock.
Okay. Picking up time. Full day tomorrow. They might be done with evidence tomorrow. They really might. So I'm going to see if they go back on the record. They might. I can barely hear something. I'm gaining this up just a
You're
little
all
bit.
set, Dr. Ensley. I should have told you. I'm sorry.
No,
See you tomorrow morning as well, sir. Okay? Thank you.
All right. The court's excusing Dr. Welcher to talk to the
All
attorneys
right.
briefly.
So first of all, anybody object if I give Ms. McLaughlin back the paperwork on the State of Rhode Island versus Michael Patino transcript or whatever she was giving me? Any objection to that? All right. Thank you.
Any objection if I just give back Ms. McLaughlin all this stuff that I didn't let them ask about? No? Great. You didn't get to ask about it. Here it is.
So, Mr. Jackson, for purposes of your edits, so the text will be removed from 5, 6, 8, 9, 23. The word measurements, I think, is perhaps the only word
Those
there.
are slides.
24, 31, 32, 33, 34, 46, 47, 54, 55, 56, 58, 66, 67, 68, 69, 71, 72, 73, 74, and 75, and 76. Separately, pursuant to what will be an upcoming evidentiary ruling on whether foundation has been made, if you could separately have a way to exclude, if it becomes appropriate based on whatever ruling, based on the foundation that you're going to attempt to put, slides 9 to 23. Now, as I said to you at sidebar, once you do this, or if you talk to the Commonwealth, if there's no objection to some of those numbered slides that I said needed to be edited, if the Commonwealth agrees that they come in, you can go ahead and put them in, because I would allow them if it's by agreement.
Thank you.
Okay? All right. So do you expect that we will finish with Dr. Rentschler tomorrow?
I do, Your Honor.
Okay, Mr. Brennan?
I don't think I'll be as long as I was with Dr. Wolf.
Okay.
Depending on how it goes, if he has an hour and a half, I expect that'll probably be about an hour, maybe an hour and 10 minutes.
Okay. All right. And then we'll figure out where we are Thursday. It seems that the case may be ready to go to the jury Friday.
Yeah, it does.
Maybe Monday at the latest.
What?
But that's...
By Monday. Based on our
Does that seem like a fair estimate to you, Mr. Brennan?
I think we'll be ready Friday.
Okay. All right. So we'll see. Okay. All
When
right,
are you gonna
thank you. We'll
wait?
see
When are you
everybody
gonna do the
tomorrow
charge?
morning.
When are you gonna do the charging conference?
Does that seem like a fair estimate to you, Mr. Brennan?
I think we'll be ready Friday.
Okay. All right. So we'll...
Oh, I think the defense prefers Monday. I'm going to back that up. I want to hear what they say again, because they are hard to hear. I'm going to gain them up a little bit.
Okay.
Depending on how it goes, if he has an hour and a half, I expect that'll probably be about an hour, maybe an hour and 10 minutes.
Okay. All right. And then we'll figure out where we are Thursday. It seems that the case may be ready to go to the jury Friday, maybe Monday at the...
That's 2.5 hours of testimony tomorrow. And the Commonwealth said they had about 2 to 3 hours of redirect. They should have their witnesses there by lunchtime. Take lunch an hour earlier and just do the rebuttal case after lunch. And then you've got all day Thursday to do the charging conference. It's Tuesday, right? You can finish this, give the jury the day off Thursday. Ask me, Emily, do you have any sense of time? No. What about scheduling? Also, no. But it seems that based on the estimate the lawyers have given, if you do a full day Wednesday, you should be mostly done with the redirect witness, not the redirect witnesses, with the rebuttal witnesses, and you can do the charging conference on Thursday, and then they can do the full day Friday for closing. Why not? Okay. We'll talk about the schedule in just a second. I want to hear them one more time.
The latest, but then we'll figure out where we are Thursday. It seems that the case may be ready to go to the jury Friday, maybe Monday at the latest, but that's...
by Monday. Based on our
Does that seem like a fair estimate to you, Mr. Brennan?
I think we'll be ready Friday.
Okay. All right, so we'll see. Okay? All right, thank you. We'll see everybody tomorrow morning. Yes.
Should I have Dr. Welch in for tomorrow or wait?
Yes.
Tomorrow's Wednesday already.
Yeah, it's Wednesday already.
Can we, Mr. Jackson, can we reevaluate that mid-morning or the luncheon break and see where we are, whether we need Dr. Welcher here in the afternoon?
Of course.
Okay. All right, we'll do that.
I think Mr. Alessi would have one issue he wanted to address the court.
Yes, Your Honor. With regard to various exhibits that Your Honor said would be admitted based upon the issue that we had with...
Alessi is now bringing it back around to the exhibits that are supposed to be admitted with regard to John O'Keefe's hoodie that the court never seemed to admit. And the court said she was going to wait till the charging conference to talk about the further instruction to the jury. But now we're getting back to conversation about those exhibits that didn't seem to get admitted.
With regard to the Exhibit 88, Your Honor said you would...
Yes, we'll put those into evidence.
Thank you very much.
Okay.
That was the only item pressing for today.
Yeah, I said yesterday they'd come in, they're coming in.
When?
Okay, so those will be in evidence. Mr. Brennan, you were on notice yesterday that I was letting those in. Okay. All right, we're all set. We'll see you tomorrow.
All rise for the court, please.
Are you just going to mark? When are we marking them?
Goodbye.
I mean, I don't blame Alessi at all for being like, excuse me, are we going to do this though? Because I'm nervous that it's not going to happen. Yeah, I understand why Alessi's nervous it's not going to happen. I don't blame him. At the end of the day, on day 30, yesterday and today have been frustrating, disjointed, and there's been a lot of starts and stops. There is so much case left to go, and yet we are almost done. The defense is on their last witness, Dr. Rentschler, who is the biomechanist from ARCCA. And today the defense briefly went through his prior findings from when he was asked to investigate the case. What I found very interesting is it's really the first time we've heard anyone from ARCCA state clearly what they were asked to do by, well, the feds, the FBI, the U.S. Attorney's Office, whichever entity hired them, those entities work together. But they were asked to take a look at John O'Keefe's injuries and determine whether or not John O'Keefe's injuries were consistent with being struck by the Lexus. We assumed that that's what they were asked to look into. Could this happen? But it's really helpful to hear them explain. We went through the injuries, the medical records, the photos of the car, the photos of the scene. We didn't know what any of the theories were or what the thoughts were on how this happened. And we were essentially asked, hey, these injuries, this vehicle, this scene, can you tell us what happened? And can you tell us if these injuries are consistent with being hit by the vehicle? And he went through how he was trying to rule out what could have happened and the way they evaluated that, including taking one of the crash test dummy heads and seeing if the head hit the back of the taillight with like the taillight going about 15 miles an hour, the car going about 15 miles an hour towards the head, if you could recreate those injuries and the skull fractures that John O'Keefe had without, he said, concomitant injuries to the neck or the rest of the body, and trying to figure out how could this substantial and significant injury to the back of the head happen from a collision with the vehicle? And then how do the arm injuries happen? Because it's not just the injury to the head. And he was saying he found that the arm injuries were also inconsistent with being hit by a Lexus, which was ARCCA's ARCCA's findings from the first trial, which the shit's out of the horse on that. And it's just first trial, this trial at this point. It's just, that's where we're at. So we got through his background, the things he's done at ARCCA, what a biomechanist or biomechanical engineer does. We talked a little bit about force and load. We definitely didn't have any conversation of spreading the load. That didn't happen. And we didn't get to talk about, the force involved in things like water polo, frozen water sports. Yes, hockey, lots of conversations about hockey. But we didn't get all the way into his testimony because there were still rulings outstanding from the court about his PowerPoint presentation. And the court went through and issued rulings saying that the text needed to be taken out of a whole number of the slides that were objected to by the Commonwealth. And so overnight, the court, it seemed, asked the defense to have two versions. Like, hey, there's still a ruling pending on this number of slides. Let me see. I've got the exact grouping that a ruling is still pending on. We don't have the slides, so we can't really tell. But the court said there was still a ruling, as I'm moving, the court said there was still a ruling pending on slides 9 through 23. And so if there was a way to have the presentation edited with the text being taken out of all of the items that she listed that had been objected to prior to the break, where Brennan went through one by one, objecting to the text, and then said separately, after editing the text out of all of those, could we also have a version where slides 9 through 23 may come in, may not come in, depending on foundation. So we'll see what, if any, PowerPoint slides, I almost knocked over my remaining coffee. What, if any, PowerPoint slides come in tomorrow? When we get into the rest of Dr. Welcher's testimony, it seems the defense has estimated they have about an hour and a half left of Dr. Welcher's testimony. The Commonwealth said they have about an hour of cross-examination. And then Will we see Dr. Welcher tomorrow after Dr. Rentschler is done testifying? Because there was some conversation about whether Dr. Rentschler, no, that's who's on the stand, Dr. Welcher, this is going to be painful. Dr. Welcher needs to be back in court tomorrow after Dr. Rentschler testifies for the Commonwealth's rebuttal case. And we know that the Commonwealth has 3 rebuttal witnesses. 2 of them are very quick about swabbing John O'Keefe's hoodie, and Hartnett, who swabbed the hoodie, is going to be the perfect person for the defense to ask about when the cuttings happened and to show the jury that picture that the hoodie did not have damage to it from January 29th. That'll be one of the last witnesses for the Commonwealth, which gives the defense on cross kind of the last crack at, hey, remember, those holes in the hoodie weren't there. We also saw something really interesting today that we have not seen in this trial. I mean, me daily, but the jury, it seemed, asked a question to one of the bailiffs who went and asked the court. And then the court instructed the jury that when the video was stricken out of testimony during the Commonwealth's cross-examination of Dr. Laposata, that didn't mean that the video was out of evidence. It means that the questions to Dr. Laposata about the video at the 29 miles per hour where Rescue Randy's arm was hit and then his foot was run over, the Commonwealth asked, did you see any impact from a bumper in that video? And that line of questioning, any answer, and the video was stricken at that time. And the jury seemed to wonder what that meant. And I think when we saw the bailiff pass Alan Jackson as he was getting up to do redirect, that's what the jury was asking the court about, because the court gave a much more thorough explanation then about what striking the video meant. So it's the first time we've really seen the jury answer a question, but I can also understand the confusion with the way the court said the video is stricken, the questions are stricken, and you're to disregard it. And the jury's like, disregard what? But what it shows me is that the jury is paying very close attention, and they want to know what they can consider and what they can't consider. That's not a jury that's just like, oh yeah, it's fine, whatever you say. That's a jury that's like, wait, no, what does that actually mean as to this? You've never stricken a video before. What we've heard disregard that last question. They've heard it regularly, but they've never heard disregard all of this and asked about it. It shows that even 30 days in, to me, that this jury is paying attention. This jury is dialed into this case, and I'm sure they're ready to get this case to them. The court said at the end of the day, we've picked up some time today. I assure you we're close to getting the case to you. I think the jury is paying attention. I also think after 30 days, they are probably ready for the last few witnesses in this case because they've heard quite a lot, truly. But it will be interesting to see what the day looks like tomorrow. And then we're going to need to get to the charging conference. What does the charging conference mean? It's when they talk about the jury instructions. It's often called charging the jury. When you tell the jury what they're to consider, what the jury instructions are, those can take about an hour and a half or more to read to the jury. What are the jury instructions? What are they charged with doing? Ladies and gentlemen, you need to consider this evidence in this way as to these charges. It can be boring to watch. I get it. The jury instructions are one of the most critical parts of a case. The instructions that they get, the way that they are read, is incredibly important. So if, and I hope that it is, if the charging conference is streamed, we are going to watch it together. Well, I'm going to watch it. I hope you will join me. I can't say what you might want to do. I am going to watch it. I hope you will join me. So get the Law Nerd app because we are going to be watching that charging conference together. I hope that it is streamed. It is a critical part. The lawyers will be gathering those jury instructions prior to even starting trial, looking at the things that they want the jury to be told by the court. And we know that the court is going to wait to take up what Alessi brought up this morning with regard to the charge to the jury yesterday about the hoodie and the holes in the hoodie until the charging conference. So it seems that the defense might have the opportunity to then ask for a stronger charge to the jury within the jury instructions. That's also when we should hear the court take up necessary witnesses, i.e. missing witnesses, who the Commonwealth called, who they didn't call, and whether or not a jury instruction will be given about that. charging conferences are very important. I'm interested to see it. And at the end of the day, one of my biggest takeaways is that no matter what Dr. Welcher said, there were x-rays done at the autopsy of John O'Keefe. How in the world did Welcher testify that there were none done? Because what we saw with Dr. Laposata is that there are sure the fuck x-rays. I mean, they were printed out on huge pieces of paper and apparently also on thumb drives, but did the Commonwealth not give the x-rays to Dr. Welcher? And does Brennan not know that there's x-rays? What? It's going to be very interesting to see. So I suspect, I could still be wrong, but I suspect that we will see the rest of the witnesses tomorrow, maybe those 2 DNA witnesses, which will take like an hour, maybe in the morning on Thursday, and then maybe the charging conference the rest of the day Thursday. I think the court will kick about bringing the jury in for 30 minutes or an hour of testimony, but then you do the charging conference the rest of the day Thursday and do closing arguments Friday. The defense, when they were chatting, said Monday. I'm sure the defense would like their weekend to work on their closings. If the jury is not going to have time to hear the instructions, hear closing, and start to deliberate Friday, the court might punt it till Monday. So will this jury get the case Friday or Monday is unclear, but we are close to the end of this case. We're in the defense last witness, which means there's a lot of witnesses that weren't called in this case. And we're going to see the rebuttal witnesses starting likely tomorrow. So stick with me in the Lawnerd app. Even though there are not that many days left, there's a long way left to go in this trial, and the jury instructions are going to be helpful. The jury instructions are going to be, well, I think interesting. And I want to see if they argue over the lesser includeds in count 2, over how count 2 is charged, over what the verdict forms look like, over the missing witness, necessary witness instruction, over any instruction about the Hoodie, reasonable doubt. What other instructions do I think we'll get through? I'm interested to see if they ask to add anything else that's outside of the standard kind of set of jury instructions. So that's what I'm keeping focused on. I don't know if we're going to have much more information from Dr. Welcher on rebuttal, but now I'm real curious about those x-rays. Aren't you? All right, let's get to your questions because I am too. And Needham, I said missing witness, necessary witness / missing witness, same. So that's going to come up in the charging conference. But let's get to questions because today was so much. Today was so much stuff. The x-rays, though, are really just a big what the fuck to me. Just a big old what the fuck. Like, what? Like, just what? What is happening? Wendy, happy birthday. Good to see you. We have lots of June Lawners in the chat. It's good to see you. So good to see you. Thank you. Casey Cat asked if our lovely friend Amy is here today. If she's not, she'll be in the replay crew. And will text me and be like, what are you talking about with me taking my wheelchair down the stairs? Well, you share it on social. I didn't talk about anything that is not public information. Rain Cloud, this is a great question. EDB, is the jury allowed to weigh expert testimony against their own common sense, or do they disregard the common sense experience in favor of the expert witnesses? They get to choose how much weight, if any, to give to an expert. If they do not believe an expert, they can decide to yeet the expert. The jury gets to decide how they want to deliberate and what evidence they regard or disregard. And that goes for when they compare what 2 different experts say. They can choose which one to believe or disbelieve or yeet both of them and say, you know what, it's just kind of moot at this point. Adrian said, he said Bruins. I bet that got the jurors' attention. Yeah, the jurors were like, wait, Bruins, what? Valkyrie's messenger said, the witness from ARCCA reminds me of the scientist from Bones. I'm the king of the lab. Where is the cannon? I mean, they were just like throwing stuff at like hockey, what's the side of the rink called? My brain has stopped. The boards. It's very interesting. Very interesting indeed. April said, if the FBI was only investigating corruption, why would they care about whether or not she actually did it? Well, they would care for me. Okay, first of all, the FBI! Disclaimer. We don't know exactly what the FBI was investigating. We don't. But they have to determine if John O'Keefe was hit by a car to start to determine if the investigation into this case was proper, if they were investigating the investigation. You have to determine or try to determine what might have happened to see if the investigation and the determination the investigation made even makes sense. Because if the investigation makes sense, then it's a bit different for what they may or may not do from there. So that is a big part of it. So yes, it does matter about what can be proven, especially if they are investigating something that they may decide to charge, because the Fed charging standards are quite high. So they're not going to charge something that they can't show and show fairly easily, for sure. Abigail said, I love your coverage. Well, thank you, but I've decided I could never be a lawyer. I would lose my mind over the endless hair splitting. Yeah, there's times it's frustrating. I think the more the court micromanages, the more frustrating it can be, but I ranted about that at the end of stream yesterday, so I'm going to spare you all ranting about it again today. But yeah, sometimes you have to just let the lawyers lawyer. It's like when refs get over involved in a game. When refs get over involved in a game, you're like, just let them play. And I don't mean to minimize a trial, but it is the same. Let them do their job. Like, let them work. I see the role of the judge very much as the referee or the umpire. You call the balls and strikes, but you're not the coach. You're not the advocate, and you're not on the team. You're literally on the bench. Call the balls and strikes. Is it coming in? Is it not coming in? And move on. You're not on the field. That is it. So let the lawyers do their work. You can only rule on what you're asked. Don't get involved. Shortness said, is Lally on strike? If I were Lally, if you were Lally, what would you do? Lally's in like the fucking timeout chair. I don't think Lally wants to retry this case. Lally's not retrying this case, and he's just sitting there. I would be sitting there fucking playing Wordle or something. No, I wouldn't. It's in court in front of a jury. I wouldn't be doing that. In my mind, I would be. Lally is just like, you are not my problem. You are not my coworker. I can't imagine, and I wish I knew. I wish I knew how this all went down. I wish I knew how the decisions were made to charge what they charged and when. I wish I knew how the decision was made after this to do an immediate retrial without even taking a breath. I wish I knew what happened at the DA's office when Lally is no longer lead counsel. Was that his choice? Was that his boss's choice? What were those inner office workings? I want to know. And why did the DA decide what they needed to do is go outside their own office, bring in a defense attorney to try this case, oftentimes like a defense attorney? It's one of my primary criticisms of Brennan is the style of cross-examination, and the way he's presenting evidence is very much defense-like, but it's not his job to poke holes here. It's his job to present the evidence for the jury to decide. Not to say it could be this, it could be this, it could be this, it could be this. And that is his style. And it's just so much. That is his, it is his natural style. I want to know all the tea. How did this all happen? And what did Lally say about the retrial? Also, fighting with your bosses is a part of government work. What are they going to do? They probably can't fire you, but you know what they can do? They can put you in the timeout chair. Yeah, your bosses can absolutely put you in the timeout chair. So I think Lally's in the timeout chair, and he did deal with a couple of the scientific witnesses, and it was like a whole different dude. Like, his questioning was a whole different Lally. It's like, who's this guy? I don't know. But last time I feel like Lally had a chronological witness list, and he was just like, witness 1, witness 2, witness 3, witness 4, witness 5, and just went through every single conceivable person. And when I said the prosecution strategy of not calling every witness might bite them in the ass, it still well might. And we saw it with the hoodie. There were pictures that weren't put into evidence. That hoodie situation never would have happened with Lally. A, he wouldn't have asked about it because he didn't last trial. And B, those pictures would have been in evidence because he put everything into evidence. There were some things he could have left out. He didn't. He put everything into evidence. The jury can't say that they did not see everything. I don't know if Brennan ever worked as a prosecutor before. I don't. I didn't go looking into his background and whatever have you. I know he is a defense attorney who has had some high profile clients. That is what I know. I don't know if he has ever worked as a prosecutor, but I often find that juries have a different tolerance for defense attorneys and prosecutors. And if they feel like the prosecution is hiding something from them, they do not like it. And there's times when the jurors are like, why can't we see XYZ? And it's like, it doesn't exist. And they don't always know that. And they don't love it. So when the jury knows that there are all these other things outside of this case, they've heard so much of it, I'm sure they're a little bit frustrated. Aren't you all sitting here going, where the fuck is Proctor? Where the fuck is Proctor? How is the jury not sitting there going, what do you mean we're almost done? We haven't seen Proctor. I'm sure they are. So wild, wild, wild. Fortana said, I rarely catch a live stream, but I've learned so much through your coverage. Well, thank you. I'm a new mom and your back catalog is keeping me company through the long nights. I watched a lot of YouTube when my kids were little, going through the long nights. So you are welcome, Fortaneth. And this trial is also on a podcast playlist. If you want to listen in the background, that should be pretty easy to do. But yeah, where is Proctor? All of you in the chat are like, right? Where's Proctor? Where is he? So I don't know. I understand why they might not call Proctor. I can logic my way through what most of the lawyers are doing. But if I'm the jury, I'm just like, what the fuck? I want to hear from these people. What about the people who lived at the house? I want to hear from these people. I want to hear from them. I want to know what they have to say. But Highest Wolf, two E's, said, so no Proctor? No Proctor. No Proctor. No Proctor. No Proctor. So let's see. Ayana said, seeing you predicting questions, do you miss being a prosecutor? Appreciate your commentary. No, I don't miss being in court every day. I love my colleagues, but I still get to talk to them. And no, I don't miss being in court every day. I love being here with y'all. Nope. This is way easier. It's way easier. I have time with my kids. I don't have police protection on my house normally. It's fantastic. So no, I am very proud of the career that I had. I am very happy with the changes that I have made. I am not mad at all. So nope. Especially after the spinal fusions. That was much. Katie said, EDB, volleyball and water polo, same season, both badass. Also, water polo needs an emoji. I know water polo totally needs an emoji. P.S. You're a great teacher. Well, thank you. The cursing helps. The cursing helps. Jam Fam said, EDB, do you think you would ever go back to practicing law? Not beyond what I'm doing now, but you never know. There may be a case where the feds are like, hey, we're starting a reality TV division. We need some help. No, I think there's a lot of room in my profession for work around emerging technology. And I like the consulting work that I do. And I love making content with y'all. So no, I'm very, very interested in figuring out how the law is going to navigate emerging tech and how the rules are going to navigate emerging tech. And I think there's a lot of help that I can do in that regard. I also really like the teaching I do with lawyers and legal organizations about this new world of trials. And I hope that people understand the legal system a little bit better because of coverage like this, because I think it should be accessible. And if I am dealing with 1 million clients and not consulting, then I'm not doing this because I cannot do both. I love this. So Clody said, Emily, is your consulting business 100% consulting? Yes. In the consulting side of what I do, I just consult, but I don't do it very often because generally it will take me away from doing this and I don't want to do that. So I say no a lot. I mean, I say no a lot to a lot of things, but it's because I want to do this. It's like, hey, can you do this thing? No, I'm streaming. The law nerds and I need to chat. We need to chat about all the cases. I can barely keep up with the amount of cases we're covering right now. Just, it's so much. Doesn't this trial and judge feel like bad justice? Liam, there are definitely frustrating times in this case. 100% there is frustration. So am I going to quantify that? A lot of it is within the judicial discretion. And I understand how frustrating that is when it's within judicial discretion. It's frustrating. So a lot of times I am frustrated, for sure. Susie Q said, what kind of lunches do you think the jurors get? They normally have a couple places they order from locally, and they give their order to the bailiff either in the morning or at the end of the day. Sandwiches, burgers, salads, that kind of stuff. Stuff that's easy. EDB, question, do judges never eat either? It really depends on how much they're doing in chambers. But I imagine when they bring in lunch for the jury, they're bringing in lunch for the judge. That's not necessarily true, but it could be. But they also oftentimes will have, I don't know, a refrigerator and stuff in their chambers and bring lunch. But yeah, there are definitely times judges don't have enough time to eat because they're working. Oftentimes they will bring something they can eat with one hand, so they're working while they eat. Lawyers, if they're talking to experts and stuff, often don't have time to eat during trial. So it is a lot. Stephen, good to see you. Stephen said, as a neurodivergent learning and development consultant, I fully agree with Attorney Little. It is a lot of information dissemination to the jury and may not be retained by a jury via oral argument only. I agree with you. I think it should be allowed to be visual and auditory and whatever other way you can help the jury learn. And the defense has done a really good job with that this trial. And there's times we've seen the prosecution use more exhibits, but it's not as noticeable of a shift. We have seen a noticeable and conscientious shift from the defense bringing in more visuals. And there were times when Lally was particularly going through scientific evidence. I'm like, can you just show them what it is? Like, what is A? What is B? What is C? Just put it on the screen. Put it on the screen. It was so frustrating. But yes, I think lawyers need to be mindful of different learning styles. And it is difficult to sit there day after day after day. And it is a lot of information, and there is no instant replay. And these jurors have missed work, life, family for the last 30 days that they've been in court. It's hot. The seasons are changing. It's summer when there's a nice day outside. What they don't want to do is go walking into a courthouse again. It's a lot. I get it. And I feel for them. So I think making the learning easier for them, especially late in the trial, matters. Just matters. Kimberly said earlier in the chat, he's seriously going here when he has Proctor. I mean, there were times Brennan was talking about, so you look at all the evidence. I'm like, Brennan, is that what we're doing? Because there's a lot of things this jury hasn't seen. The jury has no idea about Higgins's phone. They don't know about the butt dials. There is so much that's not been brought into this trial. And I think some of it can confuse the issues. So I think the jury has a cleaner case to consider. And it gives room for the defense to point more clearly, not at all of these people did all of these things, but this is what wasn't investigated. This. Liz asked critical questions. When do lawyers go to the bathroom? Generally once at lunch. And that's about it. So generally once at lunch. The jurors did ask what spiked. Back to volleyball. The jurors asked what the strike video means. I think they really wanted to be clear. And I mean, my interpretation of that would be that the jury wants to make sure they can consider those videos. For sure. So it's been a frustrating 2 days, though. Arose. Emily, stop it. It's my brain. Arose. I've done a 1 hour closing in 3 days civil trials. Rare, but I have. 1 hour closings are incredibly short. I hope the court gives the attorneys more time. I don't see how you can close in an hour on a 30-day plus case. It's been 8 weeks of testimony. I don't see how you can close in an hour. I don't. I think they need more time. They need more time to explain the jury instructions. The jury instructions are convoluted in some of those charges. Today has been a lot. Today has been a lot. So, Julie asked, can the defense bring up on appeal, well, if they get there, the fact that the judge said the jury is annoyed of sidebars when she told them to go to sidebar for the objections? They have to go to sidebar for the objections. The comments in front of the jury, yes, but sidebars are a normal part of it. And argument on objections regularly goes to sidebar, but that is, if it gets to appeal, there are bigger issues than the sidebars. But if the court is seeing that the jury is done, that itself might be an issue. So Angela said Jackson should ask ARCCA what they would do with a $400,000 budget. I don't know. They might rebuild their own Rescue Randy. So, Darkborn, there has definitely been a lot of the conflating of the issues with Brennan. And again, it's not clear. What I want to see from prosecutors is a clear explanation of things. Explain to me how this happened. And in a lot of the cases we've watched together, we've seen that. It's like most recently, the Sarah Boone trial. The closing was pretty clear. The case was pretty clear. The questions were pretty clear. You knew where they were going. The only time I didn't really know where the prosecution was going in the Boone case was when we got into the rebuttal case. And I was like, holy fucking shit, look at all these crazy videos. Damn. That's a lot. It's a lot. Carol Ann in the chat asked, Emily, do the jurors get to bring their notebooks into deliberations? Yes, but they generally don't get to keep them after that. They will be destroyed at the courthouse. Let's see. Laposata's green laser pointer said, maybe I missed this, but at the end of today, it seemed like maybe Welcher wasn't going to rebut. I wonder if the x-rays have anything to do with it. At the end of today, my takeaway was, when does Welcher need to be here? That was my takeaway from that. Let's see. Giselle Duke said, say a jury says guilty, but then majority changes their mind once the case is over and it gets info that wasn't given to them during trial. Can they change it to not guilty? No. The verdict rendered in court is the verdict that stands. Even if that came up on appeal, it would not overturn a case because the jury would have been then influenced by outside forces. The jury has to render a verdict based on what they are presented in the courtroom. They do not reopen verdicts lightly. We've seen that in this case. In all the appeals we went through in this case, courts do not reopen verdicts lightly. Soon we're going to have to circle back to talk about the Murdaugh case, but we're not there yet. But we will. We will circle back and talk more about Murdaugh later. Jeannie said, why didn't the defense bring in the x-ray to impeach before? I don't know. Maybe because they were waiting to do it with these witnesses. Is it possible the defense only received the x-rays a few weeks ago? I think we would have heard about it. But anything is possible in this case. I don't know, but I feel like we would have heard about it. But who knows? I am open to possibilities because we didn't hear about them in the last trial. They didn't really come up, and the defense couldn't have given them to ARCCA last case to evaluate. So they become more relevant now, but Welcher talked about it quite a lot and was like, I can't believe they didn't take x-rays. And then the questioning was about literally resecting and looking at the bones. Wild, wild, wild. So it's a lot. It's a lot. It is a lot. Shenanigan said the pages were blacked out because he was changing the PowerPoint as he was sitting on the stand. The one that was printed out and given to the court was given to the court earlier in the day, so it shouldn't have been. But you know what the defense is going to do tonight? They're going to roll the tape. They're going to go back and watch through. Well, they've got a million law clerks. They're going to have a law clerk go back and watch through that testimony and see if it was shown on the screen the best that they can, because most of those screens were shown in court. So they definitely did that. Monty asked, why can they rip this ME's past but not Jessica Hyde's? They asked Jessica Hyde about that prior case. And and did ask Jessica Hyde about that case to the best of my memory. So not all of it, but they did. And I think that the witness answered well about the things she was asked about. It was funny when she's like, that was all bullshit. That was kind of funny. So I wasn't mad about that. Let's see. F. Marsh said, EDB, how is it a fair trial when they argue what comes in and what is asked? That is all trials everywhere. They argue over what comes in and what is asked. Not to this degree, but the rules of evidence do require the motions happen beforehand. There are things that are proper evidence. There are things that are not proper evidence. Every trial. The delineating, like you can say this sentence, not that sentence, is a lot and incredibly frustrating, but the court has discretion and the court can control their courtroom. I don't prefer that style by any means. So that is a lot. That is quite a lot. Kimberly said, I really like when I type something, Emily then says. It happens often, and it happens in court too when I say something and then they do. It's just, we're thinking about the same thing at the same time. So only Brennan can make the ME say gross when talking about the brain. That was funny too. There were some funnier moments in court today, given how frustrating everything was, because it was frustrating for sure. Law Nerds, I know there are many questions I did not get to today, and I apologize for that, but it has been a very long day. It has been a very long 2 days. I know you're exhausted. I am exhausted. If I missed any birthday wishes, happy birthday. I will see you guys in court tomorrow. I'm going to set it back for 8:15. Court didn't even start till like 8:20 today, and then I was trying to give some Zoom room. So even when I was like, no, we're going to be early, I was like, okay, guess not. But we will have a new case brief out for you in the morning. If you are up and waiting for court, we'll see where we get tomorrow. It sounds like it's going to be a full day. I'm not optimistic it's going to be like a full day tomorrow. I don't think that's where we're going to get, but it has definitely been a long 2 days in court, and we are almost at the end. It is the end of this trial. Sam said today gave me a headache. Sames. But I'm really interested to see what Dr. Rentschler did in this case. I'm looking forward to hearing that testimony. I like hearing the scientific testimony. I like seeing the experts. I'm really interested in the next witnesses we have coming up. And then I want to hear that charging conference. I am ready. I'm ready for closings. I'm ready. Let me know where you guys are at the end of day 30. Are you ready for this to get to closings? Are you interested to see what they're going to argue? Is the defense going to focus on the prosecution didn't show you this and this and this and this and this and this and this? Is that going to be the thrust of the closing? And then what is Brennan going to argue? Karen Reed said this and this and this and this and this. We'll see. I'm interested. It sounds like this jury is ready for the case. Hopefully they won't be deliberating. What was it last time? 5 days? Leave it in the comments. Was it 5 days they deliberated last time? 6 days? It was so many days of deliberation. But if you're ready for jury watch, verdict watch, juror watch, verdict, juror watch plus verdict watch, verdict watch? No. Verdict watch. Make sure you get the Law Nerd app, because when we go live, we will let you know. As we get into days that are less predictable and timing that's less predictable, we will be keeping an eye on it so you can live your life. You just need to make sure that your notifications on the app are turned on. The Law Nerd app is free. Go ahead and download it. I will see you guys in the morning, Law Nerds. Thank you for being here. Thank you for being a Law Nerd. Thank you for making this the #1 place to watch live trials, because it is day in and day out. Law Nerds, you're the best. I'll see you tomorrow. Thanks for joining me on this stream. If you don't want to miss a moment in court, you need the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android where I can keep you in the loop with everything happening in court, and of course, when the jury has a verdict. So if you don't want to miss a moment of this trial coverage, make sure you get the Law Nerd app. Thank you for being here, and thank you for being a Law Nerd.